Good morning, everyone, and welcome. For those of you I haven't met, I'm Wendy Perdue. I'm the dean here, and it's my great pleasure to welcome you to the JOLT, Journal of Law and Technology Annual Symposium. I want to extend a special welcome to our alums who are back on campus. It's great to have you back. We're enormously proud of our journal, the first ever fully online journal, beat out Harvard by 3 weeks. Not that anybody's keeping track, but just note that for the record. They do very important work exploring the intersection of law and technology. It's a growing area, it's an important area, and the journal publishes scholarship that has a real impact on the profession. We're very proud of the work they do. We're also proud of the program today that they've put together. As social interactions within the digital sphere continue to evolve, so do the legal issues surrounding it. We have an exceptional group of speakers whom we're delighted to welcome, who will explore questions of ethics, cybersecurity threats, best practices surrounding electronically stored information, and other issues. So I know you'll enjoy this in-depth look at these timely issues. Some of you may be tweeting as we speak. That will be interesting to see what comes out of that. And now it's my pleasure to welcome Eli Hill, JOLT's annual symposium co-editor. Eli.
Thank you, Dean Perdue. Welcome to everyone. We're really excited and grateful for you to be here. First off, if you were a member of JOLT, do you mind raising your hand, if you yourself? Can we give those individuals a round of applause? Thank you for continuing the legacy. One thing that we say on the Journal of Law and Technology here at Richmond is you don't have to know anything about technology to be a member, much less run a symposium on it. We're very excited to have a great panel of speakers today to speak on a variety of issues. As you all are aware, social ESI, socially electronically stored information, is everywhere. It doesn't just involve tweeting. It's not just about Facebook messaging. In fact, if you think back to this morning, you probably have already left a record, a footprint of electronic information in your wake. And so today, it's not about enticing any fear of technology. It's embracing it and learning how we can best move forward. So with that in mind, I want to say a couple quick thank yous. Thank you to my co-symposium editor, James Williams, who will be up here later, to Nicole Alaban, our editor-in-chief, to Catherine, who is our assistant symposium editor. This is the 25th volume that JOLT has produced, and we have been partnering with more and more community groups as we move forward. Big thank you to Dean Skalbeck. He's up in the balcony there. He has helped us form a partnership with the UK company Justice. They're similar to Lexis, Westlaw, and we will be publishing an entry from an international submission in our symposium issue coming up. To keep in line with the idea of social ESI, we wanted to let you know that your CLE forms will be emailed to you. We're just really trying to go paperless here. So those will be emailed to you according to the information you gave in registration. So thank you for your patience with that. Also, wanted to recognize Kara Powell, who is a 2L on the journal. She recently submitted a comment and will be published. Can we give her a round of applause? She's in the back there. She's being a little bit shy, but really grateful to have the next round of JOLT starting strong already. So with that, I'm happy to introduce our first two speakers, Ms. Laura Lee Miller and Mr. Jeffrey Geiger. Laura Lee Miller, prior to joining Harmon, Clater, Corrigan, and Wellman, she practiced in a DC law firm for several years, representing insurers in coverage issues and disputes arising under various types of general liability and insurance policies. She focuses her current practice on medical malpractice defense, insurance coverage, and general civil litigation. And Mr. Jeffrey Geiger serves as the firm counsel on the board of directors with, for Sands Anderson, and he has also, over a decade, been practicing in the area of ethics discipline, eminent domain and litigation, business litigation, intellectual property. They will be presenting a panel on ethics related to social media. So please give them a round of applause as we bring them up.
Well, I'm not used to sitting down. Typically, I'm kind of roaming around. So if I start getting up for whatever reason, I'll try to project as well as I can. I think both Laura Lee and myself really do want to encourage a dialogue, because I think it's a lot more interesting to hear some of the questions you may have or some of the comments you may have. So I encourage you to discuss some of that. I thought I'd start the presentation by saying, may it please the court. And the reason why I do that, in part, not because we're here in a moot courtroom, but because when we talk about technology and ethics, lawyers have a very long history of, anecdotally, some people will try to say we're behind the times, but we're very deliberate, and we're very appreciative of the professionalism and the traditions that make up the legal profession. And so when we talk about things like may it please the court, some of an archaic expression, it really goes back to the idea that we do have respect for our traditions. That said, we're now in an age in which social media is rapidly forcing lawyers to contend with issues they really did not have to contend with. It wasn't too long ago, even so much as maybe a decade ago, we were still talking about opinions dealing with fax machines. Fax machines. And when was the last time you all actually used a fax machine? But within that sort of anachronistic sense of looking at the legal ethics opinions dealing with those kind of technologies, there really is a course of intentionality in which, whether it's purposeful or not, and I say that it's somewhat ironic, intentionality, as if it's not purposeful, but in some ways, our profession is so deliberative and cautious, and we want to make sure that we're getting the right result. It takes a long time to get to the point where we're able to make that grand leap to discussing from fax machines to email. So what I'm hoping that we do today is to talk about some of the ethical issues surrounding social media. I'm not going to pretend that it's going to be a very deep dive into the intricacies of the technology. I'll leave that perhaps to Laura Lee and some of the other presenters. But to look at some of the issues, see where we are right now, and see where we're heading. I mean, it really is an exciting time to be a lawyer because of all the challenges and the changes. But it's also a time in which we really have got to revisit some of our ethical requirements and how we handle those things. And even if we're going to apply the traditional ethical rules, how do we apply them to the new technologies? So I don't know if you want to...
Sure. So good morning, everyone. Jeffrey is not used to sitting down, neither am I, but I'm a little bit limited in my movement these days. I apologize. Breakfast is the most important meal of the day. That's why I started today eating a full watermelon. That's, how things go. But I wanted to sort of kick off the discussion by talking about sort of some common ethical pitfalls that happen when we're dealing with social media. And, when we were speaking about what we were going to talk about today, it occurred to us that Virginia does not have very firm guidance for attorneys on how to navigate this world of social media in your practice. And other jurisdictions have sort of taken a closer look at this, and it often comes out of large cities' bar associations that we're getting these sort of first guidances, standards, and disciplinary actions that are arising out of social media that might be influential in your Virginia practice or in your practice elsewhere. So Virginia's Rule 4.2 says that in representing a client, a lawyer shall not communicate about the subject of representation with a person that the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized by law to do so. Used to be this was simple enough. You didn't pick up the phone and call an adverse party or witness that you knew was represented by counsel. Now, however, one of the first things that we do when we get in a file is we get on Facebook and we Facebook the other party. It's easy to do that, and it gives you good information a lot of the time. It's shocking to me when we get in say a slip and fall case. We Google the plaintiff. We'll find Facebook posts, we'll find Instagram posts where they've taken a vacation within a week after their slip and fall that's allegedly laid them up for the last year. There's good information to be had there, but there are ethical considerations that need to go along with this. So the Philadelphia Bar Association in March 2009 issued an ethics opinion, it's opinion 2009-2, held that it was an ethical violation to friend a party or witness without disclosing your status as counsel for a party, regardless of whether or not the party or witness would usually accept a friend request without that disclosure. So even if you're dealing with someone who's a big Instagram influencer, has thousands and thousands of followers, Philadelphia is saying you cannot make that connection with that individual unless you make a disclosure about your status representing a party in a litigation. That's an interesting way to go about this, because I don't know about you, but I've found that the legal community is a small one. I've found that I run into people in different avenues, in different places, that I would have had no idea if they were on the other side of a litigation, if they were opposing counsel, until I get the pleading in. I might already be friends with them. So this is something that I think that we're going to see courts and ethics associations starting to sort of grapple with. How do we manage this sort of small community that we're in? Yes?
So how do they handle if you're already following someone or friends with someone else?
This ethics opinion did not give firm guidance on that point. But what I would suggest, based on my research into this from what other jurisdictions are doing, I think that it's wise to make that association known to the other party, to raise it at least, not try to hide from it, and not try to sort of pretend like it's not existing. If you happen to be friends with someone or connected to someone through social media that ends up being a witness in litigation, honestly, I think that the best course, what I would personally do, is undo that connection. I would remove it, because I don't want for that to be an issue in the litigation that comes up where someone's raising the fact that I've got this connection that might be considered some kind of ex parte communication with a witness or an adverse party.
Can I jump off that?
Sure.
Because I have a real difficult time wrapping my mind around the idea that I should be precluded from looking at social media. I mean, I think the Supreme Court has made it abundantly clear, most recently in the Packingham decision dealing with sex offenders, and the idea that the public sphere is such that social media is the new public square. And while we have that difficult time in which, for example, in a private mall, you can't go on there and picket and protest in a private property, how do you then handle that in a social media context in which Facebook, LinkedIn, all these other platforms are available to you? Sort of the piggyback, the Philadelphia opinion was also adopted in New York, but New York had a nuance to that later on in which they discussed the idea that if you do say and use your real name, hi, I'm Jeff Geiger, I want to friend you, that would be considered acceptable. The idea is that the concern that the bars have is whether or not it's deceptive or not. But again, I have sort of a problem that if somebody has 1,000 friends, and I think the friends misnomer really made it difficult for bars, because I think the bar looked at it and said, friend, there must be some kind of an association that would not otherwise be present versus a follower, which is, a little bit distinguished from a friend aspect. I would be very concerned about not being able to, for example, look at a Facebook page. And I think what Laura Lee said is, it is concerning that, do you take yourself off if in fact you realize that, say there's a member in your firm, and it's a paralegal that went to high school with the opposing party, and they are friends. Does that some manner restrict your ability to take a look at the Facebook page? Should you then be precluded from looking at something just because the friend of a friend of a friend with 1,000 friends, but it's a so-called private closed site, would restrict your ability to look at that information? I lean against that. I will say what Laura Lee said, though. The bar regulators in Virginia, while there's no official opinion, have made it abundantly clear that the Philadelphia opinion is what they would follow from an ethical standpoint, that it's appropriate that you avoid any concern about deception and that you avoid any kind of an issue in which you are representing yourself to be something that you're not and able to obtain access to somebody's social media. I just have a problem if somebody says, I friend anybody during a deposition, and then you send them a deposition or a friend request and say, JHG123, and they say, yay, you're my new friend. Why can't I do that? And that deception issue is something that we're going to see continually dealing with social media issues.
Yeah, and San Diego is another locality that has addressed this and the concept of deception as well. And that's an opinion. It's their opinion 2011-2 from May of 2011, excuse me, where they're discussing whether or not you can create a fake account to add someone. And they held that that was an instance of improper deception. So I think that there are places where you can see that it's clearer than others what you can and cannot do. I don't think that it would be anyone's inclination in this room, at least, to create a fake account called, Sue Smith and go out and friend every credible witness or every important witness in a litigation. That seems to be an obvious sort of bright line of, okay, I know I shouldn't do that, but when it's someone that's in your natural sort of circle of friends or one of your colleagues' natural circles of friends, it gets a little bit trickier. Yes?
So how do they reconcile the access you have as friend with the access you have just by going out and looking? So you have access to certain people's pages even if you're not a friend, and the information isn't posted, especially if they make it public.
Public information has generally been considered to be fair game, in the same way that anything that was part of the public record that was published in a newspaper or anything that the individual posted in a blog online that's public, that's generally been considered fair game. And when I say that we get on Facebook when we get in a new matter and we start to Facebook everyone, that's what we're looking for, is what's posted that's public. And some people are just better than others about locking down in privacy settings what's available. So I think that, in my experience at least, what's public is fair game. It's when you're trying to get behind that to the private information that it gets trickier. And the way that Facebook deals with subpoenas is essentially to tell you to pound sand. So the way that people are trying to get through is by doing things like creating fake accounts or by using these sort of naturally rising circles of friends. So another issue that has come up is under Rule 3.4a. This rule says that a lawyer shall not obstruct another party's access to evidence, alter, destroy, or conceal a document, or other material having potential evidentiary value for the purpose of obstructing a party's access to evidence. This one seems fairly obvious how this is going to come up in social media, and there's a good circuit court opinion, Lester v. Alliance Concrete Company, that was from 2011, that sanctioned a plaintiff and his attorney for knowingly deleting potentially incriminating photographs from Facebook. So this is something where when you have a client that comes in and says, I tripped and fell in a Walmart. I went on vacation a week later, but gosh, it sure has impacted my life really, really terribly. As plaintiff's attorney there, it would be ethically problematic for you to then say, get on your social media, delete all that right away. Let's get rid of that. Courts are looking at that in an analogous manner to putting paper documents in a shredder in the days of old. So that's sort of an area where we're seeing a little bit more of a bright line. Do not pass go, do not do that behavior. But it gets more questionable, I think, when we say to clients, and this is sort of standard practice, especially in areas like family law, lock down your social media. Is that preventing access to evidence? That's an open question in some jurisdictions still. And I think in Virginia right now, that's perfectly fair game to say, make your privacy settings as tough as possible. We're not destroying the information, it's still technically there, but lock it down, make it inaccessible. Whether we see jurisdictions start to shift away from that and say, no, that's equivalent to destroying evidence because you're destroying the access to it, I think that that's something that could be an issue coming up in the future.
And if I could just piggyback, because the Allied case is one that was really troubling in the sense that this was dealing with, it was Allied Concrete Company versus Lester, and this was dealing with a real tragic, back there.
My question was this, while they're posted on social media, the originals are usually stored on a computer or perhaps even in hard copy. So, I know the analogy is to shredding paper, but you're shredding usually the paper copy. When you have something like digital media, where the original before it was posted anywhere else remains where it always was, are you really actually destroying anything, or is that just purely access?
The question is whether or not, if you take down, I believe your question is, if you take down social media content, that the original is still in existence, and so therefore there isn't necessarily a problem. You're not, for example, preventing opposing counsel from accessing the information with a proper discovery request. Is that what you're...
That's
Yeah, so I think that that's true in the case of photographs in particular. Absolutely, you could still send a request for any photographs in the usual course of discovery, and that would certainly be captured by that, even if it happened to end up on a private social media page. I think that the concern is also geared, however, toward just general text posts. So sometimes what we'll run into, and I've seen it happen where a person will post a public Facebook status message that addresses, heading out to New York, and it's got like the little plane symbol and everything, and they show their flight information so that they're traveling, and that might be indication to you that they're going on a vacation when they say that they're, in absolute agony and in misery. That's something that if they're going to remove your access to that, sure, you can ask them the question in the deposition, have you been on any vacations in the last year? That's fair game. But if you're all of a sudden going to find out, if that post were public and they lie to you in your deposition, you've got your impeachment evidence, right? But if that post is hidden and it's behind a privacy wall, you don't have access to that information anymore. So it's a question of where do you draw the line between wanting to have broad discovery that's available to all the parties versus an individual is able to make changes to their social media page. There's certainly no reason that we would think that we would impose rules and restrictions on what individuals can do with their own private social media pages. There's no expectation of privacy in a social media post. The Supreme Court has made that reasonably clear. But what do we do in the specific instances where they're locking down their social media after they know that litigation is going to be happening? I think that that's where the sort of gray area is.
So if I can just go back to that Allied decision which Laura Lee mentioned, I mean, this is a case really goes to how do you handle evidence. This particular case dealt with a terrible trucking accident. I think it was on I-81, and the wife was killed, and there was this real concern over some of the Facebook pages and postings, and the attorney had a lot of back and forth both with him, between the attorney and the paralegal and the client. And there was this picture on Facebook where he's holding a beer, and it's got the shirt says, "I heart hot moms." And for whatever reason, the attorney just really felt like that was going to be damning if there was a big old blow up of that at trial. Now, I'm going to get to this in a second about is that really, from a practical standpoint, what you should be focused on. But the attorney made it very clear you need to take this stuff down and get rid of it on multiple occasions. And the thing that's kind of silly about this is it's still accessible. And there was a giant series of motions dealing with, we need this evidence, we want to get this information, and they ultimately got the information that was destroyed, so to speak, or spoliated, if you will, and they were able to use it at trial. But they still lost. They still had a verdict against them of $10 million. So this back and forth, one attorney telling his client, destroy evidence, and the other attorney thinking that in basically a case in which a woman was killed in a trucking accident, that this would be somehow dispositive, this photograph. Both sides were really unaligned with the reality of the situation. But ultimately what happened is the client that took down the information still got a big fat judgment, but he also got a judgment against him for sanctions, as did the lawyer, and this lawyer, who's a very, very good trial attorney, is no longer practicing law in Virginia. So, I mean, this idea under Rule 3.4 of being fair to opposing counsel, I mean, did anybody think that passed the sniff test to tell your client to take it down and get rid of it? Anybody. Again, those outliers help define some of where we are, ethically speaking, and those are pretty easy decisions, but the gray areas do get more difficult. You know, for example, do you tell your client to stop posting on social media, Laura Lee?
You can. It's certainly fair game. It's just whether or not, I mean, the concern I think that ethical commentators have is that some jurisdiction might someday take a more extreme stance on that and might say that that is somehow preventing access to discoverable information.
There's a question, yes.
Do you think the jurisdiction might become extreme enough to require one party to can't, if you don't have a Facebook membership, you can't actually access Facebook? I mean, it interests me that, potentially, in order to cut that off, someone could go so far as to say that one party needs to terminate the Facebook membership, essentially.
I don't think that that's something that would pass muster under the rules as I read them, at least under the model rules as they're applied nationally. I think it's going to stay a pretty consistent standard that whatever's public on Facebook, to the extent that you can Google Laura Lee Miller and find my Facebook page, to the extent that any information on there is public, that will still be fair game, I think, is sort of a good starting point, or at least a good floor for these conversations. And from there, it's a question of, if I know that I'm about to sue someone, if I know that I'm about to sue a doctor, do I then have a right to lock down my privacy settings so that no one can see anything I've posted since the date of my procedure? Do I have a right to remove photographs that I've taken and posted on social media since the date of the procedure? I think that those are the questions where it becomes a little bit more gray area. One last thing that I think is one of the more interesting areas that you can have a pitfall, because we all hear all the time, police your content that you post on social media. Don't put anything on social media that you don't want on the front page of the New York Times. We get that rule. But what about this? Rule 1.1 of the Rules of Professional Conduct. A lawyer shall provide competent representation of a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. Simple enough. We go to law school. We learn our practice areas. We work under the guidance of partners when we're new. Seems like we're doing all we need to do. But the New Hampshire Bar Association issued an opinion in 2012. This is opinion 2012-13/05. Lawyers have a general duty to be aware of social media as a source of potentially useful information in litigation, to be competent to obtain that information directly or through an agent, or to know how to make effective use of that information in litigation. So not only do we have to go to law school and do all of that, but we can't, at least in New Hampshire, bury our heads in the sand and say that social media, it's overwhelming, it's newfangled, there's ethical gray areas here. I'm not even going to touch it. I'm just going to get my information the old-fashioned way. I'm just going to send my request for production and my interrogatories and call it a day. That might not be good enough in the future. It might be the case that jurisdictions start to adopt this rationale that part of competent representation is using every means available to you. And in Virginia, looking back to 1994, McNamara v. U.S., this is not a case that addresses social media, obviously, in 1994. But the holding there is that the counsel relied on research tools that were out of date, and that constituted ineffective representation of counsel in a criminal action. At what point might a court revisit that kind of a holding in the context of using social media to conduct an investigation of a client or a witness or an adverse party? That's an open question at this point. So I would just point out to you that in addition to policing the content of your own social media posts, your client's social media posts, you can't just ignore it from that point on. It can't be the end of the conversation on the first day of retention to say, and by the way, don't post anything interesting or, incriminating or anything like that on social media and click. You might have to actually make use of these tools as part of your duty of zealous advocacy.
Well, and I think it's, yes, sir.
I guess there's the question of when you file a case, do you notify the adverse party, don't do anything to erase anything on your social media?
I think that's a very solid idea. I think that to the extent that you would typically send out your litigation hold letters that say to preserve all documentary evidence, if you're not including ESI, electronically stored information, in those letters, and if it's a case where social media is likely to come into play, which if it deals with individual human beings, social media is likely to come into play at this point, put that in there. I mean, it's only going to help you. There's no downside to doing it.
And I will say that it is a degree of magnitude about how you handle that. Say, for example, you file a case in General District Court, which is a case in which the jurisdictional threshold is less than $25,000 in most circumstances. Do you really send that cease and desist letter, or the spoliation letter to the other side? Because guess what I would do then? I'm going to send it back to you, and make you do everything that you're telling me I have to do. So have you then, the law of unintended consequences, are you ratcheting up the litigation cost and everything else by demanding such a high standard? I love nothing better than when I get some 7-page letter detailing all the requirements that I must maintain for ESI, basically having to spend, $50,000, $60,000 in document retention services. Really? Does every case mandate that or need that? I think that it makes it very difficult to have this one-size-fits-all approach that a lot of people seem to try to employ. I don't think it's ethically required. I don't think it's standard of care requires it. But let me just kind of piggyback on what Laura Lee was saying too. Rule 1.1 in Virginia was amended. Wait for it. This is some real heady stuff, okay? It was amended to say, comment 6, attention should be paid to the benefits and risks associated with relevant technology. Wow, we've come a long way. And that's that deliberation I was talking about. The idea that you have to look to these ethical rules and try to apply them. I don't think you ever needed to have a comment say that. I think by saying that, well, attention should be paid to making sure you're abreast of case law. Duh, we know that. Technology is obviously there. But part of what they said in the comments, and they talked about the McNamara decision that Laura Lee said, the comments that they presented to the Supreme Court saying, please adopt this new comment to Rule 1.1 dealing with competence. And it basically said, the rule changes do not necessarily require that a lawyer become tech savvy or acquire training, skill, or experience with information technology. At the same time, lawyers cannot ignore the fact that technology has and will continue to change the practice of law. A lawyer may discharge his or her duty of competence by employing or associating others who have developed the requisite skill and expertise, millennials. However, a lawyer may not simply ignore relevant technologies that have become widely accepted by the bar and have become reasonably necessary to represent clients competently and diligently. I don't really see, I think a question could be posed, can a lawyer practice law ethically without an understanding of basic precepts of social media? Can a lawyer do so? I think probably not. I don't see how you can not be able to understand and use basic social media precepts in your practice. You may have a very limited practice, but you tell me which one. Criminal defense, you absolutely have to know about what's going on. You're going to check out witnesses, your own client. Domestic relations, really? I mean, that by itself. So you tell me an area of practice, and maybe it's offshore drilling rights off of Kazakhstan doesn't have any offshore, I get that. But something like that, maybe you don't need to have a real understanding of social media, but it's pretty darn hard to find an area that you don't need to have that basic understanding. So again, I do applaud the bar for embracing and understanding the need for it. I don't think it's necessarily required that they put it down on paper. And well, I can go off on some other tangents, but maybe I'll wait and see where this goes about the requirements that we have to employ.
All right, so do we want to jump into the...
Yeah, so we kind of jumped ahead, and this is, once again, sort of a duh moment about some of the things that we've seen. And the Supreme Court, I think, is just really interesting because the Supreme Court seems to be ahead of where a lot of lawyers are. They very much recognize the extreme importance of social media in our daily lives. And so they provided some quotes in here. 90% of cell phone users keep on their person a digital record, blah, blah, blah. 12% use their cell phones in their showers. Come on. I'm looking around, you're nodding your head no, but I know you are. And then this quote, and I didn't attribute it, I'm not sure where I got this, but 5 years of your life on social media. I've got 2 daughters, one in college and one in high school, and I guarantee that 5 years is way below the average. But that just speaks to the importance of it. I mean, the idea that we have now given the cell phone, the mobile phone protection that you would normally ascribe a diary locked up in an attic is pretty incredible. But it does speak to the fact that we have to be very careful with our privacy. As much as we are so public, we recognize our privacy. And I think that's what the ethics rules are trying to understand and grapple with. So, this online reputation is always interesting to me because it does impact lawyers. A lot of times lawyers don't, what's that AVO thing? LinkedIn? Well, I don't even understand what that is. But the online reputation is so important, and this quote to me, and this came out before the whole fake news debacle The idea that you really do believe what's online. And how does that matter to lawyers? Because you guys are online. So I like to do, one of my projects I like to do is to collect sort of cautionary tales. These are important because these are the extremes, the hyperbole of ethics, and it helps to guide us and understand where the issues are without implicating our own selves, right? But again, that gray area, we can get closer and closer. So let's start off with one of them. This is dealing with an attorney in California. I say an attorney, she's not practicing, and that's sort of a sneak preview. She graduated from Pepperdine, I think it was the early 2000s, and here's what she decided to do. She did a great job. It's kind of hard to see, but she has on there, and this was before even Donald Trump was thinking about running, Donald Trump, George Clooney, Barack Obama, Biden, and she had all this all over her website, basically implying an association so that clients would go and visit her and they would see her social media and her blog posts, etc., and they'd say, wow, this person is connected. So if she's connected to all these important people, by that, not even 6 degrees of separation, 1 degree of separation, I have somebody that is really well connected. For example, you can't have the Barack Obama law firm, right? Reason why? He's not practicing law with you and he isn't licensed to practice in Virginia. So this woman is trying to create association. If you look at that, that's really impressive. Her Photoshop abilities are really, really good. But here's sort of the detail. Obviously, you can't do this, right? That's deception. So a client sees this and they think, wait a second, I think that you are in some manner connected with Barack Obama. Is that appropriate? No, it's not. It's deceptive. But here's why this is important, because not only is she deceptive with her clients and potential clients, it just speaks that oftentimes these disciplinary actions arise where the notion of where there's smoke, there's fire. Bar regulators will often tell you, you may see this person having missed one statute of limitations, big deal, maybe, maybe not. To the client, definitely. But the bar regulators will say there are lots of other issues. And unfortunately for Ms. Sangare, and I'm probably butchering her name, she had other issues, like such simple things as not returning files to her clients, terrible Yelp reviews. For somebody so wedded to social media, she did not do a good job of her online reputation management. She didn't cooperate with the bar. And in fact, when they did the investigation of her, she provided the basis for not testifying, I'm losing the word, implicating, was the First Amendment. And the judge said, no, ma'am, it's the Fifth Amendment, and that's not applicable here. And she kept on saying, it's the First Amendment. I have freedom of speech, and I refuse to testify based upon my speech rights. Again, as the precursor, she's no longer practicing. They did have a suspension of her license and a probationary period. She may be practicing now, I'm not sure, but this kind of stuff is just low-hanging fruit. It's easy, and that could have very easily been avoided. I'm going to jump to the next one, Laura Lee, unless you want to talk about. Okay, don't deceive.
Do that. Yeah.
Yeah, this is the Yelp review again, just basically lambasting her and just saying that she's a crook and steals and takes her money. Okay, Craigslist. There is a section, it used to be a section on Craigslist called the Adult Gigs section. It is your XXX section, as you can probably well recognize. Adult gigs, not for kiddies, and obviously a lot of issues, and law enforcement tried to shut it down, and there were lots of issues about Craigslist having this up there. All right, so here's the problem. Law firm in Illinois looking for a new assistant, and they decide that they're going to do this on Craigslist. This is another pet project of mine because what I think is really interesting is where the bar, the disciplinary regulators are looking to see whether or not your personal life, some manner, implicates your professional life. And it's not some kind of sordid or seedy investigation, but the idea is that you are supposed to be competent, diligent lawyers, right? Are you also supposed to be good in your personal lives? It's easy if, for example, if you get convicted of a felony, you need to report it to the bar. And the bar is going to take a look at it and see if it implicates your ability to practice law. But what about something like this where they're basically requesting that their assistant engage in acts that probably aren't appropriate from an employment law perspective or any other perspective? Well, Debbie with an I did respond to the ad, and she was then requested to provide her measurements in a photograph. Okay, you know, that red flags are going off. But she does provide them. And then what happens is the law firm basically, this is an immigration law firm too. Not that it really matters, it could be domestic relations, it doesn't really matter. But basically they're saying that you need to engage in flirtatious behavior, and goes on to say, in the past, people failed to appreciate the sexual aspects that are required of this job position. Okay, you tell me what ethical rule is implicated by this. Competence, diligence, conflicts. There really isn't an ethical rule that talks about the adult gig section of Craigslist. But what it does talk to is where a lawyer's behavior in some manner crosses the line, and it causes concerns as to their ability to practice law. And so when the investigators looked at this, and actually Debbie did file a complaint with the regulators in Illinois, and they looked at this, and this is what I was talking about earlier, you know, where there's smoke, there's fire. This by itself may not have been that big of a deal, maybe, from a bar perspective. But what happened is that by making this allegation that she said that this was inappropriate, there were a number of other allegations, and the attorneys that were involved with the Chowan law firm had failure to prosecute cases on behalf of their clients, taking money from their clients and not doing what they said they were going to do. So there were a number of other issues, but the bottom line is this is icing on the cake, and it ended up with a suspension. The guy, the lead lawyer in this case, is no longer practicing law. He was disbarred in Illinois. But again, does your personal life intrude upon the ethics? And your personal life, when you take a look at your social media, does that in some manner speak to what the highest principles of professionalism require? I'm not saying you can't have a picture of yourself holding a beer on a Friday night, but you've got to be careful, because what you do put out there does come back, and the bar will be taking a look at it to see if there are issues associated with that. It's kind of Orwellian in a sense, and I'm a little concerned that the bar is spending as much time or ability to spend that time, but there is a concern, and a very strong concern, about wellness issues. And so when they see people doing things on social media that may not be necessarily in keeping with a healthy practice, that may trigger at least concern. It should trigger concern, especially given where we are in the state of lawyer wellness, law student wellness, and the legal profession in general. So I think I'm kind of preaching on that, Laura Lee, so maybe I'll...
A little, but one way, though, I think that we're all, sort of generally aware of the concept that we shouldn't post, photos that are wildly inappropriate on our social media pages because of how that reflects on us as attorneys, how that can reflect on our firms, and how it can reflect on the bar as a whole. But one way that I think that it gets a little bit more interesting when thinking about what you post online and how that impacts your practice is that social media has sort of blurred the lines of practicing outside of your jurisdiction. And I'm thinking, I don't know if anyone here is familiar with the website Reddit, but Reddit is a content aggregator. It's a place where you can create a relatively anonymous account and you can post information that respond to various interests. There's different areas for your favorite television show, there's areas for different professions, and there's one subreddit that's where you go to talk about specific topics that I visit on a very regular basis because I find it highly entertaining. It's Reddit Legal Advice. This is where people will go on and they will post, they'll put their state in brackets, they're required to by the rules. They will put their problem that they're having. My landlord is saying that he won't fix my mold problem. And then they'll write out a summary of their details, and they're asking for legal advice. I'm not licensed in Pennsylvania. I can't comment on Pennsylvania's mold requirements and their landlord-tenant law, but I could go and post generally on this subreddit. So is that practicing outside of my jurisdiction? This is something that can happen. That's an obvious example of it, but it can happen on sites like Avo that allow question and answer sections. It can happen in your Facebook comments where someone in your family or a friend posts, gosh, I'm having so many issues with my landlord, and you say, hey, what's up, what's going on? And they give you a scenario and you respond to that. And the way that we need to look at that, and the way that bars have generally looked at it. DC has a good breakdown of this in one of their ethics opinions. Legal information versus legal advice. And legal advice, that is offering tailored recommendations to the unique facts of a particular person's circumstances. Responding to that post that says, what do I do about my mold problem in Pennsylvania as a Virginia attorney? If I point them to, here's what you need to do. You need to go into the lower court, you need to file this, you need to do, that is specific legal advice, and that's problematic. But if I post generally, your state might have some kind of guidance in their landlord-tenant law. Perhaps you should consult with a landlord-tenant attorney. That's probably more like legal information, which is something that involves discussion of legal principles, trends, considerations. So this is something where not only do we need to think about don't post flagrant photos, don't post wild party photos, but also even in your very tame discussion of the law, which we're all interested in, we're all here, you know, make sure that you're not crossing a line into some sort of unauthorized practice of law situation in another jurisdiction.
Well, with that unauthorized practice of law, so Laura Lee, say that on Reddit I put on a comment, and I ask a question, and I just say, I am having a lot of trouble dealing with this particular aspect of medical malpractice law, because I know that's something that you practice in. And specifically, I have this concern about a doctor, and I think that this doctor has not treated me according to the standard of care. What do you think?
Yeah, so I think that in that scenario where I've taken in information from someone, they've asked me for advice. One, I'm concerned about forming a potential attorney-client relationship. And I'm concerned about am I now obligated to maintain that information in confidence? What if I represent an affiliated entity? Am I now in a conflict situation? There are problems that come with just taking that information in, but sort of shoving those giant issues to the side. If I were to respond to that and provide information as to specific steps that they can take, as to specific causes of action that they could bring, specific things that they will have to prove in order to say that there was a violation of the standard of care, then that's giving legal advice, and you are in attorney-client relationship territory, in my opinion. You might, the ethics pro here will probably have better guidance on exactly that moment that that relationship crystallizes. But if I were to provide information, say, about local lawyers that handle that kind of work, that's legal information. Legal advice, no. If I were to provide them with access to general resources, I think that that's a different scenario. If I were to point them to the law.com article on medical malpractice information, I think that that's probably more like legal information than legal advice. I think that it's when you start to apply facts to law that it gets problematic.
And would that matter at all if they knew that it was Laura Lee Esquire versus just LL123?
I think that it does matter. I mean, in terms of the argument that I would make if I were in a disciplinary action, I think that if I were posting it through an anonymous source, maybe that makes a difference, but the gold standard is still always going to be to give your disclaimer that I'm an attorney, I am not your attorney, this is not intended to be legal advice, I'm not forming an attorney-client relationship, et cetera, et cetera.
Wait a second, I think there were a lot of people who fell asleep during that disclaimer.
Yeah, come back. We've got coffee outside. But, if you can give that kind of a disclaimer, it might help protect you a bit. But if you were ultimately giving that disclaimer and then laying out specific legal advice with, here's step 1, go to the court, get this form, step 2, I mean, the Bar Association is going to see through that. That's pretty transparent, so.
Yeah, the whole idea of forming the attorney-client relationship is one that is fraught with difficulties when you're dealing with social media. I think one of the things, and we can kind of segue into this idea, and I think we've got some folks talking about artificial intelligence, and I know you've spoken about that as well, Laura Lee, and this idea that you could have, for example, a site, okay, back up. Before you went to the library, book on how do you prepare your will, and you go there, you check out the book, you take the form, you fill out the form, or you copy it, and you draft your own will. Now we fast forward to the last 20 years, 15 years. Now you can go online, you provide really, really detailed information, and they come up with a pretty damn good will. Is there an attorney-client relationship then formed with that LegalZoom or some other kind of a legal services provider? That's something that bars have been fighting tooth and nail throughout the country, largely losing, but they have been fighting the issue, trying to say that you're providing legal advice inappropriately. But then you go to, for example, there's an Australian company called LawPath, and you can go to their site, and you provide very basic, intuitive information, and they'll come up with a privacy policy for free in about 30 seconds. How do you then handle those kind of issues with attorney-client relationships, conflicts? And I think Laura Lee said, putting that to the side, but that is so incredibly difficult. So let's just say somebody goes on to Reddit and Laura Lee posts a comment, and that person then ends up suing a client that ends up coming through Laura Lee's firm. You have no idea because they didn't share the information about the parties' names. But now the other side is saying, wait a second, you posted a comment on Reddit. You clearly were intending to have a relationship with my client. You may not have provided all the information that she needed because she had to hire me, obviously. But that in of itself could create a conflict. And you go back into the early days of semi-interactive websites. And there was a decision out of California, and the circumstance was basically along this line. You have a semi-interactive website. It invites you to go ahead and post information about something. So in this case, it's a personal injury action. And there's been a car accident. The driver of the car, the passenger of the car accident types in information. Passenger was injured in the car accident and says, you know what, I was injured. Can you help me? My name is John Doe. And that's all I'm going to say right now. And law firm contacts person says, okay, well, we'll get some more details because that's kind of what we do. We've got this, the little chat box that pops up. And then afterwards, they receive another message. Hi, I was a driver in an accident. I had a couple glasses of wine. I wasn't impaired, but I had an accident, and I'm hoping I can have some representation as well. They were both injured. Is there a conflict there? How do you handle that kind of a conflict situation where you basically provided information at the behest of a website's invitation to do so? And I think the state bar regulators, at least in Virginia, and I think pretty much universally would say, if you invite that information, you've got a problem. There has to be a way in which you indicate that you've got to check the conflict and that you are able to prevent people from basically submitting information to you and then acting upon that without there being some kind of a conflicts barrier. So in that situation, could you represent the driver and the passenger? If they're on the same side of the V, maybe, probably not. But if you didn't have that system, now you're in a position where you may not be able to represent either one. There's this great story about what happens, and I've seen it in TV shows as well, but this is a real example. Southwest Virginia, they don't have a lot of lawyers in some of those communities. And a person wants to get a divorce. So what do? They send an email to all the attorneys in the area with all the information possible about the divorce to hopefully conflict it out so that the wife can't get a lawyer nearby, has to spend a lot of money, has to go to Roanoke to get a lawyer, and that makes it really difficult. Well, the attorney-client relationship was not formed because there was no intention by sending that email to have that relationship formed. But it often is in the eyes of the client as to whether or not the relationship has been formed. So when I send a comment to Reddit, and then lawyer responds, has that a relationship been formed versus John Doe, who doesn't have a law license, respond? It really does require a real difficult analysis about the eye of the beholder type of situation. So when you talk about AI and chatbots, all those things interject as far as whether that relationship was formed, the conflicts issue, and frankly, supervision. If you think about that, if you've had a site and the site is basically preparing pro forma privacy policy, is there a supervisory element? 5.1 talks about lawyer supervision. 5.3 talks about assistant supervision. How do you handle that? I don't know if there's a good answer to that. I will say my bent, and maybe it isn't with the regulators right now, is I really hope that we can push the narrative toward more access to justice, because the great thing about social media is that you do have such greater degree to have that interaction and access. And if you curtail it and say that lawyers, we love our monopoly and we're going to prevent the LegalZooms of the world from operating even though they may not be the best, that can be problematic, I think, for the larger access issues. Rant number 3, I think it is. Sorry.
Keep going, you're on a roll. So one other way that I think that, we need to think about the attorney-client relationship aspect, and you can look back at, it's the Virginia Legal Ethics Opinion 1842 that deals with what you do on your website and how you're soliciting information from your website. If you're putting your email address on your website, fine. That's not soliciting that information. If you're putting a text box there that says, tell me all about your problem and who your problem's with, and that's where we run into the issues. But even more than that, I think that we need to be aware that when you have a situation where you're responding to requests for information online, even if you know that you're only providing legal information, you're not providing legal advice, you're towing this line very carefully, be aware that physical presence in another jurisdiction is not required to trigger these problems. You can't defend yourself by saying, well, I was responding to this Pennsylvania post about the mold in the apartment, but I've never even been to Pennsylvania. I'm not a Steelers fan. I don't go up to Pennsylvania. So if you try and use that as your defense, just this big caveat here, that's not going to be good enough. You need to be able to be aware that when we say social media is blurring the lines between jurisdictions, it doesn't require that you ever actually physically step into that jurisdiction. That's just the caveat that I would put on that.
Yeah, that jurisdictional issue is huge in the sense that what may be good in Virginia may not be good in another jurisdiction. And so you've got to be careful with your social media advertising, for example. There's been a collapsing of the rules in Virginia to make it pretty easy and clear to avoid deception. Well, other jurisdictions may have different requirements for that. There's this classic example, I say classic, it hasn't been that old, but Louisiana. They wanted to mandate that their lawyers include disclaimers in their tweets. And at the time, it was 140 characters. How do you put a disclaimer in 140 characters? We don't have that in Virginia per se, but you do need to be mindful of those kind of restrictions from an ethical standpoint, but obviously from a standard of care and a legal malpractice standpoint. If you're providing advice to somebody in another jurisdiction, you may have the UPL, MDGAL problems, and you may also have good old legal malpractice problems. Should I go to the next example? Yeah. Okay. All right. This may be more dear to the hearts of some in the audience than others. This was a situation in which a lawyer had the plum position of being a law clerk to a Supreme Court justice in Kansas. And here's what happened. And I'll give you a little bit background on this. So in the situation, the law clerk's judge was out of state. She was at a conference, and so the law clerk wasn't actually in attendance in the courtroom. The courtroom was handling a disciplinary matter dealing with an attorney. Kansas, surprisingly, has a number of really interesting disciplinary cases. People with dressing up in uniforms and doing all kinds of crazy things. In this circumstance, this attorney apparently had quite a reputation, and the law clerk, because she didn't have to be in the courtroom because her judge was out of town, was sitting in her office, and they had closed camera. They were able to watch the proceedings from the benefit of just sitting in their office. It wasn't live streamed. It was just a closed camera. And so what happened is she decided to get onto social media, microblog, about what was going on. So here she goes. So Phil Klein is the attorney, and Phil Klein is up on a disciplinary complaint with the Kansas Supreme Court, or Court of Appeals. And so here she is. She's tweeting about this. You can watch that naughty, naughty boy, Mr. Klein, live. And she provides a link to it. And then it's kind of hard to read, but she just goes through a litany of comments, basically a really fun narration of what's happening in the courtroom, but probably not terribly appropriate when you're a law clerk for a judge of that court. And she is going on and talking about, are you freaking kidding me? Where are the victims? All the people with the records who were stolen. And she talks and talks and talks. I mean, the commentary is just wonderful. But the problem is that she is a law clerk for a judge would you have a little bit of a concern if you knew that you were appearing before a judge and the law clerk for the judge was basically providing commentary about my case? I think you'd be a little concerned about that. Ultimately, unfortunately for her, she lost her job. The judge called her immediately and said, unfortunately, your services are no longer needed. She received a public admonishment, which is not a great way to start your legal career. The good news is that she did obtain employment with a pretty good firm in Kansas, but it just goes to show that filter, we often forget the idea that social media is social and it's very, very public. And again, I don't think she was intending to do anything wrong, and frankly, if it was John Doe out there tweeting the same thing, it wouldn't have been a problem, but obviously those lines, those blurry lines, come out to really make it very difficult for the law clerk in this circumstance.
And I think that brings up too, there's a lot of, at least in my experience, there's a lot of one-on-one conversations that happen between attorneys where we talk about judges. We talk about what happened in our cases. And that one-on-one conversation, I don't think anyone has an issue with me saying, gosh, I had a conference with Judge so-and-so, he really just read us the riot act. Has that ever happened to you? I mean, that sort of a conversation has been considered fine. It's when it goes public, for some reason, this changes the character of things. So there's a Florida attorney that back in 2009 was fined $1,200 by the Florida bar for posting a blog post where, among other things, and it was quite the rant, but called a judge an evil, unfair witch. Obviously problematic. Probably not something that, if you have a one-on-one conversation with someone and they're just really having a horrible day and they say, gosh, I cannot believe that evil witch of a judge did such and such in a one-on-one conversation by the water cooler, I don't think that it's anyone's inclination to go and report that to the bar. But when you take it and you put it public, it changes the nature of things. And there's so many good examples of this. I mean, you've got situations where the court or the bar association can catch you in a lie based on what you've posted publicly, that this couldn't have happened in, your typical one-on-one situation in the days before we were all leaving these digital footprints everywhere that we go. Back in 2009, again, 2009 was a great year apparently. Texas attorney requested a continuance in a case on the ground that she had a death in the family. I think she had said that her father had died. So the judge says, of course, I'm sorry for your loss. And the judge later gets notified that the attorney was on Facebook posting comments and photos showing that she was out having several days of heavy drinking and partying. So, that gets brought up as an ethical breach. So it's situations that in the past, this sort of your private sphere is your private sphere. Everybody can rant and rave in their one-on-one conversations, one-on-two conversations with their colleagues about crazy things that a court did because, sometimes we just feel that courts did things incorrectly. That's just how it goes. But when you take it and you put it into the public sphere like that, that's where it becomes extremely problematic.
And talk about the public sphere. I'm going to jump ahead to where I think is a real interesting area for lawyers and how they handle it. We've kind of moved around a lot of this, but the notion of lawyer advertising, and I've indicated, deception is sort of the watchword that we have now, and the concern over making sure that the advertising that you have is appropriate. Bates versus Arizona, 1974, Supreme Court reviews the idea that this particular ad, it's somewhat shocking, so I don't think there's a safe room around here, but here's what they had in 1976. This is an ad that they posted, which resulted in the Supreme Court of the United States getting involved. Specifically, there were a couple of upstart lawyers who had graduated from the University of Arizona that decided that they wanted to open a practice. And they were going to do the unheralded and inappropriate idea of publishing what their rates were going to be, so the citizenry could actually know what their services were going to cost. That's really unprofessional, right? So they put this ad in the paper, and ultimately there was going to be some sanctions against them, and ultimately there was going to be a sanction against them. There was a lot of back and forth in the bar about whether this was something that should be sanctionable or not, but ultimately there was a sanction. They appealed it to the Supreme Court. So, for example, your divorce was $175 plus $20 for court filing fee. That's considered objectionable. So the Supreme Court gets this, and they decide that, that's basically there is a desire. Again, ethics are designed to do what? Protect the public. Protect the public. And the Supreme Court looked at this, and along with the pharmacy case that came out of Virginia, and looked at it and said, "You're providing prices. This is good for the public. This provides information, comparison shopping for the public. This is something that's appropriate." And they said, "This is not an ad that would be appropriate for bar regulation." Then you fast forward to, and I don't have it here, but there's this wonderful, wonderful series of ads by the Texas Law Hawk. I encourage you to look it up. Texas Law Hawk is awesome. And basically, they started off with one of his ads back in the Super Bowl, several Super Bowls ago, and it was basically this lawyer, and it has this giant screeching law hawk, and it screams up there, and he's riding a motorcycle, and shady sheriff is trying to arrest somebody for drunk driving and using this little funny DUI machine, and the Texas Law Hawk just rides in there, provides some information, and says, "Get the Texas Law Hawk." That's a real far cry from our Yellow Page ads showing the prices that we're willing to charge for our legal services. Social media has obviously pushed the envelope even further with respect to lawyer advertising. But I also think it's had the consequence of looking at it and saying, wait a second, do we really need to have all these trappings to prevent people from providing information about their services? Again, protecting the public, providing consumer information. It isn't just simply you just call up and say, "I want you to represent me and send me a bill in the next month." So social media, where does Virginia stand on this? Virginia has looked at this and said, we used to have 7.1, 2, 3, 4, and 5. We're now down to just 7.1 and 7.3. 7.1 basically says, don't be deceptive. 7.3 says, when you solicit clients, if you don't have a relationship with those clients, you're required to indicate that it's advertising material. So that does have some implication with respect to social media sites and how do you solicit your clients. Obviously, a lot of people are looking at, for example, instant messaging ads, things of that nature. They find out that you are in some manner, they can take a look at, algorithms to determine what you're doing, and they can post ads on your social media sites that may be something that would be helpful to you, especially in the criminal context, the divorce context. As long as those ads are out there and they're providing the information that's clearly a solicitation with the understanding that it's an ad and it indicates it's advertising material, that's good to go. So I really do think that that's an important way that, at least in Virginia, again, that's why you have to be careful about which jurisdiction you're in, but in Virginia, they have pushed down the envelope as far as what exactly it is that's considered advertising material. Make it not deceptive. That even goes to such things as when you talk about expertise and specialization. As long as it's not deceptive and it's provable, then that's going to be appropriate. So, for example, is it appropriate for you to brag, "I have won every single case I've ever tried"? You've tried one case. Is that deceptive? Probably. It probably deserves some context. "I won $20 million for my client." Okay, what about the other 100 that you lost? The bar has basically said we're retreating back from this idea that you have to say every single time. Case results may vary depending upon the severity of the case and all the circumstances involved in it. There was this notion that we are going to treat every single person out there that's not a lawyer as a fifth grader. And I think the bar has looked at that and said, maybe we need to sort of push the bounds on that and not treat everybody as if we're going to deal with the lowest common denominator. The zero tolerance policy that you see a lot of times. The idea being that if it's not deceptive and it's provable, that you would be able to have those statements on your social media. As again, is it inflating your practice a little bit and you're not going to talk about all the ones that you lost? Yeah, okay, that's okay. As long as it's truthful in the context in which it's displayed.
I think we're coming up close to the end of our time, so do we have any questions that we want to field for the group?
I have a question. Has it ever come up regarding lawyers posted on their site prior to them being a lawyer? Has that ever been an issue?
As far as whether or not you can, unfortunately, a lot of times law students particularly have to be concerned about what they put out there. Fortunately, there's been a lot of discussion about, for example, wellness issues and health issues, such that is not such a license restrictor that it used to be in years past. Because obviously, what a terrible thing to tell law students is, don't seek help, because that might bite you in the ass. That's terrible. But your social media platforms can come into existence. There's not specifically they're going to look at it, except that if in fact there's a concern, and I don't know about Virginia, but I know in other states, if there's a concern, like for example, you had to report that you had a series of bankruptcy and all these other and criminal issues as well, they may want to do a more comprehensive investigation that may look at your social media. I think that's kind of obvious that you should be careful about that. Yes, sir.
Do you think we might see a trend in the future of the bar looking at social media history in terms of character and fitness for new members of the bar, given that so much of the life is online for people who are millennials?
I would be sort of surprised if they're not already doing it, but I haven't had experience with it directly. But I would imagine, based on, at least when I was in law school, I graduated in 2015, and when I was in law school, they told us, as we were going through the application process, to make sure that if we ran a Google search of our names, that we were happy with what came up. And if we weren't, that we should go ahead and address that now rather than later. And obviously, that's, an entirely different issue than spoliation of evidence, although it's sort of in the same general theme. Maybe you're spoliating the evidence for the character and fitness committee. But it's something that I think that law schools are aware of. They're working on making sure that any issues are addressed sooner rather than later. But there's also only so much you can do, right? I mean, once you put something online, it's there forever, is the rule. So at some point, I don't know whether law schools now in the admissions process are considering this. I would assume that they are. It's my general assumption that everyone is searching for everyone at any given moment. But if a law school is going to consider in their admissions process whether someone has just really questionable content on their social media pages, in order to sort of stave off the idea that that person, when they apply to the bar, if the bar takes a look at it, the bar might not admit them on character and fitness grounds. I think that gets into a very complicated area for law schools. I mean, if it's a 4.0 GPA from a great college and it's a solid application, but they happen to have a very wild nightlife, I mean, that's a huge problem for law schools to contend with.
I mean, it seems to me there's also an issue of whether for the First Amendment, the state bar is a state agency, and what if somebody's expressing views that are not illegal or popular?
Right. Yeah. If somebody takes a particular political stance that the committee is for, maybe in that year the committee is very homogenous in their political views, and the applicant is in the other side of the spectrum, and we consider political speech to be this core speech that's absolutely fundamental to our First Amendment rights, and good luck proving that that's the grounds, I suppose. But it's something that it's a fraught area, and in terms of I certainly wouldn't tell a friend of mine in law school to scrub their social media page of any political content, for instance. I think that that's something that if someone believes it passionately enough to be able to post about it on their social media page on a regular basis, that's who they are, that's part of it. But at the end of the day, they have to consider that what you post online does reflect on you as a potential attorney, as an attorney when you're practicing. I mean, I know that when I graduated from law school, I pretty sharply curtailed any sort of political posts, just because I don't really want people to know what my political leanings are necessarily. And it's not because I'm ashamed of them. It's just that, it's something that the private sphere, to the extent we can maintain any little tiny bit of private sphere anymore, it's a good thing. So it's complicated.
Well, think about this. What if you have a post and you're talking about how you're smoking marijuana in Colorado? From a character and fitness standpoint, it's legal in Colorado, even if the feds don't agree with that. Is it legal in Virginia? Absolutely not. Are there issues that may be from that? Because obviously under Rule 8.3, you have a duty basically to report attorney's misconduct. And the issue is whether or not an attorney whether there's a concern about the attorney's fitness to practice law or the truthfulness. That's generally the sort of the guidepost on that. Truthfulness, fitness to practice law. I mean, you could say the same thing about an attorney that drinks a six-pack on a Friday night. Is that the same thing as smoking pot in Colorado where it's legal? Maybe I'm getting into the weeds. Ha ha ha. But those character and fitness issues are real. I don't know how much they're really delving into the history of attorneys or soon-to-be attorneys' social media presence. Again, I really do believe that as much as we are becoming so much more public, and in fact, the people that are more guarded about their privacy are the 40s and 50-year-olds versus the millennials and the ones underneath them, because they feel like it is protected. There is a degree of privacy. I think Laura Lee indicated that there really isn't any privacy associated or reasonable expectation of privacy associated with social media postings. I don't know if that's the case. Legally, I think she's absolutely correct. I do wonder and am concerned that there may be a way to, especially when you take a look at Europe and their privacy regs, about how we may want to be able to say that there is a zone of privacy even if it isn't. Say, for example, and I'll just make maybe a weak analogy, trade secrets. Just because a trade secret is generally known, if you maintain the measures to keep it, reasonable measures to keep it secret, you can keep that secret formula. Say, for example, the Coke formula. Distributors all over the world are using the magical Coke formula. Is it a secret? Well, it's a secret closely guarded by about probably 10,000 people. But the same thing with our privacy. Just in fact that we have our privacy sphere maybe larger, there may be an ability to keep that, I would hope, to a certain degree protected from disclosure in all circumstances.
Yeah, and when you mentioned the concept that there's no reasonable expectation of privacy in social media posts and say that that's the law, I think that that's true, but there are caveats to that, and to say otherwise is to sort of gloss over it. And I glossed over it earlier, but I'll just put one site in front of you. Appler v. Meade Johnson and Company. This was a district court case out of the Southern District of Indiana in 2015. And the court was dealing with a defendant who requested that the plaintiff produce the entire Facebook page, essentially Control P, on the full Facebook page that was set to private, rather than trying to get that information through other avenues, like through deposition and all of that. So what the court ultimately says is, we recognize that you're putting the competing ideas of privacy and broad discovery up against one another, but in this specific instance, the court said produce the Facebook page. And so you have to understand that while there's no reasonable expectation of privacy in your social media content, and you can set these privacy settings as stringent as you want, courts are grappling with how to balance this still. This is something that's still very much up in the air. So if you have a Facebook page that's set to private, I think that everyone agrees that you can ask the questions in a deposition about what did you post on social media on that day. Everyone agrees that you can ask through request for production for the photos that you took that involved the incident or whatever the specific issue is that you're dealing with. But when you've got it locked down like that and there's content there that's not accessible through some other means, that you can make the argument that, look, this is something where we've held that there's no reasonable expectation of privacy. And even if a person puts their own privacy settings on, these sites still have in their terms of use disclaimers that you can latch onto to say, no, even if they're going to lock it down completely, I still am entitled to access in some way. Like Facebook's terms of use for a very long time, I'm not sure whether this is still the case, I haven't looked recently, but have said explicitly that you do not have a reasonable expectation of privacy in the content that you post on Facebook. Facebook initially actually said that any content you post on Facebook belonged to Facebook. They got rid of that with the idea that, oh dear, now we actually have to respond to all of these subpoenas we're getting. That kicked that to the curb very quickly. But this is still something that courts are grappling with as sort of a balancing act.
We do have a couple more minutes, so I thought maybe we turn to one area dealing with sort of the intersection of social media and free speech. And this is a case that came out of Virginia, which is the outlier in decisions throughout the country. This is Hunter versus Virginia State Bar. And just by way of background, this was a criminal defense attorney in the city of Richmond, and he blogged on cases that he felt of interest. And a lot of times he blogged about his own cases. He blogged about social justice issues, why it is that we have punishment for low-level offenses, why are these jailable offenses. So there was a mix of political commentary, but there was also a mix of discussion about the very cases that he handled. The State Bar felt that the blog posts were inappropriate for a number of reasons, one of which was he was talking about cases that he handled and talked about the results that he got for clients. And he talked about it in the context, for example, that I can't believe I got my client off on this drug conviction and used the client's name. But you laugh and guffaw, but is that a problem? Because of the fact it was a public proceeding in which he was able to obtain the result for his client, and obviously a very good result. So under that circumstance, you look at this and say, it's a public proceeding. It'd be no different than if I tried the case and Laura Lee blogged about it. Why can't I blog about my case? And the State Bar said, well, we don't think that's appropriate because you're the attorney. Well, why not? Don't I have First Amendment rights? Don't I have free speech rights? And the lower disciplinary proceedings, he was found to have violated the rules regarding client confidentiality. And we think about that Rule 1.6, and there's this idea that, and client confidentiality is much broader than the idea of attorney-client privilege. It goes beyond that, and then you talk about the whole idea of confidential, which subsumes attorney-client privilege. So, for example, confidential information isn't just the confines of my conversation with my client. It may be information that I learned during the course of the representation that if I revealed it would be embarrassing or humiliating. So even if everybody knows it, I can't go ahead and talk about it. That's the idea of confidentiality. In other words, I represent a client, and my neighbor wants to talk about the case, and I say, I can't talk about this, but I can tell you what happened in court. My client was a bozo. That stuff is typically considered to be inappropriate because clients come to lawyers because they expect that they are going to be able to get counsel. And if the client is concerned that at the end of the day, the lawyer is going to be talking about it with a neighbor, or frankly, another attorney in that firm that doesn't have a need to know, then the client may be less willing to tell you information that would be helpful for the case and give you the ability to counsel the client to do the right thing in certain circumstances, or defend the person, or provide whatever representation is needed. So that's the bar's perspective on this. The bar was very concerned about it. In fact, the bar did some investigation. It did not come out in the trial or the Supreme Court opinion, but the bar actually investigated some of the clients that he used their names with, and guess what? They had no idea. They had no idea that their name was being used in there. Okay, HR professionals. Do you think they use social media? Do you think they may Google somebody's name and up pops, wow, I am so glad that Jane Doe got off on that drug conviction. Congratulations, Jane Doe. That kind of information probably could be found by searching various databases and going to the court and listening in the proceedings. Because if you've been to a courthouse and you go to those court dates, oftentimes it's you, the judge, and your client, and the other opposing counsel. It's not like we've got a full room. So the State Bar went in there and said, this is a confidentiality issue. It's in violation of Rule 1.6. Supreme Court looked at it and said, no. This is a First Amendment issue. In fact, the only real debate was whether or not this was accorded political speech or commercial speech. And ultimately, in a 5-2 decision, the Virginia Supreme Court said, this is commercial speech. So, you get the intermediate scrutiny. But what he put out there, he's allowed to talk about it. He was in the courtroom at the time, so he's allowed to discuss these matters in his blog postings. The only issue that did get pushed back down to the disciplinary committee was his decision to not use disclaimers in his post, which is now basically a dead issue. But he took down his blog postings after the decision because he felt like after he failed to get an appeal granted to the U.S. Supreme Court, that it wasn't worth it to keep the sites up and provide the disclaimers. He didn't think that was appropriate, at least according to the press accounts of it. So The Supreme Court of Virginia looks at it as a First Amendment issue, which basically they're saying, as I read the opinion, that the First Amendment trumps Rule 1.6 dealing with client confidentiality. Needless to say, and this is why it's important, there's jurisdictional issues, Virginia's pretty much it. Nobody else buys what Virginia is selling. And in fact, there was a ABA formal opinion back in May of last year talking about the issue of blogging and basically saying you've got to maintain your client confidentiality. Now, can you blog about your client cases? As indicated, I'm firm counsel, and I tell the lawyers of my firm, you don't blog about your client's cases. It's great marketing, right? But you don't blog about it unless the client says that you can, and you believe it's in the client's interest, and the client does as well. Just because the client even agrees to it, it may not be in the client's best interest, and you as the lawyer should provide that counsel. But even if it is in the client's best interest, you've got to be very careful about the confidentiality. Why? Because if it comes from the lawyer that handled the case, you would presume that the lawyer knows the inside, that the lawyer has all the information. So Hunter is that outlier. It is talking about free speech, but I can definitely see that tenuous decision about, well, if I'm in the court, why can't I blog about my cases? Why can't I talk about what it is that I do? Because frankly, a criminal defense attorney's best marketing is to say that you won. And if you can't say that you won, kind of makes it hard to advertise what it is that you do. I know you have other ways of doing so, but I think it's an important way to distinguish yourself from all the other attorneys that are out there that practice in your area.
And will it absolve any issues with client confidentiality if you just take out the name?
Well, and it's interesting because you see these cases that come out in these press accounts. For example, Virginia Lawyers Weekly always talks about confidential settlements. Well, you say it was in Lunenburg Circuit Court. Lunenburg probably gets maybe 15 civil cases a year, 14 of them are divorce cases. You're dealing with a rather interesting personal injuries fact pattern that was well known and was in the press. So when you say it's confidential and you take the name out, is it really confidential? And if you can do a couple leaps to get to the person, frankly, you can usually cut and paste, throw it up there, and if a press account comes up, it's not confidential. So taking out the name, I don't think necessarily takes you away from the issue of the confidentiality, unless it is so incredibly innocuous, which at that point may not provide merit for the advertising or blogging that you're trying to put out there. I think that's kind of the concern that I would have with that.
But then you can go too far the other way too, where let's say you take out the name and you say, oh, I can plug this into Google and I can still figure out what specific auto accident I'm talking about here. I'm going to change the facts a bit. And you change the facts around. Are you then in some sort of danger zone for, deceptive advertising?
True.
In that you've altered the facts too far, you've made it too flashy, maybe. You've made yourself look way more impressive because you turned a 2-car accident into a 15-car pileup on I-95. I mean, is that something that you can go too far the other way?
Yeah, I think that's right. That's why you always want to use that word hypothetical. Hypothetical. It is difficult to blog and talk about cases in which you're involved, understanding that you want to be able to talk about those cases because, frankly, you can probably provide a lot of information to the lawyer public and the public at large about the cases. I will say one other thing about this, it sort of permeates some of the discussion about here's a real cheap, free way to at least monitor yourself. I do highly suggest you do the Google Alerts. All you type in Google Alerts, it will tell you how to do it. It takes about 3 seconds, and you put in your name, and that way, if anything pops up with your name in it, you can at least see that, especially if you're not as actively engaged in social media or just the internet in general. That's just an easy, quick fix to do that. So Google Alerts, go ahead and take a look at that. It is not comprehensive, but it gets you at least past go.
Yeah, and I've got one that's set up for my own name, which always makes me feel very vain, and I get kind of excited if anything ever does pop up because I'm like, oh, I'm out there in the news. But there's actually another Laura Lee Miller who's a president with Vera Wang, so I mostly get her life updates, not my own. But one day it'll actually pertain to me. But I do it for my firm too. I've got one set up for my firm so that I can see, what kind of press is there about what my firm is doing. What sort of information are they picking up from Google? So it's a really great tool. I would highly encourage everyone to use it.
Are there any questions that we can answer before we wrap up? And whenever you say that, and before we wrap up, that means there won't be any other questions.
Right.
All right, well, thank you very much. Appreciated being here with you all.
Thank you so much. I think there actually will be some Google alerts today because one thing I should note is if you want to follow the JOLT Twitter account at Richmond JOLT, J-O-L-T, we are tweeting about the entire symposium today. So we're going to take a break. I know we're a little bit ahead of schedule, so let's still do 15 minutes, try to be back in here at 10:50 if we can. During that break, I'm sure you're going to jump on your own social media accounts and make sure everything is up to snuff, or look at your potential clients. By the way, Visit UR is the guest Wi-Fi here. There is no password required for it. If you would like to log on, you just have to do the check the box to indicate the term. So thanks. There is coffee. There are snacks out in the atrium, but we look forward to seeing you back in here at 10:50. Thank you. All right, I believe we're about to get started again.
That's what it takes.
Our next two speakers will be presenting on picking up the slack, legal and information governance considerations for newer technologies. It'll be presented by James Shearer, who's a partner at Baker Hostetler, and Ben Barnes, an associate with Redgrave. The session will discuss the benefits offered by newer, disruptive technologies, so long as the business utilizing them accounts for the challenges they present. And they'll be using the software platform of Slack as an example. I don't mind saying that JOLT this year began using Slack themselves as part of their communication. So we are very much excited to have James and Ben here. Please give them a round of applause and a warm welcome.
All right, good still morning to everybody. So make sure we're not going to pick up our own feedback here. So we're going to start by introducing each other a little bit more. While we work at different firms now, Ben and I had the opportunity to work together for, I don't know, 40 years, I think, it seemed like.
It felt like forever. It really did.
Forever. So Ben and I worked together in Baker's information governance team and also did a lot of work in litigation. And the material that we're going to present on today actually came out of a client opportunity and led to a lot of interesting discussions and, as I'll explain, an opportunity to present around the world. But I wanted to kick it over to Ben so he can tell you a little bit more about where this came from and why it may matter to this audience.
Yeah, exactly. So it's really fascinating how this just came up. This wasn't something that we were just looking into. Like, we decided, hey, I'm going to write a paper on Slack because it's a newfangled thing. This actually came up through conversations with clients. We had some clients that actually used Slack in their everyday business. This is what they used, and they were trying to look and find some sort of guidance, somebody that knows something about this, and they couldn't find anything. It just didn't exist. Nobody was dealing with this issue. Lawyers weren't on Slack, right? We're still faxing people, right? I mean, we're so far behind what these much more agile companies are doing. So the client, of course, came to us and said, hey, can we actually work on this and create some sort of guidance, some sort of guidelines, some sort of framework that other people in our situation can use to evaluate Slack or these new technologies that come up. And so that's really where this process started when we actually started diving into Slack. Does anyone know what Slack is? How many people are on Slack?
Oh, and that's fair. Whenever we talk about social media, if you're looking at your phones, A, I assume you're researching what we're talking about. B, that means I'm going to call on you because we are in law school and we are firmly adherent to the Socratic method. And that's exactly right. So we had an opportunity with the client. I don't know if anybody here is familiar with the Sedona Conference. A lot of their material are cited through JOLT. What Sedona has looked at over the course of its existence has been, how do you move the law forward when you have newer technologies and newer approaches coming in that the courts simply haven't caught up with? An active discussion at the faculty dinner last night about MySpace and how maybe the jurisprudence surrounding MySpace may not be as applicable anymore, and you're trying to do extensions out. Well, as these new technologies come online, these are real client concerns, because they'll say, okay, well, what have the courts said about Slack? And you check Lexis and Westlaw, and there's not too much. So how do you give clients good advice that's going to stand up? And then how can you start to shape or frame the way in which courts and regulators and, frankly, other litigants are going to be these technologies? So that's when we step into the fray. So we'd looked at this issue. Client had posed it. And it wasn't just our client. You know, a number of clients had looked at Slack and some of the other technologies that start to integrate that. So for all of you who are Googling it right now, I'm going to ask you a more simple question. Who here has a cell phone? All right. Does anybody not? All right. So God bless you. Don't ride in the car with her because she breaks down. You're done. But when we think about this, we had taken the work that we did in Slack and had the opportunity to present at law schools in Bangalore, in India, and Kathmandu in Nepal. Asked the same question. Everybody raised their hands. We were also teaching them a little bit about United States e-discovery. So I told them all to unlock their phones. And then I strode toward them and I took one of their phones away. Never seen a more terrified person. But of course, they were involved, they were using Slack, they were using these collaborative technologies. And that's one of the wonders here, where there's no barrier necessarily to using those. So A, it means people are conversant in similar technologies and they can start to discuss the things. But B, it meant that if I look across this audience, just looking at you, I wouldn't know if you were using this technology. You don't have to license it. It's free for your use. There may be different levels that you can access and that you can pay for. And that idea of paying for different tiers or tranches of service is an important one. But there's no real barrier. As long as you've got that cell phone, you can get on there. You can start working with this. You can figure it out. And you'll use it in very different ways depending on the person. But it just depends. And that's what we as practitioners have to be aware of. These technologies, and that there are no barriers. And it's not that you would necessarily have reported to anyone else what you're doing. You just end up doing it in kind of an organic function.
Yeah, it really plays into what the last presentation had discussed about how, as lawyers, you need to be aware of those technologies that are being used. And you would not want to be on the other side when there's a question about Slack and you have no idea what your client's been doing with it. And that's a scary place to be. So,
you want to click to the first one?
Yeah.
I'll let you control.
This is way too much responsibility for me. Hey.
So what is Slack? Did anybody Google it, or anyone comfortable in discussing? We'll make this interactive. I will start just calling on you and I'll say, hey, comfy sweater in the back. No, it is a collaborative technology. If you can think about if you've ever used Microsoft SharePoint, where you'll have a document in a central place and people can all edit the document while working together. Well, Slack takes that to another degree, and you start putting that out online, not within a corporate environment, saying, okay, well, here, we're working on this piece of code, or we're working on this presentation, or this response to a request for production. Here are my notes on it. Here's how this document or how this material has evolved. And, of course, it is, for the very most part, cloud-based.
Yeah, and especially, it's not just your team, right? It's not going to be just employees at X company. You can do this with joint ventures or with vendors, and all of a sudden you have these groups that are forming that have a diverse spread of people from different firms, different companies, and things like that. And those are all issues that need to be considered when you're looking at implementing Slack.
And you think about affinity groups as well, so you can join, it's not just like a discussion board, but it can function as such. And they're not super choosy. I know this because they let me into some. So you can get on there and you can start that discussion. You can see the materials that people are providing. But of course, anytime you have a platform like that, you have an extension, if you're an organization or if you're representing your client, about how to manage it. So I worked with a client before who came to us with a very small type of platform question. And this was a client who had a big corporate campus in the Midwest, and they set up this little messaging board. And they were trying to direct people to know where you could walk and where you couldn't, because they were shutting down certain paths. They were saying, don't go over here, it's too muddy. You don't have access to this building, you have to go around this way. And of course, there was a message board where people could share information about, come over here, this is a good place to park. Did they only use the message board to talk about parking? No, of course it turned to politics right away. And, and then complaints about the business and about certain individuals. It almost immediately devolved. So the question from the client came in and said, hey, do we have to worry about possibly putting some of this information under legal hold? Now, the first point here is, if you have the question, do I have to put this under legal hold? The answer is almost immediately yes. Right? If you ask the question, it's like, should we cancel the wedding?
If you're asking the question.
The question gives you the answer. It's not often like, well, we already have whatever. So then the client said, well, we didn't know. We didn't even think about this in setting up this collaborative platform. Is there anything else we should worry about? Okay, another question that kind of brings in the answer. So we undertook this effort in looking at what that organization had put out there, like publicly facing what collaborative platforms and technology did they use. So this is a Midwest-based multinational organization. Undertook a little bit of work and effort, and in doing so, I think we uncovered at the time 27 separate and distinct instances of communications technology that weren't covered under their official policies or that they weren't addressing given their current governance positions. And my favorite one by far, were some of the organization's scientists who were speaking at an international convention. They said, well, we had a lot of challenges in trying to do this project because we were crossing borders, defining this technology and coming up with a new product. And we were stuck internally because certain of our communications protocols wouldn't allow us to share information. So we went out and found this technology. It sounded like it was like originating in Eastern Europe and former Balkan countries. And it turns out it was free, so we just all used that. And we started sending around documents around the world. Anybody here see a potential issue? Anybody? So this is when we talk about, you can see shadow and credit card IT and the intersection of information technology. So anybody here have any questions about that? I'm going to assume not, so I'm going to ask Ben. Ben, what is shadow and credit card IT?
Yeah, so shadow and credit card IT. Shadow is things that are hidden. You in all of your organizations probably have an IT, have some guy that's stuck behind a computer somewhere. He's usually very pasty. There's no windows in his office. That guy is in charge of looking and watching and making sure that everything's working within the confines of the organization. If it's tech, he's the guy to talk to. But when you get into technologies like Slack, a lot of these newer ones, the ones that are on the cloud, things that are on your phone, those types of things he can't see. He's blind to. And so those types of technologies live within the shadows. And that's a dangerous place to be for an organization, especially when you come into legal holds or record retention or what do we need to keep for regulatory purposes, right? All these considerations need to be addressed, and if they're living in the shadows, you miss it. Credit card IT is similar. A lot of times, you have a big organization, you have a lot of different teams, a lot of different groups that have different ideas, different concerns. You'll have that company that, we need to try to share things and we don't have a platform. And so they'll take their Amex, their company credit card, and they'll buy a platform. And so accounting is using this platform. No one else in the company knows about that platform. IT doesn't support that platform. These types of things, again, fall in that same category where the IT simply is not aware of it, and even worse, legal is not aware of it, or any of the other parts of the business that really need to be aware of what's going on with the information, how's it being stored, how's it being protected, and who has access to it.
So it's not just that you can get these things for free. It's not just that they're meant to be accessible. It's not just that you can do it and you may not even be sober the first time you open up one of these apps. Like, they're meant to be extraordinarily easy. It is a common lowest denominator accessibility issue. They want as broad an audience as possible for a variety of different reasons. So these applications are meant to be easy. They're meant to be really very fundamentally tied to your technology, so they're always going to work, or except that very moment when you need it to. And they're meant to connect. They're always out there seeking. Several years ago, Craig Ball was presenting here, and he talked about that. Your phone, once it connects someplace, it always wants to be a friend. I think that's still something that's addressed. You won't know how many places your phone is pinging until it says, hey, do you want to join this again? Or you found out you're automatically joined. Right? I'm pretty sure that would be a Seinfeld episode now where someone goes in and it's like, oh, you joined my girlfriend's Wi-Fi automatically on your phone. How did that happen? So your phone and your technology wants to connect. So we then combine that with the power of social media because it's easy to do. It's already built in this connection, and you have a potential audience that dwarfs the New York Times. How did we get to that point? How did we get to the point from a tweet about my or Ben's amazing jokes here today could make it out onto the social media, and depending on what line it hit, could be magnified and amplified. It can make it out there. These are these tools of potential mass destruction that we're handing out with absolutely no potential training, but a lot of potential culpability. And not just on behalf of individuals, but when we try to start to think about this. So again, combination, free, hidden, incredibly powerful, and even more so scalable, without the knowledge of the organization, but potentially on behalf of it. Because if you're doing that business, if those scientists are sharing information and it's crossing borders and they're doing it for a project for work, how sympathetic is the US government going to be about export controls? And the lawyers say, well, they didn't let us know. Why didn't they let us, or why don't they like us? Why weren't we in communication? Whatever it is, but these are the things we have to start to think about, like how do you build up some considerations and barriers around it? And that's what we want to talk about today. Eventually.
Eventually.
I guess.
Like I said, there's too much responsibility for me.
All right, here we go.
Oh, yeah, there we go. So every organization needs to actually address these hard questions. They need to have an idea of what the answer is to all of these questions before they really start implementing these tools. So the first one is, how is the tool being used in the organization and by whom? So who has access? That is a huge part, especially when you're dealing with information that is potentially sensitive, right? If you end up having health information or personal financial information, it's being shared within a group. Is everyone in that group required to have that information? Do you have people that really shouldn't have access to that information that are accessing that information? And so it's really important to try to get your arms around what this tool is actually going to be used for when it is implemented in, or how it's been implemented within the organization. Did you want to talk anything more about that?
This is a tricky conversation, and I'm going to come back to this point because it's actually one. And again, for those of you checking your phones right now, you are part of this discussion, and I appreciate that. Who's using it, and how can you tell? Well, as you do even on the e-discovery side, and like a lot of this is tied to the technology here, it is a comprehensive approach. You have to look at your IT infrastructure. Even the kind of the shadow/credit card IT, you can see what devices are accessing your network. Sometimes you can get a sense of where that information is flowing. But you have to start with what you know about. And then you have to ask. You do have to ask those questions. And oftentimes we find that those questions never get asked. Well, they get asked twice if I'm involved. They get asked when I come into the organization and I start interviewing the employees. And I'll sit down, let's pretend that you're an employee. And I try to be friendly because it sucks to talk with me. And I say, well, what do you use? Is there anything other than email and your files and some of the SharePoint or share drive sites that you have where you are communicating relevant, responsive, non-duplicative information. And you look at me and you say, no, James, I don't. And I'll say, is there any place other than email and SharePoint and your share drive that you have this information? You're like, no, I'm really confident. I was like, check out your phone. Is there any place on there where you're sending information out? Do you use Facebook Messenger? Have you ever texted about work? Have you ever done the other things? And now you're doubled down. You're like, no, James, there's no other, you don't say it exactly as I said it, but non-duplicative, relevant, responsive information. And then I say to Ben, are there any other places we should look and think about this? And you say, oh, wait a second. Do you mean, and you list off 7 places. Now that's the best case scenario. That's the best case scenario, because what usually happens is we've had this discussion. We go through and we preserve, we collect information, we start to build out policy around that, we start to preserve information if we need it, and then we get your deposition notice. And then we sit down in that room, and you're sitting there, and for those of you who are practicing attorneys who have never been deposed, good luck. You sit down and the videographer's across from you, and there's a court reporter next to you, and there's counsel and a second chair, and we're there defending with our second chair, and suddenly it seems like a very different conversation. And I don't know why, but you seem to be more engaged in the conversation at that point, and more actively thinking about where that information might be. And suddenly you start to share things that maybe would have been great for me to know about 6 months ago. You're like, oh, do you mean this application that is literally the 3rd app on my phone that I access every 15 minutes? Is that potentially responsive? So that's the type of challenge that we see. People are galvanized into responses. So how do we get to that point in the conversation when we're trying to establish policy, when we still have an opportunity to create some real curbs and efforts around it? Ben's going to tell you.
Yeah, it really is a fascinating, and it almost comes down to changing, really having a culture and really almost training your employees about these new technologies and what needs to be done with them. And there's a lot of new technology that you're just not going to be able to grasp on your own, okay? And so a lot of it is going to be building those teams where you end up bringing in stakeholders, people from these individual teams. Have somebody from HR, have somebody from IT, have somebody from whatever different team is going to actually be implementing these tools, and getting their feedback, getting them to buy in to what this technology is going to do. It allows an organization to tailor that technology and tailor policies and tailor practices in order to have a culture within that company that does this, that realizes the very real considerations that can arise when you put in these new technologies. So,
and if you think back to the example of the multinational, and those individuals who were sharing data across borders, why were they doing that? Why did they use the tool that they had? I mean, there's 2 reasons. One, they had a job to do. They had to get this work done, but they didn't have a means by which they could do it. They didn't feel like they could get a new technology. It was easier for them. They could become a maverick. They could find a way around existing corporate structures. They have the internet, and they have their own PCs, and they've got technologies now that enable them to do that. So it's incumbent in some ways on the organization then to say, we know what our employees need to do as far as their work, or that we need to have an open channel so they can tell us. How can we support that? And do the technologies that are out there, are they going to support it in that way? And then how do we find the right blend of the technology that they're going to use or they're going to want to use, and what we as an organization can responsibly incorporate into our network? So for those of you who were at the dinner last night and already heard this story, I apologize, but I told you, you're going to hear my jokes more than once. For everybody else, get ready, it's hilarious. No. Another client project. Client came to us and said, hey, We're a multinational, international organization. Our employees collaborate, they communicate. And a lot of them are already familiar with WhatsApp. So what we want to know is, can we go ahead and implement WhatsApp as our corporate communication tool? We're already all over the world, people can use it. How many people here use WhatsApp? All right, well, if you go abroad, you do. If you switch out your SIM card, you will. And it's, again, very, very easy. It's now, I think that was also purchased by Facebook. Because it's great to put all that data in one spot. So we took a look. We took a look at WhatsApp, and this is specifically for number 2 here on paying for the tool. So WhatsApp at that time was amazing as far as its terms of service. Let me take a step back here. When I was in Kathmandu especially, everybody holding up their phones, they were all using WhatsApp. They were all using Facebook. Many of them were using WeChat, so like the Chinese version of it, and I kidded them. I just said they all had significant others in China. And I asked them, I said, who here has read those terms of service? Nobody raised their hands. They put down their phones because they were hiding them from me at that point. And I said, well, guess what? You're the lawyers, or soon to be, you are the ones that have to read these things. So of course, when we're looking at WhatsApp, we're reading the terms of service. Now, WhatsApp's terms of service are almost magical. They're like, don't use this tool. Don't do it. We have no responsibility. We're telling you actively not to do this. This will kill you if you use it. They were slightly less, but just about those lines. This is not a professional tool. You can't pay us to use it. It's just free. We're disclaiming any and all responsibility. So as an attorney writing a memo for a client, this is fantastic. I can come back to the client and say, don't do it. They've told you not to do it. They could not be more explicit. I'm fairly certain if I could read these other 7 languages, it would say the same thing. Over and over and over again, do not use this tool for your business. What did the client say in return? You guys have these clients. What did they say? Anybody? Hypothetically. Hypothetically, let's just say we've been using it for 6 months. Then, does that change your answer? So, it does, because you want to support your client's business. And then you start working within the parameters of compensating controls. How do you fix things around the periphery when you can't fix the thing? How do you work around that and then create an environment in which you can still have compliance? But paying for the tool is important here. So if you are starting to investigate this on behalf of your client, or if you go back to the place where you work, regardless if that's a firm or you're in-house, or if you're a solo proprietorship, then you've got some questions to ask in the mirror. But looking at this and saying, okay, are there different tiers of service? Because if you have professional obligations, if you have ethical considerations, if you are actively thinking about how data moves, then maybe free isn't the way to go. There are different tiers of service within these technologies. Oftentimes it's just a matter of unlocking them, but you'll see there's a lot more responsiveness, there's a lot more controls, there's a lot more available for those restrictions once you start engaging in the tool. And that's an important thing to ask for the client, because different levels and different tiers of service matter, even within an environment like Office 365. So we're talking about these tools that you can download for free, but please don't kid yourself. If you're within some of these larger email systems, if you use Google Docs, or if you use Office, or if you use some of the other competing systems, they're all moving to these points of cloud-based collaborative technology. Many of them work the same because those underlying principles are still, you are sharing information, it's stored somewhere. The cloud is not just the weather here today, it's just a computer someplace else. Except that it may not be one place all the time. It may move around. If you use Amazon Web Services, or if you use Azure, or if you use some of these different infrastructure things, those are all questions we have to ask that 10 years ago we didn't. 10 years ago, it was still the pasty IT guy who could point down the hall and say, my server is there in that room. Now, that server might be load balanced, half of it's in Austria and half of it's in Alaska, or wherever it is. So we think about that. Are you paying for the tool so that you can start to ask some of those questions you may have to get answers to? And I guess that goes right into who's holding the organization's data.
Yeah, this is important for a lot of different reasons. For one is data privacy, right? What are they doing to protect it? Also, who else is looking at it, right? If it's sitting out there in the cloud, at Amazon or who knows where, Kathmandu, what if something goes wrong? Are these IT guys that are working on the cloud, are they going to look at your information? Are they going to see that information? And then what does that trigger for you? Is that a data breach? Do I have to get some sort of consent from these people's information that has been exposed? It's important to know that, to know what restrictions are made. It's also important to understand what's being done to protect the data integrity as well. Like, is it going to be changed in there? Are there backups? What safety nets have been built? This is all stuff that's outside of your control. Many times these specific services that you're using, they're the ones that picked the cloud provider, right? You had no say in it. They just said, we're going to use AWS. That's our service. And those types of things matter. So that's one of the big ideas is, where in the world is the organization? And that kind of leads into the next one about who has access to that organization. Is it just employees? What disclaimer did you agree to when you signed up for that app or when you signed up for that cloud service? Did you tell the cloud service provider, yeah, you can look at my data if it helps improve service? Have you just violated an agreement with your clients that said that you weren't going to disclose their information? You violated some Iowa statute? These are all considerations that need to be thought of for someone who's engaging in this new technology, especially when it's cloud-based.
We don't have on here too, but the other question is, who owns that data? So if you use Facebook, you're interacting on that platform. All of those interactions are data points. And they are really valuable, depending how much you buy or what potential consumer you are. For those of you who saw, or may have missed, Mark Zuckerberg's testimony in front of Congress, the question was, how do I pay for Facebook? Awesome question. And of course, the response was, we serve ads. We serve ads on behalf of those other places that are trying to get to your data. So can you flip to the next slide? So that's the question. If you're not paying for it, and this goes back to if you're licensing the tool, you're still paying for it. You just end up being the product or the service and that information you're providing. And now it gets even trickier for some of these collaborative platforms because you're not just supplying your personal data. You may be supplying the information of the organization. And they may not know about it. But I'm fairly certain they would have an opinion about that if you took the time to ask them. And we just talked about who has access to that data. Now, if one of these platforms wants to go in and pull down messages or pull down documents that you've got because they're using them for their own metrics, or maybe they're using all of that data to build up their own expert systems. Maybe they're taking those things and building up algorithms, real value that can be licensed and you can apply intellectual property protections around. Maybe you agreed to all of that without thinking through the lessons. But then you look at it and say, but wait a second, that's still my stuff, and maybe I want those messages out. Is it easy for me to get that data down? And what are the methods by which I can do that? Now, I still remember having a discussion where we had important text messages on the phone. We reached out to the client and said, okay, well, we need copies of those messages. And what do they do? And you might have thought, oh, well, maybe they forwarded them. Maybe they used a tool like Celebrite to download those. No. I got the scan where someone had taken the phone and put it on the copier and made copies of each text and scrolled through. And I swear I had just made the joke to someone. I'm like, oh, man, I hope they don't do something like that. And they did. We've advanced a little bit past that. But it's still tricky because it's no longer necessarily a conversation just between me and Ben. That's not how we communicate anymore. We might start on one platform, and we might move to another one. Or it could start with a call, and Ben's like, okay, well, I'll send this to you on email. And then I forward that email on and say, okay, let's put it up in this collaborative space, and we'll start talking about this. These conversations start taking forks in the road. And you can lose that cohesiveness, but it still all matters. And then if you have gaps because certain technologies don't allow you to pull that information down, well, then you've got gaps in your corporate record keeping as well. Now, maybe you don't want to define those things as records. And if you take a look, again, we've got this all in an article, and we're covering the higher points here. So we've gone into depth in an article that will be published as part of the symposium. But this is why it matters. These are the types of like overarching questions you want to have. Because it's good to have the checklist, but you got to start with the conversation. And the conversation is all about how do you communicate? How do you communicate with other people? How do you communicate with your suppliers or your customers? With your employees? How do you collaborate? How do you send information out there? What kind of controls do you have about that information? And where do you need controls where you haven't thought about it before?
Yeah, and that really goes into that, how the tool is being used. Like, what is the context? What's the content that's being shared? Are serious business decisions being made on these platforms? Because if they are, then perhaps there's a retention that needs to be taken. Perhaps these aren't just fluff communications back and forth that we can delete, because they don't mean anything. Perhaps it's sharing cat pictures, but perhaps it's we should fire Steve, right? I mean, these are important aspects, and when Steve sues, you're going to want to have that Slack conversation where you discuss why we're going to get rid of Steve, right? These are considerations that are extremely important, and the how is incredibly important, which is why we asked it twice, to really get that point that not just what teams are using it and who's using it, but what's actually going on within that platform. And a lot of that comes back to what we talked about before about what are you paying for, because depending on that level of how much you pay, that may vary what transparency you actually have of the tool and what's going on within that tool.
And there's ways this information can be hidden, and there's a lot more than you may think there is. So one of the good examples, for those of you who have iPhones and have started to see, this feature came out, I think it was a year or two ago, where you take the picture, but it's a little bit of a moving picture, so it starts at one point and it stops. And you've seen that, you hold it down and you can see someone move. It shows how awkward I look at every stage of getting a picture taken. But, I mean, does anybody use that function on their phone? Like the active picture? Or I think it was set at default for a little bit. It also records the audio when you do that picture. So if you don't have your phone audio on, you won't tell. But if you send people pictures like that, you'll hear the background. So you want to talk about the Steve example. If you were taking a picture of your cat, which was kind of funny, but you were talking about firing Steve, because your cat is an amazing listener, you've created a weird record, okay? A, I want that deposition exhibit. I really do. So if you've got, please share. But B, it's tricky in that way. So when we talk about how you export the data from the tool, who designs and sets up these tools? Is it a room full of lawyers like this? No, we know we're no fun. They don't invite us to those discussions. We get brought in later, and they always make us wear suits, and it's a real problem. No, it's engineers, and they're young engineers, and they're excited. And the question is always, can I do this? Can I do this? It's never, may I do this? Should I do this? Will this be a good idea a week from now? How much pizza did I eat? No, it's, can I do this? So you've got engineers designing these applications that are thinking, what can I pull in? Because data is valuable. What can I assemble? What can I drag in? My phone has an accelerometer. It's got a GPS. It's pinging off cell towers all the time. This thing wants to connect to everything. And it wants to tell you everything that's going on. It tells me when I need to breathe, which is apparently a problem. Like, I really should breathe enough that my phone isn't reminding me. But it's keeping all that data. And some of these apps do the same. They're pulling in everything. Because the phone's like, hey, here's me. Here's all this stuff. And an application will be like, all right, come on, bring it in. Because it turns out it's super cheap to store all that information, especially when you put it in a cloud. So if you are working with an organization that's using one of these tools, and there wasn't a lot of foresight about what information it would collect, chances are it defaults into an incredible data picture. Then you have to think about that at the back end. If I want to get information out, or I should be managing this information, what do I have to ask for? And it's not enough just to say, well, I just want everything out, because remember, you're not paying for the tool necessarily. So you have to be pretty specific, figuring out what the interaction was, how that went. If you've never heard the term API before, application, what is it, programming interface, that's the method by which disparate technologies can communicate. A lot of these organizations will put their APIs out there so that you can develop on top of them because, again, they want to collaborate. They want to create this network. They want to scale. They want audiences in the tens or hundreds of millions. But that means it's all these connections, and that's what you, if you're thinking about managing information, if you're trying to set up policies, if you're trying to help counsel your clients and change business practices, or if you have to worry about it on the back end for regulatory investigation or compliance with certain rules about how you transfer information or what you disclose, all of this comes together as far as the picture of information, how it's shared, how it's accessed, and just how it moves around.
Yeah, and part of that also ends up flowing into the shadow IT thing too. There might be an API, there might be a plug-in to Slack that your IT has never considered, that you guys didn't realize was out there, and then some Joe Blow ends up downloading it, and somehow information about your customers is being put onto Slack that you had no idea, which is a fascinating discussion. And there's so many interactions within all these new technologies because of those APIs. Everyone wants that interaction. It's a tangled web to weave to try to unravel what in the world is going on, what information is coming from where, and where it ends up staying.
And we even touch on one of my favorite acronyms, well, it's initialism, BYOD. Anybody know what BYOD is? Bring your own device, or there's corporate-owned device, or there's some mixture, or as you find a device on the street, you use it for a while. It's a number of different programs, but bring your own device, how do you manage that? Especially because then you're downloading these technologies onto your phone or onto your home computer, but then you're accessing work. How well are you segregating all that information? And if you do have things that are fairly well sandboxed off, how many, I'm not going to ask, this is not a confessional, and I know we're being recorded, okay? So how many of you have friends that have to email work documents to their home email accounts to work on them? Anybody have a friend like that? And no one has those friends. Okay, maybe you didn't ask the right questions, or maybe you just don't want to know. But people are just trying to do work in a lot of different places. Like the expectation for where you work and how you do has changed. And we as attorneys, or people who are responsible for counseling clients, just have to appreciate that too. If there's a will, there's a way. And that's one of the challenges here. So how do we understand, appreciate, and recognize that? Again, Ben's going to give you the answer.
Actually, before we move on to the next slide,
I was just teasing.
I did want to point out one other aspect of the export that is important, and that's it goes back to what are you paying for? You may end up in a situation where you don't have the license to actually export the data that you thought you owned on various platforms, and that data ends up being held ransom, basically, by the company because, I'm sorry, you're not a premier member, so you can't download that information. Or you're not a premier member, so the download that we're going to give you is incomprehensible. Those are serious considerations to a company to be aware of and to be ready to maybe you have an API that will archive everything, so you don't have to depend on the company. But that's another aspect of the export that needs to be considered. So we've asked a lot of hard questions. Maybe we should answer some questions before we send you guys on your way. So, all right, answering the hard questions. So these are our four main bullets about how you actually address these specific concerns. And the first one is building consensus. And what we mean by that is really working with those teams to get everybody on board and facing in the right directions when you are implementing these new technologies. This is incredibly important for a lot of reasons. First of all, we talked about how's the tool going to be used. okay? Without talking to people, without having that communication, you're not going to know, right? You're simply not going to know what HR is going to use that tool for versus manufacturing, right? You have to actually have that communication with the stakeholders to determine what the tool is going to be doing and how it's going to be implemented. It also helps on the other side too. It actually helps to build compliance as well. By having the manufacturing team know that their voice was heard, it's going to make them a little bit more likely to say, I guess we can do these specific things that legal wants us to do. I guess we can do what IT said, what the restrictions that IT has put into place. So building consensus works on both sides of that issue to really make sure that policy or the practices that you're putting in place are actually going to be complied with.
So Ben's putting the positive spin on it. This is how you use people's laziness against them. When you're building consensus, you want to create an opt-in environment. Actually, no, that's wrong. It's opt-out.
Opt-out.
And let me explain why. So in working through all of these, you want to bring the voices to the table. You want to give people the opportunity to participate. But some of this is hard. It's hard to figure out exactly how the technology is going to be used. It's difficult to work through a lot of the implications, to ask all those hard questions. It's easy to complain. I don't know if you knew that, but it's super easy to complain. We kind of default into it. And it's easy for business units or individuals to complain if you didn't have an opportunity to collaborate to the discussion. If you never saw a draft of the policy before it went final, I would have done so much work. Aspirational James of the past, every weekend would have been on this policy, I would have been researching, you just never gave me the chance. Prove that negative. Don't give that opportunity. You want to put it out there and say, here's what we're doing. This is the method in which we're moving forward. These are the points we're going to consider. This is where we're making investment. And we really do have some pretty strict guidelines and considerations around it. This is where we're going to go. This is how long we're going to keep this information. This is what we're qualifying as a record. If you want it someplace else, you got to opt out of what we're doing. You can move it. You can take the time to do that, but it's going to take some effort. Never, ever underestimate the power of forcing people to do additional work in lieu of complying. Because people, if they really need it for their work, if they really need it for their business, then they'll be motivated. You know what you need to do. You know the core material. You can work with that, and then people tend to be vocal about that. But for the stuff that doesn't really matter, think of it as like the garage. You're like, I'm going to get around to that. Sure, it's the third treadmill I've bought, but this time it's going to be different. No, we're trying to work within what we understand about human psychology to say we're going to set up these programs and these platforms, and they're going to do things automatically. We're going to set them up because for the organization standpoint, not only do we need to encourage work and find what people do and support that work, we also need to consider what they don't do, what these aspirational ideas are, because all of that data, it starts to lose value fairly quickly, but then the risk goes up. If you're holding patient data, if you're a healthcare organization that goes back 30 years, maybe that's not relevant to a current diagnosis, but it still represents PHI that in the case of a data breach you're going to have to answer for. Same thing for credit card information. Credit scores going back 20 years may not be important for considerations today, but they still represent risk. And there's a lot of personal data that's found within that. So how do we start to clean that out? Especially knowing now that we have to think about all these other platforms where that data might reside, because people don't even think about it. If you're saying, okay, well, I need to do this analysis. Oh, awesome, I'll upload this spreadsheet filled with all our customer and business data to Slack so that we can work through this. Make it very, very easy to do that, but then difficult to corral. Because then you have all those questions about, well, how do I pull that back? How do I make sure nobody else accesses it? What is it that I need to do here? So that leads right to the policy considerations.
So obviously the policy is, there's a lot of different policies that need to touch these new technologies. And for example, record retention. You may be required by certain regulators to preserve certain data. Back in the day when you had a folder that data went into, when you had paper documents, it was easier. Now, like James is saying, you're spread across different platforms. Some of that data isn't clearly indexed or searchable. All right. If all of a sudden you need to look for patient X, perhaps you don't have the right index to find patient X folder within a huge group of data. So those are important. What's the record retention that you need for various records? The other aspect is just generally record retention policies among employees, teaching employees what data they should keep and what data they shouldn't keep, and how they should handle that data. If it is PHI, then you need to have very specific rules regarding that. If it's personal financial information, there are specific rules. These are all things that employees that are managing or maintaining or dealing with these information, they need to be aware of. So that means that organizations should probably tell employees about that, right? They should actually have training programs and follow up and keep those employees accountable for what they're doing with that data. And again, that goes to transparency, being able to actually look at what's happening with that data and being able to call out Joe Blow and say, hey, I saw that you emailed this customer data that's against the policy. Like those types of conversations need to occur in order to make sure that that these policies are followed.
So that's this idea of trust but verify. So you ask the questions to your employees because they'll tell you things that you won't otherwise be able to find out. So you kind of trust them, but then you need to verify what's actually happening. So that's the back end. We'll introduce a couple more acronyms or initialisms. DLP, digital loss prevention, data loss prevention, programs that work on your network that will check what types of files at least cross there. And to Ben's point, sometimes you can tell if files go out that have employee IDs or social security numbers or data that fits within certain categories. Those will get bounced back and they're often held somewhere. So knowing what's happening within those. It's a little bit more challenging though, in that personal aspect. 30 years ago, I'll tell a personal story. When I met my wife and I was in law school, I had a friend who worked at a publishing company, which meant that if you went and visited the publishing company, you could take home free books, which always sounds like a great idea. I had to buy more bookshelves because I would visit my friend and I would bring home books. It turned out that I had a camping backpack that could fit 72 paperbacks in it at once. My spine hates me, but I could pull all those things back. So when my wife met me, despite her better judgment now, she is my wife, but hundreds of books in my apartment. You could tell the type of person I was when you walked in my apartment. Like there was no confusion. Now I have a Kindle. And I gave away all those books. I still have them. Come on, they are important to me in my heart. The same thing for CDs, the same thing for movies, the same thing for all of this information. But you can't tell looking at me. Well, maybe you can. You could be a really good judge of character. But it's difficult. We can't see the pack rats so evidently now. It takes a little bit of doing. So how do you confront that? Like what types of questions do you ask? Again, trust but verify. Maybe they don't want to admit. The best story I heard in New York was somebody similar where they actually had a storage locker that they rented that their spouse didn't know about where they kept their book collection. And they would just go there and visit their books. It's not cheating. It's not me, by the way. This is not like I have a friend. So this is, just put it out there, trust but verify, then.
Well said. I don't believe that. I believe that is a story about you. But access and security. Moving on. User controls. With those traditional IT systems, you had the pasty guy that knew that only these 10 employees had access to a database. When you move that off-site, when you move it into the cloud, a lot of that transparency disappears. And if you don't have the right licenses, perhaps your company doesn't have the ability to see that. So access and security become an issue. It also crosses over when you have those integrations, those APIs that we talked about, that all of a sudden you have a great system, you have everything structured, only these people can access this information, but then one of those people plugs that into Slack through an API, and all of a sudden, now there's another group on Slack that has that access that you were unaware of. These are all considerations that need to be taken into account. Perhaps you create a policy and you say, listen, this system has a plugin, but you're not allowed to use it. Or you take some sort of technical steps to make sure that that plugin isn't implemented. These are important aspects to consider. And part of that is having just a comprehensive information governance program that covers all these aspects. What employees can do with certain information.
Can you go to the next slide? Yeah. Because we do want you to think about that. Again, this all goes back to this information life cycle. What can you do if you're helping advise clients? What can you do when you're thinking about this? Because there really isn't an area of practice it doesn't touch on. When we talk about this ethics thing, now, as attorneys, we are obligated to know how these technologies work. Or you have to find people expert enough that they can inform you. You can't show up to that first deposition if you're defending a client. Understand the first thing that's in front of them is their deposition notice, and the second thing, their LinkedIn profile. The information they're putting out there, maybe they weren't completely accurate about. Turns out you can put anything you want on LinkedIn. I know this as a 3-time Mr. Olympian. So when you're looking at where information resides, those are the type of questions you have to ask. And how did the information get there, and what can you get, and what can you elicit out, and are there different tiers? Imagine if you're defending that deponent, but the opposing counsel has the super access to LinkedIn and can look back at variations of that policy or whatever it might be. What is it that you don't know that you're going to be surprised about? And that's just as a litigator. If you're thinking about a corporate entity and what information's out there, if you're trying to do due diligence on a deal, if you're thinking about where all this information resides and how it's set up, I mean, these are tougher questions. Again, it is one of these areas in which we as practitioners can play dumb and it can work to our advantage. You can go into a meeting and say, hey, what does this word mean? What is this? And if they say you should know this, you're like, oh, I just wanted to make sure you knew. That's the game that I get to play. And then you get to ask over and over again, or you get to ask someone else. I know some amazing attorneys who really do well with that. Well-versed computer scientists are like, what is this RAM of which you speak? What's this about? Like, you mentioned this, do you mean X or Y? And then 2 hours later, it's this incredibly incisive question. Of course, it's built up out of those fundamentals. So you get to ask some of those questions, but you need to ask them from a place of fundamental knowledge. So then when you're starting to pull this information together, when you're educating on the platforms, when you're working with your clients, that really is based on those current practices we talked about. Speaking with people, asking them what they're doing, and then building that in. And it's not just asking once. Again, if you take away anything, it's I am empowering you. You can even blame me and Ben. If someone says, why do you keep hounding me about this? Why have you asked me the same question? You're like, well, Ben and James told me. And I'm fairly certain they're monitoring my social media at this point. So I better go along with that because they seemed irritating and like they could find my home address. So empowering in that way. Ben, how do you develop an information governance plan and approach and do that kind of drafting? Have you ever done that type of work?
Occasionally, I've done that a lot, and a lot of it really is working with the client to understand what their needs are, what their concerns are. You may have a client that just is, or a company that's just a little bit more risk adverse, or maybe you have somebody that likes to take some risk. They're like, I know that this is kind of a shady area, but we're going to risk it because that's who they are. So working with them to understand what their concerns are, what their profile looks like, right? I mean, are they being sued a lot? Do they have a broad litigation, or do they never get sued? Maybe they want to be a little bit more aggressive with their retention process because of how their litigation profile is. But it really is working with those clients to figure out what their concerns are and what the specific issues that they're facing. And then from there, you can actually develop a plan, a way to actually manage that information and govern that information that makes sense for that organization. Something that can make sure the right information is protected, make sure the right information is preserved, but also that the access to that information is still there, that employees still can do their job. There's really a balance between that legal side and the business need that needs to be balanced in order to have an information governance plan and approach that works and for everybody.
This is an area where, a couple points. One is, perfect's the enemy of the good. It's not going to be perfect. We want to get better. We want to ask the hard questions before somebody else does. It may not be all of the answers in the world, but we want to have considered these things. We want to have a response. We want to have a considered answer. We don't want to be blindsided when a regulator asks or opposing counsel, or frankly, when an issue comes up in a business deal. And then the second is, this is in support of the business when you think about this practice. There are some very specific regulatory requirements. If you ever need help on a record retention schedule, we can walk you through what those specific requirements are, but you go back to one of the earlier slides in the Arthur Anderson case, Supreme Court's pretty clear on this. You manage your stuff according to business need. Just don't be sketchy if you're under reasonable anticipation of litigation or a regulatory inquiry. I mean, that's the balance. You do what you need to do until you're in front of a court or a court gets to adjudicate what you did with your information. But that means it's in support of the business. What's going to make the most sense? We're not trying to stop your organization from doing what it needs to do. It's just, let's think about it carefully so that we can find good ways. One of the wonderful areas of this practice is it's not, for the most part, adversarial. It is collaborative. You're trying to work with that organization. These organizations are trying to benchmark with each other. The Slack paper came out of a lot of discussions within industry. And our client had come back and said, hey, I'm not the only one with these questions. I'm friends with these other GCs. We work together. We contract with each other. We work on projects in a collaborative space, some of which we have proprietary interests in, others that we don't. What can we do here? We don't have a firm standard. And these are these opportunities, then you benchmark enough, you can start to build what an industry standard is for this type of information, this type of collaboration. Understanding there's some very specific gatekeeping functions here, but for the most part, you have a lot of latitude. Let me go to I think we're almost to our last slide here.
Yeah, so these are some final considerations to take away, and we mentioned some of them, but again, this is a very collaborative approach with individual clients or companies, and it's going to vary by who's doing this. So the regulators, one company may be in a certain jurisdiction where they have a particularly zealous regulator. That's going to change how you're going to create that information governance program. Courts and e-discovery, we've talked about that a lot. I mean, what courts are you in? What sort of cases are you dealing with? All of those types of things are going to affect how you implement this information governance strategy. Of course, records and data management, that's a lot more of the practicality of what that information is doing. Do employees have access? Do the employees that need access have access? Do people who shouldn't have access not have access? And how do you keep that data safe, and how do you keep it correct, right? Keep it up to date. And then, finally, information governance. This is a great question, and we get this question a lot about, should I have a policy and just not follow it? How about you write me a really good policy, and then I'll sit on the shelf, or do I need to actually have a policy that I can actually implement? What's the answer?
There's a secondary question here, which is, well, if I have a policy I'm going to immediately be out of compliance with because I can't perfectly abide by it, should I still have that policy? This is not a debatable question. Yes, please have a policy. Because I, as your outside counsel, when the regulator asks me for your policy, I don't want to say, well, they didn't really think they could pull one off, so we don't have one. No, I want to point to the policy and then explain how your wrongdoer was outside of the policy that we really expect everybody else to comply with. why you have a cowboy. You can't have someone offer a reservation if there's no reservation to begin with. You got to give us some foundation, and that's what you can start to tie behavior to. And I want you to think about, like, this is an active process in litigation, in regulatory inquiry, in doing compliance work for your clients, even in just getting a sense of how information works and where that value lies. You want to go back to your clients or back to your company and start asking questions like, hey, do we use Twitter? Do we use Dropbox? Do we use Google Docs? Do we use Jira? Do we use GitHub? Do we use MailChimp? Do we use Trello? Do we use Stripe? Do we use Caboodle? And if they come back and say yes to all those, you'll say, well, I made that last one up, so it's impossible for you to use that service. We need to have a franker discussion. I stole that from John Oliver. You're welcome. So that's how you get in. You get in, you can try to be funny. They always appreciate when lawyers attempt that. But you're working toward those goals. You're starting that discussion. I think our last slide. So before we go, and I think we have 30 seconds, are there any questions from the audience? So Ben, you never told me. Do we have? Oh, someone just flinched. Okay, so Ben, do you use Slack right now?
No, I don't. I have it on my phone, though.
Okay.
I've played around with it a little bit, but I don't really have any teams right now that use it.
All right, so if anybody uses Slack out there and wants to add Ben,
please add me.
I'm already
I need
full up
friends.
because I'm that popular. But anyway, that's our presentation on Slack. Please do take a look at the article. If you have other questions, feel free to reach out, and we really appreciate your time.
Yeah, thank you.
Thank you again to all of our morning speakers. Thank you to James and Ben. Their article will actually be published in JOLT's upcoming issue 4, which will be related to the symposium. So thank you. We are about to break for lunch. Couple quick little updates. One, during your break, we encourage you to look up JOLT on Facebook, follow us on Twitter at Richmond JOLT. We also have a live stream of the symposium going on. So if you know of someone who's not here who would find this interesting, or if you're unable to be here for the afternoon, we encourage you to look at that. I have to put in a personal plug that I have family in Georgia and Delaware who are watching the live stream. So hello to you all. I'm sorry that we are not delivering lunch to you all, but we do have a great catered lunch here for everyone in the moot courtroom. Please help yourself to the box lunches that are outside. Bathrooms are down the hall to the left. When you see the library doors, turn to the right. If you indicated a dietary restriction on your registration, we have those lunches set aside for you by the coffee station. You can find a JOLT member who will have a name tag on. They'll help you with that. So enjoy your lunch. We will see you back in here around 12:50, 12:55. Thank you again. Excellent. How was lunch? Oh, good, good. We will have an afternoon break that'll also have some snacks and drinks, and then we encourage you to stay at the end for a dessert and coffee reception. I know a few more people are kind of trickling in, so we are very proud to be able to offer speakers who represent a wide variety of expertise in the area of technology. Part of today is about looking at the past and how the courts and the legal system has addressed social media, electronically stored information, looking at the present, how we can better adapt to today's world, and then also looking at the future. And with that in mind, our next speaker coming up is going to go into that. First, I'd like to recognize, you may see a logo around. JOLT has just started that, branded themselves, I guess, with a brand new logo, and we wanted to recognize Sarah Albestein for that. If we could give her a bit of a round of applause. So, it's very nice. We appreciate it. So on to our next speaker here. We went from putting foods in our mouth to now putting words in your mouth, the evidentiary impact of emerging voice editing software. Nick Mira is a cybersecurity attorney in the Woods Rogers office in Roanoke. He is also a former editor-in-chief of the JOLT Law Journal. I can speak personally that he was a wonderful mentor for the 1 year that I got to work under him. He also is a whitewater rafting guide, and so he's going to be guiding us through some emerging technologies today. And I'm also told that because he was an undergrad minor in Spanish, he can translate the entire presentation he's about to give into Spanish afterward. Is that
Only per request.
per request? We are very excited to have him back here presenting on a very unique topic that has big implications for the future of evidence. Please give a round of applause for Nick Mira.
Well, thank you, Eli. I really appreciate it, and thank you to JOLT for having me today. It really is a huge honor to come back full circle and have the opportunity to speak. I remember sitting in the jury box last year, and we were listening to a good panel of speakers, and I think you guys have assembled a great team this year, and I thank you guys for all of your effort, and appreciate you having me. So, we're talking today about voice, and I saw a video in 2016 that was very interesting, but also very concerning. And I'm going to show you that video later today because it's after lunch, the enviable after lunch spot where we all need to get our energy back up. So we're going to watch a clip that has Jordan Peele in it, if anyone's a fan. But so I saw this video clip, and it's about how we can now manipulate the human voice, kind of like Photoshop. So we had a few speakers discuss Photoshop earlier, and we took a dive on that. But later in this presentation, I'm going to explain why we should start looking to Photoshop for some answers for questions that are raised by this new technology. Okay, so why did I think this was so interesting? Our human voice is a fingerprint coming from our mouths, and whenever you talk, if someone's remotely familiar with you, they're going to know those are your words, right? That sounds really fundamental. And it wasn't hard to distinguish. We have different issues that arise in courts where people are trying to distinguish one voice from another, comparing, but by and large, it's a pretty unique identifier. And now it's kind of under fire, and I think the federal rules of evidence might need to update in order to reflect that. So evidence in this day and age can be manipulated very easily. As we know, not that we do that, but it can be. And sometimes we might have clients who are more willing to take liberties before it reaches our desk and make some adjustments to a photograph or maybe a financial statement. And as attorneys, it's very important for us to know what technologies are out there so we can identify some issues that may arise through the use of those technologies. So, as we discussed earlier, the advances in technology help the legal system a lot. Who uses a document management service for their files in a law firm? Keep it all organized by client and make it streamlined. That's something that was new to me in the legal practice, but has really helped me out. Photoshop is great for different applications, screenshots, but now we also have to recognize that the legal system is pretty slow to move when it comes to adapting to these new technologies. So, when looking at these new technologies, the courts have to examine whether they're going to provide novel forms of evidence or augment existing forms of evidence. And as I stated earlier, these changes don't happen quickly when we need to enact new rules or new guidance on each of these issues. So, for example, the federal rules of evidence were enacted. The medium to capture voice recordings was analog tape. And that was a lot more stable and easy to authenticate than digital recordings now. So current laws that govern the admissibility of evidence for voice recordings are based on the assumption that juries are capable of weighing the evidence and taking that into appropriate consideration. And we're going to dive into some of these rules in a little bit. I know we're all really excited about the federal rules of evidence. But with Voco, Adobe's project Voco is that voice technology software that we're going to watch a video from in just a minute. Juries would be unable to distinguish computer-generated speech from that natural voice of a real person. So when I saw this video, I thought, wow, there are some really horrible implications that could be applied to evidence. So I laid out 3 essential questions that I hope this presentation will help us answer as a group later. And we'll come back to these, and I might call on some people to see if we're paying attention. But it's really, if we can accomplish and answer these 3 questions, I will have gotten my point across today. I just want to raise awareness of this technology. It's not mainstream yet. Adobe has a suite of services that you can subscribe to, like any other software subscription, and I'm anticipating that this might be a part of that package one day. So without further ado, the three essential questions. One, how reliable is voice evidence as it is today, and how reliable it will be down the road? Two, how do the federal rules of evidence prevent modified voice recordings from being authenticated as evidence? And we're going to explore those challenges. And then three, how do the federal rules of evidence need to be amended to account for emerging voice editing software? So in order to understand where we're going, I wanted to take a quick look back at old technologies and how evidence is adapted to those. So Alexander Graham Bell, a little history fact, invented the telephone in 1874. Federal rules of evidence were effective, not enacted, they were effective in 1975 when the telephone was commonplace. So we got a 100-year span where the telephone was still the cutting-edge piece of technology, one of the cutting-edge pieces of technology that the federal rules of evidence were very focused on. Things are moving a little bit quicker now, as we heard today. There are a lot of new technologies coming out all the time and new ways that the courts and attorneys have to compensate for those new technologies. And we're going to look at the voice changer, which is a voice modulator. So if you ever had one of those toys, or you had a kid who had one of the toys where you talk into it and it makes you sound like Darth Vader or something like that, there are cases out there where criminals have used these, and through shifting pitch back to their natural frequency, the police were able to prove that it was, in fact, this person talking. And so with Voco, it's going to really change that, because it's not shifting pitch, it's changing the words that you said. So Photoshop, I think, is the most analogous, as I touched on earlier. Photoshop came out in the 90s and allows you to alter several different facets of a photograph to make, as actually someone showed earlier, the attorney who had all these pictures with famous and political individuals, those looked real. All of them looked real. And Voco does the same thing for the voice. So Project Voco is a software that enables the user to make a computer read back anything that the user types into it. But it's not Microsoft Sam typing words in and it just reading it in a robotic voice. It can read it back in the voice of any person that it has a voice sample on. So the way it works is, if I have a rough, right now it's about a 10-minute recording, voice recording of an individual, I can use that target's voice to read anything that I type into a computer. And the technology is getting better, and so I hope the wheels are starting to turn about what this could be used for, and we'll explore some of those. And I want to hear some ideas from you too. So feel free to reach out if you guys have questions at any point during this. Just shout them out. I'm open to it. We're going to talk about some examples, and we're going to talk about how sophisticated this is becoming even since this first debut video came out. So, Carl, if you could help out. Could you do full screen?
And I kiss my dogs and my wife.
Okay. So let's do something here. Okay. So suppose my cookie wants to send this over to his wife.
So this is the debut launch of the software.
To show before the box. So, okay, so what do we do? Easily copy, paste. Let's do it. Copy, paste. Oh, yeah, it's done. Let's listen to it.
And I kiss my wife and my wife.
Oops. Oops. Where are the dogs? Okay, how can we let the dogs out? It's actually easy. We can just type the word dog here.
And I kiss my wife and my dogs.
Wait, here's more. We have to type something that's not here. So, I heard that actually the other day, Michael actually kissed our children. So, to recover the truth, let's do it. So let's remove the word my here.
Your secret's out.
And just type the word Jordan.
Ooh.
And here we go.
And I kissed Jordan and my dogs.
Well,
You a witch. You a demon.
oh yeah, black magic. And the last magic I'm going to show you guys is we're not just going to do with words, we can actually type small phrases. So let's say, okay, we'll remove those words and we do 3 times. And lay back.
And I kissed Jordan 3 times.
Okay, so we have already done much for photo. We have already removed the live photo editing. Now it's time for us to do the audio stuff. Okay, how's my photo?
That's good, thank you. So the video shows it a lot better than I can explain it. And since this video came out in 2016, there have been a lot of new developments with the software. So let's think about this in a legal context. Imagine you are in a deposition and you have a voice recording exhibit and your client says, no, I never moved those funds. And then you have a phone call of the opposing counsel has a phone call of your client saying, yeah, I put it in this account. That's pretty damaging evidence. It's really easy to get voice recording evidence into the record as it stands, and I think there needs to be a change. So, as we said, the federal rules of evidence were enacted when it was very difficult to manipulate voice recordings. So, tape recordings were cutting and splicing and reintroducing different mechanical methods of manipulating the voice evidence, but now it's digitized. So Rule 901B5 says, an ear witness may testify to their opinion identifying a person's voice, whether heard firsthand or through mechanical or electronic transmission or recording, based on hearing the voice at any time under circumstances that connect it with the alleged speaker. So after today, any of you could testify saying, there's a voice recording, that's Nick's voice, I heard him speak at the JOLT Symposium, and it'd be admitted and the jury would have to weigh the evidence. And with VOCO, we all know now that that could change, and that might not be a true, authentic copy of something that I said, but it's going to be really hard to refute that if everyone in this room says that's Nick's voice. That was it, if we don't have an awareness of this technology. So Rule 104B, one of our favorites, when the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. The court may admit the proposed evidence on the condition that the proof be introduced later. The standard in this rule is the provision of evidence that could support a finding. So that's how we get these voice recordings in easily. We introduce them, we have people verify, and in motion eliminate any other circumstance. These things can come in. So let's talk about a scenario. An ear witness testifies that a particular voice recording is indeed the voice of a specific individual. The jury has the responsibility of giving weight to this ear witness's claim. So how does VOCO technology affect the weight of this ear witness testimony? If juries don't know about this, how are they going to weigh the authenticity of this evidence? And it's not mainstream now, but we're looking forward. Can a sample VOCO recording slip in as evidence? Do we think Photoshop photos have ever been introduced into evidence? I read an article where they said it's appropriate for attorneys to use Photoshop or employ someone to use Photoshop to emphasize certain portions of a photograph, but obviously manipulating it and putting a great white shark in the back of the picture is probably not a good idea in your personal injury case. So, and the immediate concern is currently, as we stated, the technology is not mainstream, but it's really on the edge of being introduced. So, we could use, or a dishonest opponent may use VOCO to blindside someone with a smoking gun. So without awareness of the technology, how are you going to rationalize that someone has a recording of you saying something that you never said? And that's the whole point of this conversation, is to bring awareness. So some exemplary court decisions that would have been modified with VOCO if applied. So in the United States v. Dionisio, the Supreme Court held that no person can have a reasonable expectation that others will not know the sound of his voice, any more than he can reasonably expect that his face will be a mystery to the world. That's why voice evidence is so easy to get in. And in this case, they ruled this because it shows that they can compel someone to provide a voice sample. If we have the recording, you refute the recording, but they can compel you to provide the sample. You're just out of luck. So in a grand jury, the voice of the defendant is replicated using VOCO and made to admit the relevant subject. Court compels the voice sample and is matched up. United States v. Basie. Identification of the defendant by one individual was sufficient to establish that the defendant was the voice on a recording. So this shows that it doesn't take a lot to get this admitted. And I know we're iterating these things, but that's why it's so important. This technology is going to change evidence that you can get into court with the very lowest threshold of admissibility. This is Ninth Circuit. And this was when someone was throwing their voice as an alias. This was a telephone conversation, and they never met the person in real life, but they were still able to testify that that was the individual who was speaking. So looking into Photoshop as an analogous technology, Photoshop enables the manipulation of photographs. VOCO is used for voice. It's very analogous. It's just what form of editing we're looking at. In order to predict how VOCO will be addressed by courts, I thought it was insightful to take a look at how they handled Photoshop. Photographs, to be admitted, need to, 1, be relevant, and 2, authentic. And then to prove these factors, it is sufficient to prove authenticity and relevance by saying, if you have an eyewitness say that's an accurate depiction of the scene, it can come in, right? And it's a low threshold, and that's why Photoshop was such a concern for the courts too. In an effort to combat tampering, there's an emerging practice where people analyze metadata, and metadata is just, it can be a small set of data where it shows the modification history, the changes made to these different photographs, and just various edits that were made. And it's kind of a historical log of who was accessing this file, what they were doing, but metadata has its flaws. 1, it's easy to wipe. It's very simple. Some law firms use metadata cleaning tools before they send attachments and emails. It's very widely available. And if we have so much metadata attached to every photograph that needs to be analyzed, soon we're going to touch on this in a minute, we're going to be bringing expert witnesses in to testify as to this metadata where we didn't need one previously. And the same thing might happen with voice recordings if this hits the mainstream. So what's the penalty for modifications? It would probably fall under the veil of false declarations under 18 U.S.C. 1623. The modifications to the photograph are being falsely represented as true. So what's the penalty for that? Fine and up to 5 years of imprisonment, right? You know, like I said before, attorneys are most likely not promulgating this, but if your client is facing 30 years of imprisonment versus 5 years of imprisonment if they get caught for this on top of it, it might be a risk someone's willing to take, and that's why we need to be aware of it. And because photographic alteration techniques are so covert, the risk of detection is substantially outweighed by the reward, like we just described. So how should the courts handle VOCO since they're not equipped right now? So I posit 3 separate alternatives. 1, the law stays exactly the same. 2, the law could require a metadata expert to testify as to the metadata for all photographs, which would back up the docket even more. Or 3, we could adopt a threshold standard, which I think is the better alternative. And this threshold would be implicated after a triggering event, and that's when we could bring an expert in. So, as we discussed throughout this entire presentation, the rules aren't equipped to handle a technology like this, and that's why we need to raise this awareness. The second alternative is if we require a metadata expert for every piece of voice evidence, the courts are going to become clogged up. And the time frame of litigation would increase, and the cost associated is already a very expensive process. I don't think it would be appropriate to have someone come testify for metadata of every piece of electronic evidence moving forward. So instead, if we propose a threshold standard, where if you could show that there was plausible evidence of tampering with the evidence, that an expert would be required to testify regarding the metadata of a voice recording. And if as we mentioned, the metadata will describe who edited the software, or the file, what changes were made to it, and when those occurred. So it would be probative of anything that affected the file. So after the expert testifies, then this is admitted, and the jury can weigh it more appropriately now that they have someone who has a stronger basis for determining whether this file is legitimate or not. So in conclusion, the current status, we're not equipped. Next steps, we need to become more aware that VOCO and similar technologies exist, are emerging, and are evolving to become even more realistic in our daily lives. The federal rules of evidence should be amended to account for the proliferation of this new technology, but as we stated, it's pretty slow. So revisiting the essential questions. Does anyone want to take a stab at how reliable voice evidence is as it stands before this technology comes out? It's pretty reliable right now. People can make changes, shift pitch, and do different things, but with VOCO, you can take each syllable and augment individual phonemes to make it sound exactly like a person. That was a very basic demonstration on the video, but they can take every single syllable and shift it 9 or 10 different ways to find the most natural sounding for your voice and make it very fluid and cohesive. How do the federal rules of evidence prevent modified voice recordings from being authenticated as evidence? As of right now, they don't. And then third, how do the federal rules of evidence need to be amended to account for emerging technologies that alter vocal recordings? I propose that we should adopt a threshold standard where we have an expert witness come and testify when appropriate. So all citations are contained in the JOLT article, and it's available online. All JOLT articles are available online. But then I want to start a dialogue about other forms of evidence that you think need to be addressed that the federal rules of evidence are not equipped for. Does anyone want to volunteer to talk about what they think is another problem that we're not ready to handle? Besides Slack? Yes?
So this isn't really addressing that, but
Yeah.
I've got a question.
Sure.
On your proposed rule. Who would the burden shift to of hiring the expert in a case where somebody may have tampered with evidence?
I think that's a very interesting question. I think if you're able to prove plausibility of tampering, that it would shift the burden to the person who would have tampered. But that's definitely something that you would need to look at more closely based on the trend of cases. Do you have an opinion on that?
It seems like both parties would probably want to.
Yeah.
One side's going to be required to do it, but it's the party that is wanting to fake the evidence, and you may want to independently verify, but just didn't know if there might be, maybe you have it funded by the court and the parties split the cost or something of the sort, because experts typically are not very cheap.
No, exactly. And that's one of the concerns is where would that cost be shifted to? And I personally believe that if you're able to prove a reasonable level that there could have been tampering, something plausible, that the other party should be fronting that, but obviously they're going to disagree and want to shift it. So that's something we'll have to distinguish moving forward. Any other questions? Yes?
You talked about photos and voice. You didn't really talk about video.
Yep.
I mean, video technology is getting a lot better too. That'd be something that should be lumped in with the other two.
Yeah, it's very similar, actually. I'm glad you brought that up. So Final Cut is another software that makes video editing very easy. I believe that the standard is currently similar to photographs. If someone sees a video of a bank robbery and someone was at the bank robbery, they say that's the scene as it was depicted. This is authentic because XYZ, and it is relevant to this case, it still comes in. So all of these technologies, as the editing softwares get better and more advanced and more natural looking, we're going to be confronted with this. And then video presents another really interesting facet too because of CGI, computer-generated video, and we can look at the progression from films, back in the 90s or the 70s with Star Wars and everything, moving forward to now, it's indistinguishable, some of these characters. So it doesn't come up a lot. CGI is extremely expensive, whereas Photoshop and Voca would likely be very cheap and easily accessible. And it doesn't take a strong, you saw how easy, you just delete it and type something out. I think that's where it's distinguished. What's that?
It is now.
What is?
It's expensive now.
Oh, absolutely. Yeah, no, there will definitely be progressions where CGI is just super simple. I mean, if you think about augmented reality on your phone, there are different programs that make it simpler, but to put someone in, I agree. I think it will be much more accessible in the near future. Any other questions about the new software or any new other technologies that might pose problems? Yep.
Have you seen any studies that pose a question for what the changing in harms for those who would utilize Voca? Anything from, we talked about the idea of it for admission of evidence, but would it shift at all the considerations for the type of charges or whatnot for, say, a person who's using it to deceive someone or obtain information? Is there any?
I think there's definitely an argument to be made that, there's probably something in the sentencing guidelines in a criminal context that you could apply to this case. But largely, it'd most likely be an additional charge, if you will. Any other questions? I know we're wrapping up a bit early, so and if you guys are good, I appreciate your time, and I hope we can all remember that this is going to be floating out there very soon, and hopefully it doesn't leach too much into our field. So thank you.
Yeah, thank you. It's very fast. And as Nick mentioned, his article can be found in the first issue of this past year of JOLT. We have it online as well. I believe we are a little bit early. However, we will go ahead and take our break now. The coffee and drinks may be a few more minutes, but we will break and come back in, let's say, 15 minutes, and we'll push things up that way since Kelly's here next. So again, thank you.
Sticking around, we're gonna get this show back on the road. So earlier you heard a lot of different things that technology can do with the appropriate control, and it's not always that great. But our next speaker is going to talk about how people use technology for, say, cyber attacks, cyber security concerns. My name is James Williams. I'm one of the co-editors of the symposium alongside with Eli. I feel like I should introduce myself just briefly, but I'll be introducing Miss Jackson Higgins. So Kelly Jackson Higgins is the executive editor at darkreading.com, and they cover a wide variety of issues, but some of the more relevant to today's conversation are cybersecurity, topics and trends, and then some of the more recent cyber attacks and campaigns. And just as a little cherry on the top, she's also been noted recently as one of the top 10 cybersecurity journalists in the US. So without any further ado, Miss Kelly Jackson Higgins.
About right, Mike? Okay, good. So as you can imagine, I'm a little bit different speaker for you today. First of all, I'm not a lawyer, but I want to tell you who I am first and a little bit about what I'm not. So just to kind of set the stage a little bit. So I'm a cybersecurity journalist. I've been in this industry for at least 20 years, covering this particular sector. Prior to that, I was in the IT journalism space. So I was covering like networking and internet stuff. And basically, before that, the most important part of my resume was I was a sports writer, which has absolutely nothing to do with why I'm here today. But that was my first dream. It didn't all work out, but it was a good exam. It was a good start. So as executive editor of Dark Reading, I run the whole news operations. That means I'm assigning reporter stories, I'm deciding what we should be writing about, thinking big story ideas. I also edit pieces, and I also write I'm also still stay in the reporting side of things, not as much as I used to, but I still write 2 or 3 times a week. We're a daily, so that sounds like a lot, but it's really, when you're used to being a daily, it's sometimes 5 times a week. So what I'm not, besides a lawyer, is a cybersecurity consultant, technician, or a hacker. So you're not going to get that from me. What you're going to get from me is the perspective of what we report on, the people we talk to, who are cybersecurity technicians, hackers, good and bad, people out in the industry and also on the business side who are being affected by these threats. So our job is to kind of bring that together and keep our readers updated on what the trends are, what the threats are, what they can do about it, and sometimes who's behind them, which is not always the easiest part of it. So what I'm going to talk about today, I don't want to make this too technical, but I want to make it too high level where it's kind of not helpful to you. So what I'm trying to do is give you a good sense of what the major forms of cyber threats are today facing the legal sector, how they work, who they are, who the attackers might be behind it, what their motivation is, and also kind of some real world examples of law firms that were attacked and what happened to them, so you can kind of get some views of what's happening. More importantly, I'm going to provide some best practices for you and yourselves personally in your firms. Now, I'm not a consultant, so don't, I can't give you all the go get this product, go get that product, but I can give you what we consider the key things you should be doing to protect yourselves and your firm. I want to leave some time at the end for a Q&A. First of all, as a journalist, I'm used to asking the questions, so it's weird for me to have questions asked of me, but you can ask me questions. But I also would like to ask you some questions if you are willing to sort of share some of your experiences, because like I said, we talk to people who are doing incident response at law firms or who help secure them, but it's always helpful to me to get real world experience conversations. So I want to hopefully be able to do that with you a little bit at the end. So I'm not going to talk super long because I want to leave that open. So if you have things you want to share or share with each other, sometimes talking to your colleagues in an industry about something you're experiencing, you learn a lot from them. We try to do a lot of our conferences that we do at Dark Reading. So I should probably tell you a little bit about Dark Reading. Forgot to do my slide. Okay, so we are considered one of the most widely read cybersecurity news sites. We've been online since day one, so 13 years. We started in May, 13 years ago. We get about 1 million page views per month as our high. In 2016, Apollo Research did a study, and Chief Information Security Officers ranked us #1 among the publications that they read. So that was, to us, really important because you don't always know how you're doing with actual practitioners. You hope that people are relying on your stuff. So that was great. We have 6 full-time editors. When I say editors, I mean writers and editors. There's really only 3 of us who write full-time, and I guess I'm kind of more part-time writing. And then we have a few contributors, and we also have a whole section of commentary pieces that we take from experts in the industry who want to talk about things. So we have that whole part too. So we have a pretty wide base of contributors and voices on the site, which we really like to have. And that's our website up there, and it's very secure, by the way. We're part of a company called UBM, which was recently purchased by a company called Informa, and they're massive events and editorial properties, and so they're out of London. But we're like one little piece of their puzzle, but we're a pretty strategic one because cybersecurity is such a hot topic right now. So our content sometimes lands on Information Week, if you're familiar with that, a network computing magazine site. We're a sister brand of 2 really big security conferences, well, Black Hat, which is one of the biggest ones, and then Interop, which is more of an IT, but it has security elements in it. We do a cybersecurity crash course there for people who are trying to learn more about security in their organizations, if they're IT people who kind of starting to bleed into the security stuff. So anyway, that's kind of who we are, to give you some context. And so real truthful answer, has anybody ever looked at Dark Reading or read it before? Just raise your hand. I won't be offended if you haven't. So, okay, I've got a couple. All right, well, maybe a few more will now. So I wanted to share with you, we do a bunch of surveys, but this is one of our kind of more comprehensive ones. It's a strategic security survey. We basically do an online survey of, this time it was 300 IT and cybersecurity professionals. in North America. And this is going to give you a little context about what's happening out across the board, not just in legal. I'll come to legal stuff too. But so we wanted to talk to them about their challenges, their plans, their directions, and basically their firsthand experiences with security breaches and data breaches and kind of what they're worried about, what they're doing about it. Just a couple notable findings to kind of set the tone here, because this theme's going to come across a lot. One of them is users. 48% of them thought that end user awareness training was one of the most important and valuable security practices. So keep that in mind, because that's going to be a theme throughout here a lot is about users, and that's a really important to a lot of organizations are actually training now. And 69% have password policies, which is a good thing, and 67% have invested in end user awareness training. So that was just a little snapshot. I'll show you a couple slides from it. Hopefully they came out okay on the big screen. It's a little. I'll give you the highlights. So basically, we asked them what types of security breaches that they had in the past year, and 54% of them suffered a malware infection. That's not surprising. There were probably a lot more that didn't know they had been, but that led to an incident of some sort. So it wasn't just that their antivirus scanned it; it's actually that the malware got in. So that's pretty significant. 48% had a phishing attack that led to an actual security breach. And interestingly, you probably heard of ransomware. How many people have heard of ransomware? Like, we're going to talk about that today too. Good. So only about 16% were hit with ransomware, and 16% with a targeted attack, which is one that's literally pointed at your company or your organization specifically, not just random, big swath of let's kick out some emails and see who clicks on things. An actual targeted attack. So that's about the right amount we see too. So another data point was interesting. Oops, did I get? Oh, I went back. Sorry. Okay, so then we also asked them, if your organization was going to be hit with a major breach in the next year, what do you think would be the most likely cause or core cause of it? And number one, by far, were those pesky users. And it's not always millennials, it could be all ages of users. 61% of them said that user negligence or mistake was going to lead to a breach. And that is very common, because it doesn't take much to make a little mistake. You know how everyone's done it. You've clicked on the wrong thing in an email or accidentally forwarded something. Think about if you clicked on malware accidentally. So kind of next up, and not nearly as prevalent, was on this more sophisticated malware that we write about a lot of dark reading. It's not as common, but it tends to always go back to those mistakes that people make or things they fall for are usually the most likely. Social engineering is an interesting category, because that kind of does overlap with phishing, because it's sort of getting a user to do something, but this could be some other way to get lure a user into clicking on something. We didn't break this down by industry, unfortunately, so I can't tell you what the legal sector said, but I wanted to kind of give you a big picture first before we jump into the other part. So, I keep looking down, I have a copy of this up here, sorry. So I wanted to just kind of basically go through what we see are the most common cyber threats facing the legal sector. And these are conversations I have with incident responders who go in and clean up after a breach or help a company after they've been attacked, and other researchers who are finding a big attack campaign. They say, oh, this law firm got hit, or this is what people are doing now. So this kind of gives you a sense of what the threats are. So cybercrime, which could be ransomware, phishing, we'll talk about these in detail in a minute, but phishing, ransomware, BEC scams. Cyber espionage, which is a little more rare, but it's still just as devastating. This could be just pure spying type things by nation states, trying to get information about you or your clients. Strategic attacks, which are kind of similar, but it's more that the attackers are going to the law firm to get to one of their clients or one of their business partners, sort of like a stepping stone kind of attack. And that's not unusual in the big picture of attacks anyway. That happens a lot. A lot of times the lower level suppliers are attacked to get to the bigger fish. So that's very common. A lot of attackers will go that way. If you think about the Target breach a few years ago, they breached their HVAC company first. So it was a sort of stepping stone type attack. That's very common. So cybercrime is really what it sounds like. It's basically online attacks for crime. It's a really anonymous way in most cases for bad guys to make money. Interestingly, a lot of cybercrime attacks are kind of random, so they're more attacks of opportunity rather than we're going to focus on stealing money from this company. It's basically they're throwing out a big net with a bunch of lures and seeing what they get back in a lot of cases. It's easy, anonymous. If you are a cyber criminal who lives in Russia, for example, even if the US indicts you, Nothing's going to happen unless you leave the country. It has happened when they've gone to the beach in Spain or the Caribbean. We've had some arrests there. But for the most part, you're free, scot-free. You can get away with just hacking away and stealing money. It's not hard to do. Cyber criminals are using malware, malicious software code. They're also using social engineering, also with phishing, where they're using a message to get you to click on something or make you think it's something that it's not. They're taking stolen credentials from a user of your organization, and they're oftentimes taking advantage of users who reuse passwords, and we'll talk a little bit about that more too. But that's just to give you an overview of that. So everyone's favorite topic is ransomware, and I'm going to put you a little bit on the spot. Has anybody actually experienced ransomware firsthand? Just raise your hand. You don't have to tell me details. There's a couple. Okay. No. Has anybody paid for ransom attacks? No. Okay. Good. Don't want to do that. That's good. Okay, so basically ransomware, if you don't know what it is, it's just a type of malware, but what it does differently is it locks you out of your data and your files. And then you get this little cute note that's actually a ransom demand for payment, and it's usually in cryptocurrency for obvious reasons. It's an anonymous way to pay. There's no way to track it. Bitcoin was very popular. Now they're using different types. So really, it used to be one of the more lucrative ways to do things. We'll talk about that in a minute too. But so basically, it usually comes through a phishing email. So you get an email, one of your users gets an email, and they think it's from someone they know, and they click on it, and they've got the malware on their system, and suddenly it locks up your server. It takes their credentials, gets to the server, locks up your server. You get the pop-up note, boom, you're out of your systems. Or in some cases, they may already have stolen credentials from a user, and then they can come in through, I don't know how many of you use remote desktop protocol, which is like log me in, things like that in your organization, where the IT people can log into your machine to check something or update something. Those ports can be abused, and that's sometimes the ransomware attacks will come in that way. They can also come in through Citrix virtual machine if it's not properly locked down. So basically, if any ports get left open that you don't know about, they can get in. Even a virtual private network, which everyone thinks is, I swear by VPNs, but if your VPN doesn't have two-factor authentication, or if someone gets your credentials, that's a problem. So they can also get in that way. So ransomware, basically, the kits themselves are super cheap. Like some are free, some are only $250. You can get them in the dark web. It's basically just deploy, point and shoot. It's really easy. You don't have to be smart. You don't have to be a hacker. Then you get your Bitcoin and payment, cryptocurrency payment. So in 2017, the average demand for ransomware was $522. And that's actually down. In 2016, it was $1,070. That was the average. We'll talk a little bit more about how ransomware has dipped a little bit. But there were some companies that even admit to just sort of planning to be hit with ransomware. So there's another study I saw, this wasn't ours, Code 42 did it. They talked to companies and asked them, CEOs and executives, do you stockpile cryptocurrency? And 60% of them said they do. So they actually get their accounts and they stockpile it just in case. And of that group, 8 in 10 had actually paid the ransom. So a little bit of a catch-22 there. In general, the best practice is don't pay, and we'll talk more about that as well. But I thought that was kind of interesting. So even though I'm doing a lot here on ransomware, because I'll tell you in a minute why, but ransomware has actually dropped a lot this last year. 91%, as a matter of fact, in 2018, it declined. And part of that is because the attackers started going after just really specific, more lucrative targets. They figured out who had the money, they got more targeted than the random way they used to do it. And the second big reason was crypto mining and cryptojacking. Has anybody heard of that? Crypto mining, cryptojacking? Okay, so that's when the bad guys basically illegally use your processor power of your machine to mine cryptocurrency. So that became the new way for cyber criminals to make money. It was a lot more anonymous, a lot easier, less messy. You don't have to worry about the whole payment part. And they could just keep mining cryptocurrency. So cryptocurrency mining went up 237% last year. I mean, that's huge. And that's one of the things you don't always notice anyway, right? You might notice your machine's a little slow. A lot of times they do it at night after hours. You don't know that they're using your machine. So that was a more tricky one that a lot of companies had to deal with this past year. So basically, they're dropping malware on the victim's machine and using their processor. And so that was the big one last year. And ransomware historically was a consumer problem. I don't know if you remember, I think it was like 8 years ago. This industry, everything moves so quickly. I have a hard time with my time frame sometimes, but there was back in the day where people would get these weird FBI morning emails, you're in trouble because we saw this and you have to send money or you're gonna get in trouble. So those were the early days of ransomware, and then it sort of evolved into going after bigger targets. They'd throw it out there and then they would get a hospital. I'm sure you've heard of hospitals that were attacked. We had up at Georgetown, University Hospital was attacked, and some others. So the targets got a little bigger as they got a little more sophisticated with it. So right now, I would say enterprises are still the majority of the attack, but they're still a smaller percentage overall of ransomware attacks, but they're just more lucrative ones. And one of the areas that they're targeting is the legal sector. 81% of ransomware attacks now are just businesses, including law firms. And they're also using email more now than in the past. I mean, they did send those weird emails to consumers, but then they started just throwing malware around and on websites and other things, and then they just really went more targeted with it a little bit more. Probably the most interesting real-world example of a law firm getting hit was 2017. Did anybody hear of the DLA Piper attack? A pretty big law firm. So they got hit with this interesting form of ransomware that turned out to really not be ransomware, but pretended to be ransomware, called NotPetya, that has been identified as a Russian state operation. They were kind of swept up in this whole attack that happened against a Ukrainian target. Sometimes you get collateral damage, is what the theory of what happened. So they basically had hit this attack where they were down for, oh my gosh, I want to say, they were down for like 13 days total. They had their email was down, they had their servers weren't accessible, they lost their document system, everything was just offline. And it came up with a little, ransom note, but the ransom note didn't mean anything. If you tried to pay it, it didn't even work. So it was really just a fake ransomware. It was actually a data destruction attack. They tried to blow up their data, basically. I never heard the final word of what happened. I think they were very quiet about what happened. They did restore, I don't know how much data they actually lost, but it was kind of scary. Kind of like what happened to Sony. It was the same idea. It was like all about just destruction and mayhem. So that was probably one of the more interesting, I would say, significant ransomware attacks that the legal sector faced. And just to give you some perspective from our survey on that, so you can see how the ransomware decline happened pretty quickly, relatively overall between 2017 and 2018. A fourth of the respondents in 2017 said they had been hit with ransomware, and then in 2018, only 12%. So it really did drop pretty significantly. Again, a lot of these attacks right now are just getting more money too. They're more lucrative ones. And then, the good news is most people don't pay the ransom. There was a little confusion. I think it was 3 years ago, there was a conference, and an FBI guy was on the panel, and he actually said, I really got in trouble later, I'm sure, that you should pay the ransom. That's probably a good idea. And it got, the FBI officially said, no, we never say that. And there are some people who would tell you, well, there's some cases where you have to pay the ransom. But really the best practice is don't, because, and hopefully you won't have to, in other words, so really try not to. And really the reason why probably now most people aren't having to do that is they're getting better at one of the key things to protect yourself from ransomware is a really good backup. And that means an offline backup, not one that's attached to your network that also gets infected. That's happened. People have had their backups, they're like, oh, we've got backups. And they're like, oh no, the backup servers are also locked in. So you wanna have offline backups. Ideally you have a backup on site and then one off site. And that's one way you'll restore. You don't have to worry about if you get hit with ransomware, you can bring it all back after you get cleaned up. So that's one of the reasons I think too that people got better at it and the bad guys are like, okay, we gotta try something else. So that's usually what they do. So phishing, I think everybody kind of knows what phishing is, right? But I'll just give you a quick explanation. So it's really just a malicious email that comes to someone. It tries to get you to click on either an attachment, a Word file, Excel spreadsheet, a URL that's in the actual email. And of course, if you click on it, you're infected. It's a kind of a form of social engineering. Usually it's kind of convincing in some way. It's something you think you'd be interested in, or they think you're interested in, and you just fall for it. It's always pretty much the first step of almost every cyber attack is a phishing email. By statistics, that's pretty much even the nation states come in that way a lot of times. That's usually the very common first step. Then there's the BEC attack, which is the business email compromise. That one is kind of a more sophisticated phishing attack. They have to do a little bit of intel before they actually send the email. They have to know maybe a name of a partner in your firm or one of your business partners' names or something about what your invoices might look like. The whole idea is to get you to transfer money. And it sounds, oh, who's going to do that? But it happens a lot. And I'll show you the data in a minute. It happens a real lot. So as you see up here. So they use like phony invoices. It's usually from your boss or someone that you report to, and there's always a sense of urgency with it. So it gives people very little time to figure, was that really for my boss, and why is he asking me to do that? But you know, most people want to help, and they want to do what their boss asks them or their superior, and everyone wants to be helpful, and it kind of plays on that a little bit. So it's a pretty effective one. It's actually really one of the biggest ones now. It started out, interestingly, if you've heard of the Nigerian scams from a few years ago, it was evolved from that. Interestingly, all the people who were in the Nigerian scams got more sophisticated with this, and now they're kind of international organizations. I was in London in December at Black Hat Europe, and there was a big bust of a group called London Blue, which was a big BEC group that originally had been like a Nigerian scammer group, but they just got international. And these guys were living the large in London and pretty blatantly about it, and because it's hard to get caught, but they did eventually get some intel on them because they tried to BEC scam, not realizing an email security firm who right away played along with them. And that's how they unmasked them, which was kind of a cool story. So that, you know, they throw these things out there hoping they're going to get somebody, and they didn't realize that they hit the email security firm. So that was kind of interesting. So they were, when I left London, they were getting ready to, I don't know if they actually arrested the guys, but they had identified them, where they lived. So at some point, the authorities were coming knocking. I wasn't there when that happened. But so anyway, the BEC scams basically in the US went up 136% from December 2016 to May of 2018. The US had something like 41,000 incidents, and we're talking like billions of dollars in losses. This was like almost $3 billion in losses because people do, you know, they basically wire the money. They think they were really supposed to do it. Sometimes these attackers will be super good about their intel gathering. They'll actually get in your system, or they'll just do open source stuff, like look online and see, you know, who are the people at this company. It doesn't take much. Just look on your website, who's the financial person, use their names, spoof their email address. And sometimes they'll even get a look at what your real invoices look like, if they can get in your organization to really like make it look legit. So it's definitely really sophisticated in some ways, but in some ways it's not when you think about it. But the money ends up going obviously to their account. You're given this account to wire to, and it's somewhere typically, I think it's China is one of the main locations for where they tend to, I think it's China and the UK, and China and Hong Kong are the two main areas of where the money typically gets sent to these banks. So it's definitely a thing to watch out for. I was going to tell you about one other one. I think I'll skip to that because there's, yes?
If you know that they're already in your system gathering information for a phishing attack, is there a way of protecting that and blocking?
There are ways, and a lot of companies don't have the right tools to do that, but there are ways to have where you can watch for unusual behavior in your system, where maybe a user is doing something because usually they're using someone else's credentials to get around to the system. So there are products and services out there that help you determine whether, you know, Joe in accounting is suddenly doing something. Joe in accounting doesn't usually, why is he accessing that? Like, you know, you can see them doing something different. So there are ways to like have red flag things pop up where you could catch it. But sometimes people don't have that technology. You know, smaller firms probably don't, right? And nonprofits probably don't. And sometimes they kind of masquerade as the user. They kind of watch. If they're really good, they'll know how to kind of like blend in. So.
I recently got an email which I didn't click on, but it was telling me that it was providing information for a seminar that I registered for.
Yeah, that's a common one. If they see the industry you're in, they know how to kind of get your interests that way. Yep. Did you click on it?
No, I didn't click on it.
Good.
I don't know how to get them on the system if they're in the system.
Yeah, I mean, you would need to have a security person help you out on that one. And there are ways to kind of watch for behaviors that are, now if they're emailing from outside, that's a different story. You could block that email address if you knew it was not a legit one. But if they actually have someone's email address, so if they compromise someone in your organization, that's something you want to obviously take care of right away. Yeah. Sometimes they'll just spoof and make it look like it's from your organization or someone's personal. Like one of the ones I know of that happened recently, it looked like the boss's home Gmail address. So that's why the person, their subordinate went with it. Oh, well, he's working from home, so he wants me to do that, so I'll do it. And there's always this deadline, we need this done right away, so you don't have time to ask questions. I'm sorry, did I jump? No, I did good. Okay, sorry. So I want to give an example, just to give you a real-world example of sort of the threatscape a little bit. So there was a study done by a cybersecurity firm in the UK called Repnite. They decided to kind of look in the dark web, which there's a lot of organizations out there now that have threat intelligence services where they actually do just study what's happening in the dark web, and that's where all the bad guys hang out and all the bad things happen. That's a whole other story. And that's also where malware is traded, stolen credentials are traded. So they basically looked around and they found more than 1 million user credentials from the top law firms in the UK. And there were 2,000 emails per firm on average. The largest firm had like 30,000 exposed emails. But the good news was, the relatively good news was, most of the credentials weren't stolen from those law firms specifically. They were actually from third-party breaches, which is another element that people forget about. So these were from breaches that say, I think one of them was like LinkedIn and Dropbox. So this was a situation where your users are using their corporate email address on another account. Okay, and those were dumped into the dark web to be resold or stolen or used. And sometimes their passwords were. And in that case, this whole password reuse thing that people still want to do is really dangerous, because if you had your same password that you used at the firm and then used it for your Dropbox and it was found in the dark web, they've got your credentials to the law firm. So that's a really popular thing they try to do now, is find those credentials and try them on other sites. So it didn't mean that these firms were actually hacked, in other words, but that they were still at risk. There's something called credential stuffing attacks. Have you ever heard of that? It's the same, what I'm just saying, it's sort of the same idea. So they're gathering a bunch of stolen credentials and they're basically just taking them and throwing them at different sites to see where they work. Because they know, oh, I bet this has been reused somewhere else. And they find out that it is. So that's a really common attack right now. There's just one this week we wrote about, I'm blanking which company it was. Sadly, there happens so much, I can't remember which one it was. This is very common, quick way to get in. So you want your users, in other words, to not be reusing their passwords. So cyber espionage is pretty much what it sounds like. It's basically nation-state hacking groups doing spying, but online. I mean, we have our acceptable levels of spying, obviously, in our country, too. We do it, too. But there's some lines that have been crossed by some nations at times. China is probably the most active, and they're known mostly for intellectual property theft. And that's a well-known conversation here in the US, obviously, policy-wise. And then Russia, as we know, has done some things of more destructive kind of things, in North Korea as well, with the Sony attack and then the recent attacks they did on the SWIFT banking system, and that was a moneymaker for them. Iran's also an up-and-coming nation state going after, there was a few years ago, they did big DDoS attacks against a bunch of US banks. It was more of a disruptive attack, but all these nations are looking for ways to get information, and when I'm talking right now just the whole pure spy part of it, there's also sometimes a money-making part. In North Korea, that's how they get money when they're being cut off funds from everyone in the rest of the world. That's how they make their money, is with hacking. So they kind of do their attacks similarly that cyber criminals do. It's really just the same thing in most cases. It's stolen credentials, it's phishing emails, sometimes water holding attacks, which is similar to what this gentleman you were just talking about, a conference that you went to. So sometimes with water holding attacks, that's when they try to seed a website, say they were looking for some information on our diplomacy, the US diplomacy discussions with China. So they would go to an NGO's website that's specialized in China and just seed some malware on there and hope they get somebody who knows something logging in there. So they try to get people in that sector. So that's a spying way. It's not as popular now as phishing, but it's still being used. More people know about it now, so it's a little bit less effective. So in the case of the legal sector, you guys have some really valuable email systems. Obviously, you have to keep everything, right? You have your document management systems, and you have information, sensitive information on your clients, on intel on maybe their business deals they're doing, mergers and acquisitions they're doing. So you have some valuable information, and maybe even some of your own intellectual property of things that you're doing. So you're definitely a target too. Everybody is. So keep that in mind. We'll give some examples, and here's one. So this one just got revealed like a few weeks ago. So they had these funny naming conventions for the nation states. Different security companies like to do cute names. One of them does APT, one does like Panda, and different names. It gets kind of crazy. But anyway, so there's a hacking team that is called Stone Panda, aka APT-10. They're out of China. It's strongly believed it's the intel agency, the non-military intel agency in China, the Ministry of State Security. They basically attacked a bunch of US and European companies last year, and one of them was a big US law firm that specialized in intellectual property law. So, and in that realm, they had pharmaceutical clients, tech clients, electronic clients, automotive, biometric. So they were trying to get some info on some of these patents and intellectual property. So this is the kind of thing that the nation states are looking for from law firms. They're trying to get to your client information that's valuable to them. There was also an international apparel company too. I thought that was interesting. But that was between November 2017 and September 2018. And they basically got, I think they got in, I remember they got in through virtual machine, like Citrix accounts, and also LogMe and remote access accounts. So they had stolen credentials that got them into the law firm and other targets via those legit credentials, so they could get in and remote into somebody's machine and be a part of the network. And right away, they could just tool around and find what they needed. So strategic attacks are a little bit of an overlap, but the difference here is that they're using you for a stepping stone, not just for the ultimate. This quote I just thought was perfect for you guys. I was talking, Tom Cross is an old source of mine. He's now with OPEC Networks. He's not old. He's a source I've had for a while. He had a great quote. It's not about how well known it's about how well known your clients are, not how well known your firm is. And that's really something to keep in mind. You might think, oh, we're just this small firm. We don't have, what would we have that's important? It doesn't matter. You might have a client that has something of interest someone else wants to get to. So that's something he does work with a lot of law firms, and he's always kind of pounding that in their heads. This is why you need to care about these things. So really, it's just hacking the law firm to get to their clients or business partners. And again, the size doesn't matter of the firm. It just, the kind of information you have is key. It could be a nation state, or it could be a competitor or a business partner who wants to know what's going on with some deal, right? Who wants an inside scoop. That has happened too. Probably one of the more high profile, I'm sure you guys have heard of Panama Papers. That one was a little bit different, but it was interesting at the same time. So the Mossack Fonseca law firm in Panama, someone hacked into their stuff and dumped, and this is 2016, dumped 11.5 million sensitive data records. It was like 2.6 terabytes of data, tons of data. It was a whistleblower, supposedly, who wanted to show illicit financial dealings of high-profile people. And we're talking pretty high-profile, Vladimir Putin. You had former British PM Dave Cameron, and soccer star Lionel Messi was very disappointed about that. So it really shows how the legal sector can be vulnerable. And that was a sort of turning point for a lot of security people who follow the law sector and people who do work for the law sector was, a lot of these organizations don't have the resources they should have for security. They may not have the expertise in-house. We got to start looking at this more seriously. I think that was a little bit of a wake-up call for the sector. And so there's a company called BitSight. They do sort of a credit rating of your security posture. It's really interesting, so you can compare how you're doing other companies or your industries, how they compare. And they recently, this was probably about a year ago, so maybe it'll be better now, but they had the legal sector at a 690 out of 900. And just so you know how that does, that was ahead of PR and head of communications companies, but behind accounting firms had like a 740 rating, benefits administration had like a 750 rating. So it's not a terrible score, it's not a great score, but that's kind of where it is right now. It's sort of in the bubble of needing to get a little better with security. So I know the next group is going to talk about mobile, I think, or telecommuting, so I'm glad because it's made a good handoff. But how many of you all still rely a lot on printers in your office? Raise your hand. I would think that's still huge, right? Printers. Okay, so, do you ever think about what your printer is just to print out ink, right? Well, actually, it's got a lot going on. It has an operating system. It's networked to your Wi-Fi network or your network. It has a scanner. It has local data storage. A lot of cases, printers are being used as a first step to get into your organization, to hack into, because they're just sitting there, and you think that was a dumb system. Well, it has a port, it has wireless networking, and it has data on it, stuff that it's storing in memory. So they're pretty ripe for attack. A lot of those devices, just like your video conferencing system or other, as we call Internet of Things devices out there, people forget have connections to the internet. So does your printer. And they come with default passwords, which is a bad thing. The bottom line is you want to be able to change those default passwords. Don't take the one that came with it. A lot of them, you really kind of need someone to be monitoring and limiting the connection to that printer. Not everyone should be able to access it. Make sure it's not just blasting out to the internet. My husband's famous for leaving one of his printers on our home network, and I get really upset because I'm like, the printer's still on, it's still on the network. I'm always shutting it off. Turn it off when you're done. We have a little bit of a paranoid household, as you can imagine. It's not a bad thing, though. It's a good thing. We had a security expert who used to write for us. He's gotten too busy to do it now, but he used to give us he was a hacker turned security expert guy. He worked for a company. They had a Polycom video conferencing system, and they just kept getting hacked into all the time, and they couldn't figure it out, so they started just tearing it apart. And they realized, bottom line, the default passwords hadn't been changed, and the attackers just kept coming in through the same passwords over and over again. So they were like listening in on their video conferencing. So that's a scary thing. So you got to keep an eye on your ports, obviously, that what's actually open to the internet, and also the passwords are super important to keep them. So if you don't believe it about how actually printers can be used, there was a study, I think it was Booz Allen did, that found that 61% of people or companies they surveyed who had reported a data loss incident in 2016, half of them said that one incident was linked to a printer in some way. So it was either an intercepted print job, a loss of data from a printer hard disk, it could have been just something was swapped out, or their actual printer was hacked into to gain network access to their network. So printers are smarter than you think. And they're also a little more dangerous. We've also heard tales of printers being attacked by ransomware, which isn't as common, probably more accidental, but that's kind of like a vandalism, could be a distraction kind of thing too. So lock those things down. So is there anybody here who does not work on a laptop or smartphone mobily today? That does not, like literally stays in the office the whole time? Okay, so bottom line, everyone's mobile now, lawyers too, right? So like most workers, you've got your smartphone, you've got your laptop, you're sometimes going on a coffee shop Wi-Fi network, you're in an airport. So those are definitely vulnerabilities for firms. Your users could get infected from a network that they hop on. So the bottom line is to make sure that they're using things like they're not using open networks without some sort of security, and I'll tell you about that in just a minute when I'm talking about specifically. But malware is on the rise right now for smartphones. It was kind of a rarity a few years ago, but Android's got a ton of malware, for example. iOS, Apple's getting more. So don't think just because your smartphone's so personal and you have it in your pocket that it can actually be affected. It absolutely can, especially if you're in a public Wi-Fi situation. And a lot of times, your home routers, for example, if you have people working at home routers come with default passwords. And most people have no clue that they did or even how to, we just set up a new network at home and it was the most frustrating thing ever because it wasn't easy to set up. It was ridiculous. And I had to do so much recon to make sure we did it securely. No wonder people don't bother, right? It was crazy. And I had to add a layer to it and this whole thing, it took a whole day. It was horrible, but I thought most people don't bother, they just turn it on. But if you have people working at home, their router could easily get infected. There was a big, I think it was about a year ago now, there was a big attack. It was also traced to Russia called VPN filter. It was a botnet they were trying to make of home routers. So they infected a bunch of home routers, kind of infrastructure infection basically. And everyone's like, what were they doing that for? They never actually triggered an attack, but they found a bunch of popular home routers that had this malware on it. They had to send all these updates, everyone had to update. I don't know how many people, I'm not sure everyone even actually updated it, right? So that's what's scary. You want to keep that firmware updated on all your Internet of Things devices and your video conferencing systems. Anything that has software connection, make sure that software is updated, make sure you know what's connected to it. So again, just a disclaimer, I'm not a security consultant. But I write about this stuff all the time, and I live and breathe it. So I'm going to tell you what some of the best practices we hear from in our reporting, and these are things I've touched on some of them. But the bottom line is just assume you've already been attacked or that you're going to be attacked. Don't think, oh, we're fine, because that's not the case. You probably do have malware in your system, don't even know it, or you may have been hit and you don't know it. So always assume that. And the bottom line is do the basic hygiene. And I think I mentioned a minute ago, update your software and your firmware. Run anti-malware scans. Make sure your users have strong passwords, not their dog's name, nothing dictionary, not their birth dates. family that does that. Not stuff that they don't reuse it. Don't reuse it. Just have you can use password manager systems that'll help you if you're worried about that. I don't know what you guys have. If you don't have already a password policy, you can use password managers. They actually change the password for you. And also to make sure they're strong passwords, obviously. Don't click on stuff you weren't expecting. If you get something, I got an email from our financial group at our company a few months ago, and it looked a little sketchy, so I escalated it, and I'm like, what? It was asking me to click on something, and I sent up the ranks, and I ended up getting in touch. Our CISO got in touch with me and said, okay, thank you so much, for no one ever does this. It's actually a legitimate email, but it was horribly presented. You're right, we need to talk about how they present these emails to you. But I feel like the biggest goober. I'm like, oh my gosh, this huge company and the CISO is like contacting me, but he's like, no, thank you so much. I'm like, well, this is what I do all day. But his bottom line was, no, people don't even check, but you're right, this email was sketchy looking. It was from our financial group. And I wouldn't click on the attachment because I didn't know what it was. So it's good to don't click on what you weren't expecting, check on it. I talked about backups a minute ago. Backups you want to have, the ideal is 3. So 3 copies of your data, your original copy, a backup nearby, and then one offsite, offline, not connected at all, just in case. That's a really important best practice. And then multi-factor authentication is something that a lot of people there's so much more availability of it now, but not everybody's really using it. So that means, you have a password, right? That's your static password. If that thing gets stolen, your account's just stolen, right? But if you have 2-factor, things like Okta Verify, even Google Authenticator, these are all free apps like Google Authenticator is, Duo Security. Those are like a second factor that you get. It comes to your phone, or there's an app, and it gives you a code that lasts for 30 seconds, and you have to type it in as your second factor. Sometimes they'll text you a second factor. All your accounts, your personal accounts and your work accounts, ideally you want 2-factor authentication. That saves you if you get the email and password compromise. So the other thing that I wanted to just touch on, I was talking to one of my consultant buddies who does incident response for law firms and other organizations, and he was saying one of the things that he's trying to get people to do is something called least privilege. This is something that's been talked about in our industry forever. So that basically means your user should only have access to the exact information they need for their jobs, nothing else. So, the IT guy probably doesn't need access to the case files of the attorneys. So give them access to exactly what they need, nothing more. So that helps minimize your risk, right? So if you have least privilege, if someone's password gets compromised, then just that one sector of information is exposed, not your whole company. So least privilege is something they really do push hard. We've been talking about our industry for 13 years, and it's finally now kind of taking off as a best practice. There's also something, I don't know if any of you guys are doing this, he said it's kind of new, this idea of case-specific access. So I haven't seen this firsthand, but literally you have to be granted access to a specific type of info in a case that you need for your job, and that's it. You can't have the whole view of the case, just what you're doing on the case and nothing else, and it's very specific. He said it's not a super popular choice because it doesn't seem as efficient, and everyone's like, oh, it's too much work. But if it's a really sensitive case, he actually advises firms to do that. And I can tell you more about that offline if you want to know, but it's a really high level of really high risk, maybe super sensitive case. You want to make sure everything's very carefully protected. Let's see. So there's also out there, I know most of you probably, how many of you actually have a security person dedicated on staff? Oh, that's pretty good. Okay. And that's not typical, right? A lot of people don't have that. And if you do, it might be a small staff, maybe one person. So there's a lot of services out there now, and I have none that I would promote, that's not what I do. But there are a lot of email security services that help you filter out stuff, obviously, and some of you may have that as well. And a lot of vendors now even do, if you have a security product, they'll do the servicing and monitoring of stuff for you. So there are ways to sort of source it out, use the cloud, not have to worry about having a person on staff. The one thing the cybersecurity industry really lacks right now is talent and people to fill these positions that are out there. We're in a huge gap right now of people for the jobs that are out there. So it is hard to hire people, and I'm sure it's hard for you to find people. So look for their services out there. I can talk to you offline too. There are actual security services that do these jobs for you, so you don't have to sweat over it yourself. And even just little things, if you have Microsoft Active Directory, you can go in group policy and set things to minimize access to certain things. You can do some of that on your own. You don't have to have a security person on staff to do that. So I don't know how fast or slow I went, sorry. I want to just kind of give you my final thoughts. So this is something I talk about a lot with family and friends too. I think that cybersecurity needs to be a cultural thing. So I always tell people, not only in your job, but in your daily life, like it's okay to be a little bit extra careful. It's just like any other physical security, right? It's where the money is now is in the cloud, everywhere else, except you don't have control of where your information is. So do what you can do and do what your firm can do to really make it part of your culture. And that means having employees and users feel like they have a stake in it too. And that doesn't mean like shaming them. I was joking about users earlier because our industry, some of the really technical people like to complain about the users, but then other ones will say, look, we're not given the right tools to do it right, so what are we complaining about? I mean, they've got to make it easier for users to make it more seamless, but if you make security part of the culture where everyone feels like they have a stake in it and you train users regularly, not just, oh, here's your little, click through, check boxes, take a little quiz, not that, but make it part of their day, like how to handle a phishing email, who do you send it to? Like in my situation, I didn't really know. I just escalated that email. I'm like, I didn't even know who our CISO was because our company was so big, I'm embarrassed to say. So I sent it along and then it got eventually up to him. But, take the time to really get users entrenched and be part of that whole solution. Have a security policy, hopefully you have one. And then have an incident response plan. And you don't have to actually do all the work yourself if you have an outsourced service, but know, like if an incident happens, who do you need to tell? What do you need to do? Do I turn off that machine that's infected? Do I take it off the network? What do I do? In some cases, you don't want to shut it off. You want to keep the forensic data on there. So you might just maybe take it off the network, but you don't like turn it off. Don't power it off. There might be situations you would, but you got to know what to do. So get yourself an incident response plan. Know what you'll do when it happens. Make sure everybody knows what to do in the company if they see something, or in the firm if they see something. Oh, that was it. So I wanted to leave some time for questions because I know this is a totally different talk than the other talks, so I don't know if I was at the right level tech-wise or whatever, but I'm happy to answer any questions you have. And I actually have some questions for you guys if you'll entertain them, just because I'm trying to learn from you also. So does anybody have any questions?
Has your organization done any reporting on cyber theft from real estate settlement services or law firms that handle real estate settlements?
The real estate market is becoming a very big target. I didn't talk about that today, but we're seeing more attacks in that space, and some of the more sophisticated cybercrime groups, they're realizing, wow, that's a pretty hot area. So yes, that's a really big space that's getting targeted now. I don't know of any breaches right now, recent ones, but we are keeping an eye on that. And personally, I'm in the middle of buying a house, and I thought about that when I was signing documents the other day. It was kind of frightening, like, this information is everywhere, like, where's it going? So yes, it's definitely one of the more lucrative spots right now, and I would think law firms that are handling that would need to be thinking about that as well. Yes?
We've recently gone to an electronic document signing, DocuSign. Mm-hmm. Are there any particular vulnerabilities there?
Any vulnerabilities there? Well, it depends on how you're, okay, so yeah, I just used that recently too. I was on my VPN I was all behind all my things I could be behind my firewall. I mean, if you have it secured, if you're in a secured environment, like I wouldn't DocuSign something from Starbucks without a VPN, I wouldn't do that. I would do it, even in my house I have a VPN, so I would do it very carefully because that's still sensitive information, obviously. I don't know much about DocuSign, how they secure things. I don't know about them as a vendor very well, but I know it's a super popular way to do like real estate forms and things like that now. So, anybody else? I thought I saw a hand go up somewhere else. Yes?
I have sort of a general idea of what the dark web is, but could you describe it maybe a little better?
Yeah, it's kind of it's a big fat mess. So basically it's a part of the internet that's not searchable on Google for the most part. So it's like it's and you have to have an in somehow to get on many of these sites, but it doesn't take that much once you get in. And that's pretty much where everything's sold, like weapons and malware and stolen things. And yeah, and most people are using Tor browser, which is anonymous browser. They're anonymizing their access so no one can figure out who they are. There's different levels of it too, if that makes any sense. But it's basically where stuff is traded illicitly. It's like an underground, basically is what it is, but online. And it's not searchable on Google. But if you know how to get there, you can get there. Like you have to have a little portal in, and someone has to let you in sometimes. And once you get in, you can continue along. And it's not. I've done some research there. It's not pleasant to watch a lot of it. It's very disturbing. I hope that answered your question a little bit. Does that help? Yes. Okay. Yes.
Have you noticed an uptick in keyloggers at law firms or denial of service attacks?
Not yet, but keyloggers are a good spy piece, right? That's something that a lot of the nation state groups will use. They'll use keyloggers to just sort of get, that's one way to get people, I didn't talk about, that's one way to get someone's passwords. If you have a keylogger, which is basically a little sniffer application on your machine, it's logging your keystroke so it can get your password and your login. That is one thing the nation states do use. Not as much lately, but they do use that sometimes. But I don't, not at DDoS, not so much, but it's not of the realm possibilities at all. Anybody else? Any questions? I wanted to ask you guys, if you don't mind, how much time do I have left? I have like 5 minutes? Okay, good. I'm wondering how many of you, I guess we'll just, does anybody have like what are the main things you're worried about? Like, I know you're here learning about this privacy stuff on the legal side, but in terms of security stuff, what are the biggest things you're concerned about? Is it managing passwords? Is it ransomware attacks? Or have you had any experiences that you're trying to learn more about today that would help, this might help? Does anybody have anything they could share? I won't write about it. No? Has anybody been, oh, yes, go ahead.
Inadvertence, maybe.
Excuse me?
Inadvertence, maybe the fact that we're lawyers and not IT experts, that we could conceivably compromise something or do something wrong and not even know it.
Yeah. You're talking about maybe like clicking on something you didn't mean to click on, or is that what you mean, like getting duped into a phishing email or something?
Yeah, or just, anyway, even doing kind of something, we could even accidentally send something to a perfectly legitimately, but we didn't know it was going to them, for instance, and then we would be in trouble. We would have violated things, confidentiality, for instance, and not even know it.
Yeah. Well, I know most user insider attacks, they call them, are inadvertent. Most of them are. Fewer malicious, but it's usually someone making a mistake, sending a document to the wrong person, or again, clicking on something, or not realizing. And it's easy to do. If you're your phone sometimes too, and if you're quickly checking something, it's so much easier to mess up on your phone, I think. I'll be like, no, I shouldn't answer that right now, because you don't have time to actually assess it, right? So, yeah, I think that's definitely challenging. I think, and again, with cybersecurity, users are usually it's a social engineering phishing attack that starts the whole chain. So it's really hard to, as they say, you can't patch people, but you can help them understand and be prepared and be more savvy. I know I'm probably pushing my time, so I won't keep you guys, but I'm happy to answer any questions offline if you'd like to talk, and I hope that was helpful. Thank you.
All right, we're going to go ahead and get ready for the next presentation. We will be passing out a copy of the slides that you are welcome to take some notes. And aside from that, just to piggyback off Ms. Jackson-Higgins, she told you, among several things, to watch your email. You're not just going to want to watch it for maybe this Nigerian prince, but after today, we will be trying to get the CLE forms via email to you, so keep an eye out for those forms so that you can get the credit.
How do I know it's you?
Yeah. Okay, so our next speakers are Miss Nicole Harrell, who's a member at Kaufman and Knowles, and then we also have Mr. Dustin Davies, who's the CIO of Kaufman and Knowles, and they're going to talk to you a little bit more about telecommuting, so the idea of talking to not only your support staff, other people within your firm, but other people in a more mobile setting. So this could be clients, staff, peers. Anyway, I'm going to turn things over to Nicole Harrell and Dustin Davies.
Thank you. Thank you. And we know sort of we're the last presentation between you and the afternoon. So, but we're really pleased to be here. And when I got asked to come today and had the opportunity to be a speaker, I was sort of thinking about what I was doing. I was in looking at sort of ESI and how that affects your work environment. I immediately thought that sort of the more interesting of the speakers would be the gentleman sitting here to my right, because he's who, sort of in our firm, is responsible for controlling all of the stuff that we can and cannot do, and for taking the complaints when I need to get to something and I can't get to it. Dustin is often sort of the first line of attack. So hopefully we have a lot of slides here today. We may not get through them all, but what we've done is try to give you some sort of practical take-home information as well. So, okay, there we go. So at one point in time, this was sort of the work environment that you were dealing with, and it didn't get really outside of this. The only thing wrong with these pictures is these two people appear to be playing nicely. That doesn't always happen. That's a seminar for your labor and employment professionals, which would be sort of a different journal. But so this is essentially what you're dealing with now. We're all over. When I came out of law school, it was unheard of that you would not physically be in the office. And there was very little good ability for you to even access anything that was in the office. I had a computer. We had Citrix at some point in time, probably before Dustin came, sort of a very old Citrix, but nothing worked well even if you did. So the work environment has really significantly changed, and you're seeing it, and you're living it, and you're having to deal with it, and you're having to engage lawyers that may be on a contract basis, or you've got employees that are great employees that for any number of reasons you're allowing flex work time and the like. So we've really had sort of a shift in your workforce and how it looks and whether people are in the office or out of the office. And it's sort of any probably number of reasons for that.
So we titled this slide Confluence of Events. None of these items are surprising to you, but if you understand in context, each one affects the other quite a lot, actually. So the shift in workforce would be job types and responsibilities. We know that industries are changing. Access to information and data is becoming a day-to-day requirement to do a job. Working conditions and requirements, changing expectations of workers. Right now, 43% of Americans would say that they spend at least part of their time working from home. That's a big shift in a very short period of time. We also see flexible schedules. Then there's also cultural changes, and those are pretty broad. We see more relaxed working environments. Law firms probably are the last to be affected by that, but I know law firms where routinely partners come in jeans. And I know of law firms where there are partners who won't use the restroom without putting their jacket on for fear of being outside of their office, outside of their jacket. So that's the shift that we see in the workforce. Next slide.
Yeah. So one of Dustin's probably biggest issues that he has to deal with is if you look at your workforce, look at the span of people that you're dealing with. So sort of from a top-down look there, we've got people who, and we have plenty in our law firm, and many of you may have them either in your firms or your work environments. Individuals who almost want very little to do with a computer, the guys that still want everything in paper and have their secretaries printed out and they take them in a nice sort of folder, to people sort of coming in on the newer end of that spectrum who don't know how to use a rotary dial phone. So there's a big spectrum of people that you are now sort of trying to work with, and that sort of makes Dustin's job a whole lot more difficult.
And I'll give two stories, one that's personal, one that is from the Wall Street Journal. In a 2006 time frame, I was a consultant, and I worked with many different law firms, and there was a firm of about 35 lawyers, and we were charged with upgrading their systems. And we just knew that the managing partner was going to love his computer. And to my dismay, I was called into his office, And he said, "Get that off my desk." This was 2006. He wanted the computer off of his desk, out of his office. That was seen as sort of an underling function. And I was fairly new to the thing, and I thought, this is different. So that's one side of the spectrum. The other side of the spectrum, maybe a month and a half ago, the Wall Street Journal ran an article about the office desk phone. It's a hilarious article, and the best thing about the article is that they start off with a gal who worked somewhere, and she worked there for 2 weeks before she called IT to complain that her handset wasn't working, her phone wasn't working. And they went out and found out that there was no cable between the handset and the phone portion, and she'd literally never seen a connected phone on a desk, had no idea. And other great parts of that story are those folks, they were one of the guys was a little bit older, but he decided he was never going to answer his desk phone, and he was never going to return voicemails sent to his desk phone. So he let his inbox fill up, and they just, the company that was describing this tolerated the fact that this guy was available on his cell phone. He was a mid-level executive. His voicemail was full, and that's just what it was, which is interesting, to say the least. The commoditization of technology, that's also just not a surprise. In 2003, there were 0.08 connected devices per persons worldwide. 0.08, so it was that 1 in 100. In 2010, 1.8 connected devices per person worldwide. We expect next year to see 6.5 connected devices per persons worldwide. So see, that's clearly following in the Moore's Law footprint. Is everybody familiar with Moore's Law? And what's fascinating about Moore's Law is that it was Gordon Moore noticed in 1965 that in roughly a 2-year span, the number of chips, the number of transistors that could fit on a 1-inch square chip doubled, and the price approximately halved. Skeptics said that cannot last, it cannot continue, but it has lasted, it does continue. We don't know when that tails off, but it seems to be accelerating.
So I put this slide in here primarily for amusement versus anything, because I'm on I started sort of clearly on the left-hand slide here. Even before my first job in between high school and college, and then when I went back all the summers thereafter, we still used carbon paper, and we still had to set the memory on the typewriter. And what the really awful part was, if you forgot to set the memory and then you typed all this stuff, it was gone. So now we don't you generally have to worry about sort of those sorts of things. But what has happened is that, it's far more accessible. The amount of data that we're able to keep has expanded, extraordinarily.
Just to kind of bolster our claims with data growth here, and another story. When I like to remind my parents about this. I was told as a youngster that computers were a very expensive hobby, and it just wasn't going anywhere. If that says anything. On to Moore's Law, I wanted the better, faster thing every couple of years. Data volume worldwide is slated to grow by 10 times between now and 2025. Most is going to be created and managed by enterprises. So when we talk ESI, when you hear ESI, we're really just talking about everything. It's all the information, and there's many facets to it. There's what we traditionally think in sort of a flat model, like the information on the page. And I appreciated the question about inadvertence, because maybe I'll share another quick story, the difference between lawyers and programmers. It's a great sort of quip. We think about things in a very flat concept. It's because it's how we think. We see a piece of paper and we think that's information that's there, we can read it and we can understand it. And when we talk about making it electronic, it takes on almost a whole new dimension that most folks don't even consider. Yes, you can read it, you can access it, but so can other people. And it's infinitely available. It can be infinitely available. The difference between programmers and lawyers. I'm sure there's a lot of jokes that could come out of this, but this is not a joke. I found very early on that most systems were designed from a programmatic standpoint, and a great example is I think the #1 document management system in use at law firms right now. If you go and you search for all case documents, you get a maximum of The system can be set to allow you to see 9,999, and that's it. And a lawyer is used to being able to say, let's go back 10 years prior to this being a thing. I want to see all the documents. And what they really mean is they want to go into a conference room and they want to appreciate 25 red welds, and they know that end to end, this is what I have. And they want to think about it, and they want to sort of ruminate on that, and they might want to pull out 1 year, and they might want to look at the beginning and the end of that 1 year, and they are incensed that the system is insufficient. And a programmer would say, to see those documents, you used a search function. And if you pull up more than 10,000, you did a bad job searching. It's just a different way to think about the world. Worldwide big data market revenues for software and services are projected to increase from $42 billion in 2018 to $103 billion by 2027. And according to an Accenture study, 97% of executives agree that companies that don't embrace big data will lose their competitive position and could face extinction. So this is clearly on folks' minds. It's going to be on your clients' minds. And we have to talk security and privacy. And often heard quipped, it's two sides of the same coin. So most privacy issues are also security issues, and many security issues can give rise to privacy issues. So that's a simple view of the world. To make it a little bit more complicated, we have a textbook definition of privacy, but in practice and sort of as the technology goes, it's a bit of a mess. What's next? In 1998, the Federal Trade Commission reported these principles as being the tenets of privacy. And this was actually reported to the legislative branch in a document called Privacy Online, a report to Congress. So if we take that at face value, we're talking about some pretty slippery concepts: notice and awareness. There's a lot of wiggle room there. Choice and consent, access and participation, integrity and security, so security maybe rears up a little bit. Enforcement and redress, some legal terminology. Fast forward just a little bit, and the GDPR, does that ring a bell? If you've noticed, you've got to click a lot of I agrees on the web. You can blame the Europeans. It's all about opting in. And they give some entirely different privacy tenets. Just, some similarities, some overlap, but it's different.
And some of that is driven by I think a lot of, we in the U.S. have a very different view of what privacy means versus how many European countries do. And if you look and if you were to read through the sort of tantalizing pieces of GDPR, it becomes very, very evident that they have a distinct view of how individuals' information should be treated.
It's precisely right. I read an article titled Big Data Ethics, and what was remarkable to me is that some of this was spot on, some of it was different. And again, there's just a very different perspective. And I'm not a lawyer, so this is not legal advice, of course. This is technology advice. This is Dustin advice. Assert your right to privacy, but understand it comes with responsibilities. So when you're doing something, think about the many dimensions that you should be considering the thing. In short, privacy is hard. It's hard to define. It's still slippery. There's a lot of additional context needed. Fortunately, security is pretty easy. This has been standardized. There are 3 tenets: confidentiality, integrity, and availability. Those are the ways that technology folks like me try and rationalize the world. It's how we think about things. So I've got a slide in here. It just says, the rubber meets the road. Can anybody give me a guess as to why this was a sea change moment? Which you see up here, the 2013, 2014, HIPAA, and GDPR. Any idea why those things created change? Any thoughts, any guesses at all? Penalties, dollars, money. So one of the things we saw with Target is banks who traditionally were on the hook for the cost of a breach of card data were able to push it onto Target. They were able to do the same thing with Home Depot. And ironically, even though those are roughly a year apart, just under a year apart, it was very similar sort of hacking mechanism to get to the data and get into the systems. So HIPAA, even though it was enacted in 2009 and then not actually implemented much later, we're talking real dollars, real cents, real penalties. Now we have to really care about this stuff. And Brian Dunlap, the client security officer for HP, said whether it's patient records, billing information, cardholder data, the ultimate responsibility rests with the originating organization, despite our best and well-intentioned efforts to transfer some of that burden to third-party service providers. And he went on to say, all are issuing guidance and making strong statements to the press about the need to protect data across the vendor and partner ecosystem. That's a true statement, and they've been pretty successful at pushing some of it down. So that was about 2015, but again, with Target and Home Depot, we see that now they're sharing they're paying their share of the burden for sure.
So I want to mention sort of one thing here, particularly since HIPAA was mentioned on that slide. All of us, you've been to a doctor's office, you've called. Now you can go get your patient records online and you can make appointments online. So very recently I got a phone call, and it was from a concerned individual, obviously, and this is what was happening. You would go and you would log in, select what day you wanted your appointment with the doctor, and that email was then sent to the home address of the office manager for the healthcare practice, who printed them out on her home computer and then brought them in the next day to actually physically schedule them in the system. So if anyone doesn't think that that's a problem, in every aspect of it, I was sort of just running through that, thinking of all the things that were wrong. So you have to be very mindful of that sort of with your clients and in your own organizations as to how you're handling those sorts of things. There are a lot of better ways that could have been set up from an IT perspective. But it was the easiest route that they could take. But they're on, and not only sort of is the information there sort of leaving the system to an unprotected network outside of the environment that Dustin is trying to control, but you're also dealing with extraordinarily sensitive health information. So the HIPAA violation on that sort of thing would, and the penalty on that, so, had it been a really big practice, been through the roof, because the FTC and OCR are not going to generally sit back and take those types of things lightly. If you look in the healthcare field generally, you still have your own physicians, and if you represent any physicians as your client base, those guys still have a stack of files in the back of your car, I can guarantee you. There are people that troll hospital parking lots looking for unlocked cars to take laptops and files and any number of other sorts of things. The healthcare arena is still really ripe, and while they will have some sort of IT-based security issues. One of the biggest penalties sort of that I'd seen in a while was a paper record system. So for the healthcare industry, not only are you still dealing sort of with the security IT piece of it, but also very much sort of on the paper side. They had terminated a physician, I think it was out in Washington State, and they took all of 80 boxes of files, of paper files, and delivered them to his home by a FedEx or a UPS guy or a courier in the middle of the day, and he wasn't there, so they left 80 boxes of patient records literally on the curb. I think they were fined something like $950,000. I'm not sure that was enough. But that, so on the healthcare side, that's a lot of sort of what you're still seeing. Did we? Yeah. Okay. So your biggest threat, heard a little bit sort of about malicious attacks and the like. Your biggest threat are your people. No one wakes up in the morning and goes in and be like, I'm going to tank my company today. My sole mission is to bring down my employer. That can happen, but most of your employees, and most employees sort of are not in that mindset. It is the very much of, I want to get this job done. I want to be efficient. I want to show my colleagues and, you know, my boss that I'm responsive and receptive. So a lot of times, you know, what happens, and if you look at it now, like this is W-2 scam season, and so someone is just anxious to get the job done. And it's a matter of not stopping to pay attention, because W-2 scams, the email addresses that these things come from are so evident. All you have to do is hover your mouse over it and it will pop up. And it's pretty clear to see that this wasn't from the head of the human, or head, your CEO or head of HR who wants to do a salary analysis. So please send me a PDF of all the W-2 files. First of all, they should already have access to that information and don't necessarily need to ask. But second of all, just stop and pay attention and sort of look at that. So a lot of what you almost have to do is repetitive and consistent training. And employees will begrudgingly go to training, and everyone has pizza or food or some sort of lunch or whatever you do to get people there. It's really important. Whether or not, you know, there are other ways to sort of do that as well. If you have a internal newsletter that sort of electronically goes out, put a little tidbit about, you know, a data privacy or security, you know, tip in there. Make your IT department, or so, at least someone in your IT department, fairly accessible. So like if I have an issue, I can walk right into Dustin's office and say, hey, you know, what's this? Or I can send anything to our IT department, and they will look at it and most willing to help. A lot of times your IT department is isolated somewhere. I don't think they should be, just sort of logistically. They need to be available so people see them, know that they can go there. It's not sort of an issue if I'm not crossing the line, if I go to Dustin and be like, I don't get this, please help me, you know. Make sure your employees sort of are aware of that. There are other threats that you have are going to be sort of technology and various environmental factors. A lot of the environmental things you can't necessarily control. It's sort of things that are going on the outside and trying to get into your system. A lot of the sort of the technology threats are, if you were to ask the head of your IT department, your CIO, if they had enough money to do what they wanted to do, I'm going to guess the answer is going to be a real quick no. There's not an amount of money that you could continuously spend to necessarily be on top and have sort of the top of the line of every piece of it all the time. So that's one thing. And a lot of times with technology, you see people simply not patching. If you look at any of the number of data breaches and the like, and the way hackers will get into the system, it's through a vulnerability. And if a patch comes out and you've not rolled it out, then you're vulnerable. And one of the largest data breaches, I think it was last year, not only took down one of the world's largest law firms for multiple days, but also took down Maersk, Australian Airlines, their entire booking system, simply because someone hadn't installed the patch to the software. That's a pretty costly mistake. And if you were to think about your business alone going offline for a couple of days, and the economic impact that would have on you, think about a law firm sort of that is one of the largest law firms in the world. They've got offices all over, and sort of the volume and mass of data and transactions. As a transactional sort of lawyer, I look at it like I can't imagine holding up multi-million-dollar deals for weeks, you know, over something like that. So.
Great. A lot of the rest of this can be boiled into sort of policy and kind of legalese kinds of things. I'm always excited when I get a chance to prove that people can be a security threat, because some of these examples are, I don't know if fun's the right word, but, you know, share them and people can identify and they see it. This article was written in 2012, but it still holds true. It's still commonplace. The common, you know, hiding places for workplace passwords. Like, this is still a thing that happens pretty routinely. Monitors under keyboards and desks. So the suggestion, and I heard it from the last speaker, and password generators. If you, I was actually struck in talking to a room full of lawyers, and I said, never use the same password from site to site. At the number of like offended looks that I got. And in short, and what I found out after the fact was there's no way I can go through and change those 600 passwords, because I use the same one and I've done it since college. and it's got my pet's name in it, or it's got my kid's name on it, and I add a 1 to the end, and I rotate that every time they make me do it. Use a password generator. It's pretty easy. If you learn that technology, you can use a 26-character password. It's different and unique for every website, and it's pretty secure. At a minimum, a firm should prohibit people from using shared passwords for firm resources and outside resources. That should be a policy statement that's made. If you want to really let the air out of a room full of lawyers, this is a favorite predictable demonstration. How many people have been to WikiLeaks, like actually gone to the website? So I'm always struck by that because it's in the news all the time. Everyone's heard of it. If you go and you look up the Sony WikiLeaks, you can pull up a searchable interface, and you can search for the words privileged and confidential, hit enter, and faster, or as fast as I could produce documents for the lawyers at the firm that they should have access to, they can see 14,000 documents to and from a lawyer at Sony. And it's fascinating reading. And again, the room just kind of looks, and you see the air. You see people's ears start turning red. You see the wheels start turning. The chief executive officer of Avast, a security suite, said that lax attitudes towards security of the home networks is creating a security environment reminiscent of PCs, personal computers, insecurity in the 1990s. So your home networks, you need to pay attention to those. When you carry electronic information home with you, you're taking some liability in your hands.
And one of the things is, as sort of legal professionals, your workday is no longer 9 to 5. And and before sort of the evolution of technology, there may have been paper files that went home and the like, and that you did sort of those sorts of things. But you regularly now have clients sending you emails at 10 or 11 o'clock at night and expecting that you respond. And so it is almost necessary that as a part of your job, if you are working from home, that you do have sort of your home network pulled together and tightened up. And I was guilty of that for a really, really long time, and started to realize why everything was very, very slow. And my husband, who does the IT amongst any number of other things, that's not his primary job at his automotive dealership, had just installed it, never changed the default password. And the other thing that people don't realize is your modems and the like, they require updates as well, and most people never download those and send them to, and that really, A, is a vulnerability, but B, makes things sort of very slow. So.
Indeed. So home networks, and this actually probably belonged one slide earlier, but I have to tell you, this is hard to read, and it's hard to read on purpose because I had to hide so much information. This is an urgent care's front desk. I took the picture myself because I couldn't believe it. And they had great awareness of who the chief privacy officer was, who the chief information security officer was, of the protocol. One of the things that I covered, because I don't want the names to be on there, like, do you know who to call if there's an incident? And I mean, to be on the floor, to be working, you had to be able to answer these questions. And amongst that paperwork was the username and password and the phone number to access patient information with one of the insurers. I mean, you could masquerade as them. You could call. I could have stood there and called them and given them my name and this username and password, and they would have read me any number of PHI, which I thought was. They're trying to create a culture of security, but they might be missing the forest for the trees. Another sort of perennial favorite, and I intended to pull these up. I'll just describe them to you. Redaction failures. That's one that is always in the news. It's one of my favorite things because it's so outrageous, and it's been around since the mid-90s. You heard about some group deciding that they were going to take it upon themselves to redact some documents, and they highlight it, and they use a black highlighter. And this is all about, when I said earlier, thinking multidimensionally. It's not the thing that you can see, it's the thing that it is. And the thing that it is you can copy that and paste it into Notepad, and all of the information is still there. The first one, Bruce Schneier, a security researcher, points to Italian media published classified sections of an official U.S. military document. where they were inquiring into the accidental killing of an Italian agent in Baghdad. And everything that was redacted was actually just hidden under black highlighter on the electronic document. The second one, sanctions, and this one's great just because of the parties involved. Sanctions issued against a firm that disclosed confidential information in an Apple and Samsung license. So they disclosed confidential information. Actually, one of the clients was Samsung, and they passed information along that they should not have passed on. They did it by just highlighting it, marking it black, saving it, sending it by email, and there it was. In 2011, there was an article studying redaction failures, the frequency in PACER documents. And there were hundreds of PACER documents, most surrounding litigation, where fields were improperly redacted. And this guy put together a quick program, sort of enumerate it, and it, of course, was shocking. Hopefully that's changed. I suspect that there's still stuff in there that's less than secure. And then just a couple weeks ago, Manafort lawyers, they botched redaction revealing details on alleged Trump contacts. I don't know if you picked up on that. That was really just a redaction failure.
And I think that's probably the one that really brought it to light for a lot of people if you're following the news, because the redaction issue has been around for a long time, but most people didn't really realize or notice it until it was very public in sort of the midst of what's going on with respect to that investigation. So that's one where it's pretty easy actually to make, you almost have to make sure that the redaction, I don't know how you want to say it from a text standpoint, is embedded into and part of the document, not just overlaying it. And there are any number of ways that you can do that, but that is very much of I've got to get this document out, I've got a paralegal, a legal secretary sort of helping me redact this information, and then we're going to go ahead and file it with the court. Or I'm doing it myself, late at night. That's sort of making sure everyone knows what the process is to make it embedded sort of really into the document, and again, not just kind of laying over top of it.
Another great example, at the frequency that we see, I don't mean just to pick on Dropbox here, but the frequency we see problems with file sharing sites and the sort of cavalier attitude towards using them. This is the standard. Young folks just want you to Dropbox things to them. And there have been any number of specifically Dropbox issues, but others as well, where, for some period of time, if you knew the email address, you could see everything that was there. And we've seen a lot of sort of apologies from Dropbox or these other file sharing sites, or, hey, we've had this breach. But when you see 68 million user accounts leaked, I'm still surprised that I don't see a correspondence in like breach notifications where folks were using Dropbox to do other business things. I can't answer why that's the case, but it's always surprising to me.
And from a sort of transactional standpoint, Dropbox is very, very popular. So we've got, any number of clients when sort of populating data rooms on M&A deals that they want to use Dropbox, which to me is extraordinarily frightening, because if you think of all the material that you're going to disclose during the course of an M&A deal and that your buyer needs access to, and it's all just sitting out there on Dropbox. And clients often want to do it because it's cheap and easy. But the flip side of that coin, it's not going to be cheap when something bad happens. And it's hard to get clients sort of over that, but it is one of the things that sort of I've had a number of discussions with clients, like spend the money on a data room where it's sort of a little bit more secure. Dropbox, and there are companies, for example, that cannot use Dropbox and other types of files, file sharing types of service. For example, a lot of the big insurance companies, Marsh, I know is one example. You can't send anything to those guys using Dropbox.
This is always a sticky wicket, and this is more questions than answers, but I'll just say, what about cookies and web tracking? Has anybody really thought about the implications? You're researching for client, you're doing some casework, you're putting a lot of information out there. What does that mean? And actually just today I paid attention to and noticed a tweet from an Apple engineer, Don Marty, and it was, we're investigating reports of news site subscribers getting spuriously logged out and found that trackers were adding so many cookies that the news story's legitimate cookies for access, logging in, has been pushed off the edge. There are thousands of characters that can be used in that space, and we're talking about as many as 70 different trackers and cookies using, and they're kind of sloppy and lazy. You only need 12 characters. It just has to be anonymous, or it just has to be a specific identifier. They're lazy, and they're pushing actual real use cookies off the end. So, I mean, what are the thoughts about 70 trackers watching what you're looking up on New York Times? It's just a fascinating question. Another example, this is an example where there was a malpractice suit. A physician made some server changes. So when it comes down to role-based security, is that being applied? You know, folks that are pretty mobile, they have needs. Are you just willy-nilly handing out credentials or access that just necessarily shouldn't be there? And, you know, I think we really are talking about information governance when we talk about how are we dealing with ESI.
So the biggest sort of, when you're looking at the whole picture and figuring out your organization and where people are located, where your data is and where it has to go, sort of the first thing I think that you generally have to understand is what data do you have. Dustin can probably speak to it better than I can, but a lot of companies don't know, and a lot of companies don't know where it is, and a lot of companies don't know how much hardware they have and where it's located and whether it's in use. Companies just aren't sort of tracking those sorts of things, and that is quite scary, because think of the amount of data that can be on just one device, or think of the access that someone can gain sort of through just that device. So then, you know, looking at not only who has access to the data, but again, the devices as well. And how can they be accessed? Because if Dustin doesn't want me to access on the system, something on the system remotely, he can do a few things. I think of as turning a switch, but he can make so I can't get to it if I'm remote. And then where and how can your data leave the system? And that's obviously pretty open-ended, but what ports do you have? What ports are open? What ports should be closed? Some of the biggest data breaches have occurred because someone didn't sort of close a port which has allowed someone in. One of which was actually very publicized, particularly in our area, was a government contracting company did not have a port closed. So they could get some of their employees trafficking in and out of it, but they could have done it another way. Well, what happened was state actors who, at least they had a firewall up, they had a firewall sort of prevent foreign addresses, but the state actor got into a municipality in Georgia and then used that as a pivot point and pinged into this system. The system happened to house the entire maintenance schedule for the Atlantic Fleet, and when ships were going to be in and out and what was going to be happening when they were in and out of port. So we want to talk about sensitive data, particularly on a national security level, all because they left this one port open so a few of their employees could sort of access that through sort of the IT piece of the system. So I do want to leave some time for questions if we have a couple minutes, but the next couple of slides really go through sort of some of the practical aspects of looking at your data and who has access to it. Data mapping, if you've not been through that exercise, is extraordinarily probably painful and tedious. Dustin is shaking his head yes. I have not had the pleasure of sitting through a lot of that, but it is really knowing what data you have, where it's stored, what the retention policies and the like, who has access to it. When you're looking at your workforce, if you don't have a home and or mobile access policy, you certainly should. Do you have a bring your own device policy? And what does that say? So if you're not issuing employees a device that they only use for work purposes, because lots of people now have multiple phones. If you allow your employees to bring their own device and access your systems and documents and the like through that, what's the policy? If something goes wrong, can you have access to that individual's phone? Can you basically make them give you the password? What happens if you have to wipe the device and you've wiped out, 1,200 pictures of Dustin's kids because you had to take his phone? You're not going to have a real happy employee, but you've got to sort of essentially be able to monitor that.
And likewise, I would say, do you have incidental personal use as an exemption?
Mm-hmm.
So a lot of folks know that employees use incidentally, personally, and there's a business case here. I mean, I would much rather that my employee who might be trying to buy a house work the afternoon, knowing that they need to get this email and they need to scan the document and get the thing out. I'd rather that he takes 15 minutes to do that at 3 o'clock rather than taking the afternoon off because we don't have any incidental personal use exemptions that apply. Of course, that comes with no reasonable expectation of privacy and all the other things that the lawyers can help you with. But if you're accepting that kind of incidental personal use, is that clearly defined so that you're not violating what your policy states?
Mm-hmm. We talked a little bit, and you heard it from the prior speaker a little bit about sort of security and the like and things that you can do and making sure you're using passwords. And one of the biggest things, though, is permissioning people. You've got to permission people really, and she spoke to that as well, for what they need and not for everything. It'd be great for everyone to have access to everything. I don't need it, sort of in my organization. And to a certain extent, your employees shouldn't expect it. They shouldn't be able to sort of go through your system. Imagine if you had a secretary in your company who had access to all the HR data, and that individual was not in the HR department. Just on a very basic level, think about sort of the ramification of that could have sort of amongst the ranks of the employees. Sort of not only the fact that they just don't need access to all that information. We shouldn't be giving it to them. You would be surprised at the number of flash drives and the like that are lost. I speak fairly regularly with one of the FBI agents who works in the Norfolk division, and at a law enforcement conference, they dropped flash drives at any number of locations throughout the conference. And they were tracking the number of people that picked it up and then plugged it into their computer at a law enforcement conference. Most of them were tracked as someone picked it up and plugged it in. And it came up with a flash like, you could have been hacked, or they had some sort of fancy little saying on, but sort of looking at that stuff and what can you take out, what can your employees take out and the like. We've talked a little bit about this again, sort of managing privileges. One of the things that we often see where companies are lax on this one is if an employee leaves, and regardless of what the circumstance is, you have to cut them off from the system. And there can be a lot of bad things that happen if one of the employees that leaves is in your IT department and has the keys to the kingdom, and you don't cut them off immediately sort of on termination or their resignation, however it happens. Make sure that you are people don't have access to their accounts. And so you're in part of that process. Your IT department has to sort of be in the know as to when people are coming in or going. So I know we were almost out of time, so I'll stop here and we'll ask for some questions. But there are a couple other things here, sort of on monitoring your systems and developing a strategy and policy for that. How you protect against malware. A lot of that is training your employees and training them and training them again, because that sort of, do you want a free Chick-fil-A sandwich, click here, is a lot of what you're looking at there. General sort of network security and the like. So some summary slides here again, and you probably heard a good bit about this through the day. But, you know, your environment is always changing, and we do have to be able to adapt to that. We have to be able to adapt to the fact that we've got remote employees. We have clients who may want to, we may have portals for them to come in and access documents. There are any number of sort of inroads and paths out of your system, and making sure that those are as secure as you can possibly make them. People have the right access. People have access only to what they need. Your network is patched, and you're taking sort of Dustin's role and making sure, to the extent you can't prevent obviously everything, but it's one thing to be able to say I did all the stuff. It's another thing to be able to say on the back end of a breach response, I didn't do X, Y, and Z. And having sort of been through the breach response process with a number of clients, the insurance companies are going to ask all of those questions. And the way sort of cyber and data breach policies are now written, there's a whole lot of exclusions, and there's a lot of ways for insurance companies to sort of say we're not going to pay. So I know we are literally right. Any closing remarks? And we'll open up for questions.
I would just point out specifically, strong recommendation, have a written breach notification protocol. So people do know what happens, and they do have some examples of what a breach entails and how they're expected to protect ESI.
Okay, perfect. We know we ran right up to time, but if you have questions, we're happy to either answer them now or stay around for a few more minutes, whatever works.
Yes, sir.
So we do have time for questions now. If you all have any questions, and if they're willing to around and leave a suggestion, please feel free to go ahead.
Yeah, so on the recommendation that you use like password generators, 26 characters for maximum security, do you have any thoughts on application systems now that are offering to do password management? I've been seeing a lot of ads for them, just don't know what they're thinking.
Yeah, I do, and there are a number of them that have good cryptographic sort of proofs that are available that would show you, and you know, if you don't know how to read through that, find somebody that you trust, and make sure you have one that has limitations to what they actually can access. So I think commonly referred to as trust no one kinds of security. The one that I use, and there are several that do this, all of the information is decoded inside your computer on your browser, and if the database itself gets compromised, all they have is a salted hashed database that's encrypted very well. It'd take them, you know, I mean, there's a calculator for this, like, and I'm not kidding, like 1 trillion years to access it because of the difficulty of the encryption.
Anyone else? I will just, one of the questions in the last panel, and I just thought I didn't sort of want to interrupt that, but one of the questions in the last panel is, are you seeing a lot on the real estate side? I believe you asked that question. Title companies are targets, and their lawsuits abound, and we've seen it quite a bit. People are losing money left and right on real estate transactions, and they are huge targets. It is coming back on all parties to the deal, because you then have to figure out sort of where the breach was. I can tell you I've seen any number of title companies just bury their head in the sand and say it's not our problem, and it's where all the money's flowing through, you know. So breaches can certainly happen on any side of the transaction, but title companies right now are getting hit hard. Well, thank you very much. If you have other questions, Dustin and I will be around, and thanks for having us here today.
Thanks.
All right, well, it has been quite the day in terms of having the symposium, so I just wanted to have a few final remarks as one of the co-editors. First of all, I just want to say thank you all for registering and coming here today, as well as thank you to all of the speakers who were able to make this the great event that it was. So we not only were able to come up with this idea of looking into social media, but we were able to take that and break it down into a wide variety of topics. And I hope that you as practitioners were able to not only listen and find some worth in it, but also find some ways to apply some of the skills and things. Now, there were plenty of pretty scary stories, plenty of article headlines and things that nobody wants to be associated with, I'm sure. But hopefully you'll remember some of those takeaways, some of those reminders that all of our speakers were able to suggest today, and protect yourself, but also protect your firms in terms of your ESI that you have. There's a lot of information out there today. There's a lot of ways that it can be accessed, but just with a little bit of due diligence, I'm sure you're familiar with that phrase, you can make things so much easier for yourself and your firm. So I also just wanted to thank the administration for helping us put this on. So Dean Perdue and her welcoming remarks, as well as her general assistance with this whole process. And Mary Ruth, who works in the dean's office, she helps us coordinate so many things to make this seem quite smoother than it actually is for some of us on the outside. But I also just wanted to throw a specific shout out to some of our IP faculty and other staff. So Professor Chris Katropia, as well as Dean Gibson, the advisors to JOLT, they helped us not only reach out, but to spread the word. So I just want to make sure that they know in this recording that they are also appreciated. And Dean Skalbeck of the library also helped us coordinate a lot of this for today. So I really just wanted to make sure I said thank you to some of the more directed people who normally get a little bit of recognition, but I also wanted to say a special thank you to our staffer, Carl Ham, and he has helped us for several symposiums at this point, always being the person who's making sure that my mic, when I'm talking, is actually working, that the PowerPoints or whatever our documents or materials are showing properly, that this is actually being recorded. All of these things, he has basically helped us set up. So many things for us. Being a tech journal, we would hope that we would be able to do, but thanks to Mr. Ham, thanks to Carl, we are able to get this going. All right, so again, I just wanted to thank you. It's been an honor to have all of you here. I'm going to turn things over now to our editor-in-chief, Nicole Alaband. Thank you.
Hi, everyone. As James said, I'm Nicole. I'm the current editor-in-chief, and I wanted to thank all of you for coming today. I think it's been a really successful day, and we couldn't have done it without you, and of course, our wonderful speakers. Can we just give them all a round of applause? And I also wanted to send a special thank you to all of our JOLT staff who you guys have seen walking around the halls and in and out of this room, helping to make sure everything runs smoothly. So they've been really great today. They've put a lot of work in behind it. And finally, I really want to thank Eli Hill, James Williams, and their associate who couldn't be here today. She's off at a trial competition, but Catherine Schroeder. They have been working on this for close to 9 or 10 months, and having it come together in a day as successful as this is really rewarding. So they've done a fantastic job. So thank you, guys. And I wanted just highlight, we have 2 issues coming out the rest of this school year. We'll have issue 3, which is going to have our student comment that we're publishing that Eli spoke about earlier today. And then issue 4 is our symposium issue, so it'll have a lot of the topics and some articles from some of the speakers that you heard here today to go and kind of add to what you learned here today, hopefully. So that is it. I know it's been a long day, but we have coffee and snacks for all of you before you go home. Please be safe driving. Hopefully it won't rain anymore. But thank you all for coming.